my Lord's kind permission, may I mention item 31, my Lord?
Item
31. This has been listed from day before yesterday, my Lord, in the supplementary list. The matter where the stay was continuing from June regarding teacher's appointment, my Lord.
31.
Item 31.
Yes.
Rupam Rao.
Yes.
We requested on the last date that the matter could be taken up yesterday, but the state did not consent for it. State consented for today. Last evening at 8 o'clock, the state released a notification that we'll declare the results by midnight, 12 o'clock. And midnight, they have declared the provisional list. I have filed an IA, my lord. The IA is already numbered. We have filed it. All that I'm requesting is, my lord, when the matter is taken up, the IA also may be taken along. I will demonstrate, my lord, from my arguments that how the state is playing a hide and seek in this matter from day one.
IA has been numbered.
IA has been numbered, my lord.
What is the number?
IA number is, my lord, 11991 of 25.
But the provisional list has already been
Provisional list is out, my lord,
out.
but still we can be
Monday. Item 31.
Item 31. Only
31.
the IA, I am requesting that the IA may be taken up today, my lord. Along with the
Monday then.
well, there is a one. I am sorry, my lord, I am pushing. But then protection needs to be granted for this reason, my lord. From 30th June, there was a protection.
It's already out. We'll have the IA listed on Monday.
There is one thing in that.
It's already out.
No, my lord, the provisional list of merit is out. But, my lord, what I am requesting is any further step that needs to be taken, my lord, that needs to be stayed for this reason.
Monday.
My lord, kindly consider.
Nothing will change in.
It will, my lord. Can I just?
All right, then wait till your matter.
Very well, my lord. Can the IA be taken along with the matter? All that I'm just requesting that I've already served.
If the IA is already numbered and registered, then you call for it.
Very well.
Yes.
I've already served them a copy, my lord. Grateful, my lord.
It will come only if it is numbered and registered.
I understand. I'll be fair to that.
Yes.
Grateful, my lord. Deeply grateful.
May I please, Your Lordship? I beg to mention item number 18 of the list. Time for the petitioner. I have taken consent from the respondent. Yesterday, I have given a slip, my lord, adjournment slip. Can it be on
Item number
18, my lord?
18.
18, my lord.
Yes, 17 and 18 or only 18?
Only 18, my lord.
As prayed for by Mr.
A. Bhattacharya, my lord.
A. Bhattacharya, learned counsel appearing for the petitioner with consent from the other side. Advance circulation. Relist after?
On the 16th of October, my lord.
On such and such date. Yes.
Make praise your lordship. Lordship, I beg to mention item number 17. We
Yes.
have informed the other side.
And I think you had given an advance.
Yes, we have given
Alright.
the advance.
You are?
S. Goyal on behalf of Mr. P.D. Nair.
As prayed for by M.S.S. Goel, learned counsel appearing on behalf of Mr. P.D. Nair, learned counsel for the petitioner with advance adjournment slip, which is not opposed by the other side. Relist after 2 weeks on a date to be fixed at the
Lordship,
registry.
vacation.
Yes. Next.
Highly hope.
Lordship, item 21 to 24, 4 matters at hearing column. I'm appearing in 2 matter and another my colleague is appearing. In my cases, I have filed affidavit, but these are connected from the same departmental proceeding. So in his cases, he had sent his affidavit for vetting. He intimated me that he had taken consent. So matter be taken up together after puja vacation.
You are appearing for the respondent.
Yes, Lordship.
What about the petitioners? They have given consent.
Yeah, it is intimated to me by Mr. S.S. Roy that he had informed. Yes, he is in 2 cases.
MSB Sharma, and a mention is made by MSB Sharma, learned CGC, for taking up these matters after the vacation, on ensuring vacation. Prayer is not opposed. Relist on such and such date. When?
From my side, I'm ready. Let it be come up in the 3rd week of October.
Did you get that date?
Okay.
Item number 1.
Yes. Agreeable? Agreeable? Agreeable. Give your names, huh? Don't go away without giving names. Agreeable?
Lordship, no.
Huh?
No, because.
Why, Mr. Sharma?
In Union of India, there is such no compromise, etc. outside court, and it's a service matter.
No, what is that service matter is in that list? You make an effort. Have you not seen the list circulated under that mediation drive? The nation mediation drive. What are you saying? Union of India doesn't fall under that?
Lordship, but this is a service matter and service.
Service matter is there. That is why this matter has been listed under this referral column. Please have a look at the notification
And it-
before you make a submission.
Pension, etc. Then all right, but it's a
Miss
governmental.
Counsel, have a look at the notification. Your matter has been selected under this column because of a reason. Know it. After that, you don't. The Union of India is not interested. That is a different thing. But please find it out. Why the matter is listed under this column. Find it out. That notification is there. In earlier matters, I'm always enclosing a copy of that notification. What?
As Lordship is.
Agreeable. You'll get a copy and you see. If it doesn't work out, it will come back. Yes. Any counsels want a copy of that notification, please ask the court master. He'll give you the notification. The cases, the subject matters have been identified, and as per that, these matters are being taken out and put in this list.
This matter becomes infractious, my lord.
Item number?
3, my lord.
Yes.
Already get benefit, my lord.
Your name?
M. Polita.
Mr. M. Kalita, learned counsel appearing for the petitioner, finance, AG, PHE, anyone there? Also heard MS. H. Barwa, learned counsel appearing on behalf of Mr. P.D. Nayak, learned standing counsel, finance, and also PHE. No, stop. Mr. Kalita so-and-so submits that in the meantime, the matter has become infractious and accordingly makes an endorsement to the same effect. In view of the aforesaid endorsement, the writ petition stands dismissed on being infraction. Agreeable?
Yes.
But where is your counterpart, Mr. Baisa? Forest? AG, SGAZ, anyone there? Forest? B. Gogoi? Mr. Baisa, I can take it up in another after 5 matters. You just, yes, anyone there? Forest. B. Gogoi's name is also here for R2. Mr. Baisa, just have a look at it because if they are agreeable, we'll put it. So, yes, next.
Item 5.
Please inform Mr. Chalia. Inform B. Gogoi and and standing counsel Forest and AG to be here. Yes. Agreeable?
Yes.
Agreeable? Agreeable.
Item 6.
Give your names, huh?
Yes.
A copy of the order will be given, then you will know on which date the parties have to appear before the mediation center. Yes.
Item 6. I'm agreeable.
Same. Agreeable? PWD? Okay, agreeable. Item
7.
Give your names, huh, Mr. Decker? 7.
7.
You're appearing in 7? Agreeable? 7 respondent? Agreeable. Agreeable. Yes.
Item 8.
8 is come for the second time, I think. Yes. No, 8.
Not agreeable.
Not agreeable. Give me the file item 8. What about the government? You are agreeable? Heard Mr. AK?
R.A. Pramanik on behalf of
Heard Mr.
R.A. Pramanik.
So and so learned counsel appearing on behalf of Mr. A.K. Barwa for the petitioner. Also heard M.S.H. Barwa, learned counsel appearing on behalf of Mr. P. Nayak, learned standing counsel, GMC. This matter was fixed today for obtaining instruction as whether the parties are agreeable to solve the issue involved in the instant writ petition through a mediator or not. However, today when the matter is called, though MSH Barwa, learned counsel appearing for the respondent, submits that the respondents are agreeable. However, Mr. So-and-so, learned counsel appearing for the petitioner, submits that the petitioner is not agreeable for amicably settling the issue involved in the writ petition through a mediator. That being so, list after 2 weeks. This will come for what? Admission?
Admission. Phone number 480.
You are also agreeable?
No, no, nothing to do in the matter.
Okay. Then just give his appearance.
Publish.
This will come for admission.
Alright.
Admission, Ms. Barwa. Yes, I look like he did a list, relist, and such.
Item number 9.
Agreeable?
Lordship not agreeable.
Not agreeable. Not agreeable, Mr. Ganguly. Both parties not agreeable. All right.
For addition. Okay. Item number 10.
Not agreeable, ne? Too.
Lordship makes into mediation.
Mediation, agreeable?
Agreeable.
Agreeable. Give your names, huh? Did you register one and one?
Okay, admission item number 11.
Well, this matter pertains to payment of leave encashment. And the department APGCL has adopted a part of the-
Viswas, is this matter parted?
Yes,
CCS rules 39D. Whether APDCL has adopted 39.6A2. Is that the, yes?
Also, for time being, my senior is late in other
Who's your senior? Mr. HR Das?
dinner,
Huh?
dinner.
Deenat. What was the issue, Mr. Viswas?
my lord, I am seeking the leave encashment as per Rule 39D of the CCS rule. But they have adopted a rule of 39.6A2. And their submission is that they have adopted a part of the CCS leave rule.
All right, Monday. Oh, yes, you have come.
Lordship has directed us to obtain the
Record, that's what I've seen.
I have received the record.
You have received the records.
Look, I think, Lord, this particular thing, this has a long. Look,
Check.
ultimately,
I think the decision of adopting CCS rules 39.6A2,
Madam,
isn't it?
yes,
Is that the issue?
Yes, my lord.
Lordship wanted.
What
to-
is this CCS rules?
Lordship wanted to know how, and under what circumstances they have taken this, and whether they have the power.
Just
I
Mr.
have-
Biswas or Mr. Nath, one of you just refresh the memory of the court.
Yeah.
It has come up after a long time.
Yes,
I do not remember. Yes.
But the petitioner herein, after filing his resignation as a technical resignation, there is a office memorandum, there is a circular from the government of India. By submitting a technical resignation, he has been appointed in another department in the public sector undertaking. So as per the CCS rule, whoever is appointed after the technical resignation, he is entitled to get the entire leave encashment benefit which has been created in his account.
Okay.
So as per them, my lord, there is another case, gratuity case. They are not paying me gratuity, but that writ petition has been disposed of. The honorable court has held that as per the gratuity act, I am entitled to get the gratuity. So this leave encashment benefits, they have given me 50% of the entire credit that was there in the parent earlier department, APGCL. So I am seeking, my lord, the entire leave encashment benefit should be given to me, because as per Rule 39D, whoever is absorbed in a department after the technical resignation formalities is over, he is entitled to get the entire benefit of the leave encashment benefit. But they are saying that I fall in the Rule 39.612 because they have adopted this rule. So my submission is that, my lord, they cannot adopt a part of the rule just for their own benefit. And if I am the employees are entitled to a particular benefit in terms of the particular rule, that rule has to be invoked. This is the sum and substance of the case. So
Yes,
they,
Mr. Nath?
Well, I have received the minutes of the board meeting where they have deliberated as regard what provision, in fact, what the rule they will follow for giving the benefit of leave encashment benefit to the employee who have resigned. In fact, a list has been given. So many employees have resigned, and after a detailed deliberation, they have decided to adopt Rule 39(6)A Roman 2. That particular rule says that the half of the benefit they will give, and the technical resignation thing, this petitioner's resignation cannot be treated as technical resignation because he has responded to a direct recruitment advertisement, and after that, he was selected and he resigned and he left the organization. The records which will
These minutes are, Mr. Biswas, have you seen the minutes?
no, my lord.
recently I have got.
Why didn't you bring it by way of an affidavit?
I'll
Give him a chance.
yes, no, I can.
Have a look at it.
Yes.
Lordship. I'll find one. Lordship may give me 1 week time. Lordship, next Friday.
Heard Mr. S. Biswas, no? S. Biswas, learned counsel appearing for the petitioner. Also heard Mr. D. Nath, learned senior government counsel appearing for the state. Mr. Nath has submitted that he has received the records as called for earlier by this court. However, no, stop. It appears that the minute by which the respondents have resolved to adopt, to adopt TCS rules 39(6)A2
39(6)A Roman 2.
A12 is available. However, he seeks a short accommodation to place the same by way of an affidavit. Let prayer is allowed, released after a week. After a week and a date on such and such date. You file it along in addition to the aforesaid minutes. He is the state is at liberty to bring any other documents pertaining to the issue in hand by way of the additional affidavit they are proposing, if so advised.
Here,
So whatever from the records you want to rely, just bring
Yes,
it so that Mr. Biswas can have a look at it, and on the next date we can finish the matter.
yes, sir. I'll place it.
22nd, Mr. Nath.
Mal, before that, I'll.
March of
12 from 13.
What are these repetitions?
Regarding selection,
Principle.
principle, what's the principle you wrote?
It is reserved for judgment, my lord.
Huh?
That is reserved for judgment, my lord.
Reserved for judgment?
Lordship, it was reserved for judgment. It came up on the last
Judgment.
occasion, and Lordship was
Yes.
pleased to fix this matter for hearing today. my lord.
Another court.
Lordship,
Yes.
So you want,
we have some urgency in this matter, regarding the fact that our candidature has been.
no, are you ready?
You have to pick one.
My lord, for the time being, my lord, the freezes, my lord. will be-
Okay, then Tuesday. Relist Tuesday, huh?
Can it be on 18th, my lord?
All right, as prayed for, so ends.
Time being item number 4.
Agreeable? Yes, Mr. Bhattacharjee? Are you agreeable?
Can do.
Finance, yes. Agreeable?
For mediation, yes, Lordship.
For mediation, I am not asking you if you're agreeable to grant the relief.
Yes, sir. Yes,
I'm not asking you that, Mr. Chalia.
Very true one.
Yes, agreeable. Huh? Mr. Vaisa, ask your junior to just give the name so that
Yes,
the copies would be given to all the parties.
I'll do that.
To Bhargava Koidib.
Item number 14. May I please?
Yes, area salary.
As well as pension also, Lordship, nothing has been paid.
What's happening, Mr. Barwa?
The petitioner retired from service.
Your Lordship, the latest instruction that we have actually received. It says that the employee petitioner was drawing his last salary from the judicial head of account. As a government leader, and the mentioned head of account is under disposal of the district and sessions judge Dima Saw. And hence his pensionary benefits shall be processed by the concerned department. And view of the above, a demand has been placed to the joint LR and joint secretary to the government of Assam Judicial Department. 5/4/2025, this is very recently, for disbursal of the arrear amount due to him. So some time may be granted, your lordship. In the meantime,
Pension also not released without.
They're having some development. it seems.
Development is.
What does this instruction says, Mr. Bora?
basically his area salary is being drawn from the account of the learned district judge Dima Saw. So since he's the government leader, so now that proposal has been sent to the judicial department, LR. And some time may be granted to get the assent from the LR for disbursal of the area salary to the petition.
Regarding regular pensions also.
Pension,
All right, then how much more time you want?
2 weeks time may be granted.
Huh?
2 weeks time may be
2 weeks.
granted.
As prayed for by Mr. D. Bora. DORH, na?
Yes.
D.
One-
Bora,
1, 2, and
Learned
5.
Counsel appearing for respondent number
1, 2, and 5.
125. Release, give a specific date, huh? Next week then.
Next week, just before the holidays, so 24th or 25th.
On such and such date to enable the respondent to place the up-to-date status report as regards the pending area, salary and pension
Pension.
as
also.
claimed in the instant writ petition.
Can it be on 25th, your lordship? 25th.
Yes. Your presence shall be recorded, but you ensure that the payment is also made. Then we'll record your presence. Yes, record her presence.
Obliging.
Respondents koridiba status too. Yes, you also ensure that the up-to-date status is placed before this court on the next date. So it is Mr. Bora. Okay.
Wait, please.
Yes, Mr. Datta.
On the last date, your lordship,
Yes, Mr. Angpi.
Here it says that as per the hearing report,
This is that case where you were ready to forego the salary.
yes,
Yes, for that period of leave.
for that
yes,
period.
Your Lordship, it
Yes.
is not, here the instruction says that, Your Lordship, it is not possible to do an extraordinary leave, Your Lordship, on a medical ground, Your Lordship, to the petitioners, Smriti Tribeni Bora. However, the state period may.
You
be
have not
treated
filed
as
your
more than-
affidavit in this
Your
matter.
Lordship.
And the prayer otherwise is to quash the impugned order 27/6/23. And to grant extraordinary leave of 120 days and medical leave of 225 days. They are saying they are not, it is not possible.
Well, that is in that, Miller, I made the submission
You
because
file your affidavit then.
Yes, Your Lordship.
Let her,
otherwise, Miller, on records, Miller, they are bound to consider it.
Mr.
there was-
Datta, for
yes.
this court to adjudicate the matter, the return has to be filed. It has not come yet.
Your Lordship.
We had only specifically because on the last date you said the matter can be disposed of
Yes.
if they are agreeable to this proposal of yours. Only for that the matter was posted today. Now they are saying they are not agreeable to the proposal. So the matter now has to be taken up,
No, Miller.
isn't it?
Yes.
The
Miller,
matter has to be heard.
Yes, Miller, my predicament.
This is for
Miller,
admission.
Admission.
Are you filing your affidavit
Yes,
or
Your
not?
Lordship will be filing or.
By when will you file your affidavit? Next week?
Yes,
No,
yes,
no,
sir.
not after 2 weeks.
This.
You
lady-
file it within a week.
Miller, the lady is retiring
Ye-
next month.
So you file it within a week. Heard Mr. S. Datta, Learned Senior Counsel, assisted by Mr. P. Sen Gupta.
Yes, Lordship.
Learned Counsel appearing for the petitioner. Also heard Ms. H. Tarang P. Learned Standing Counsel, Secondary Education Department. Ms. So-and-so submits that as per the instructions received, the respondent department is not agreeable to the proposal proposed by the Learned Senior Counsel to the effect that the petitioner is willing to forego the salary for the period of leave in question. And she further seeks a short accommodation to file to bring the return on record. Prayer is allowed, released on such and such date, that date deduct. It is needless to be clarified that if the return is not filed by the next date of listing, the matter shall be proceeded in accordance with law.
Obliged.
There is item number 28.
Please, Your Lordship. Till now, the affidavit has not been filed, Your Lordship. Last order, 3/9/2025.
Yes, affidavit
Yeah, instruction.
you have received.
Yes, Your Lordship.
Miss MSD Mushahari, Leonard Standing Council, Secondary Education Department submits that her office has received the
Last occasion.
your last date. You said a counter evidence already been drafted and sent for vetting, and now you're saying you have received instructions. What is this, Miss Mushahari?
Lordship, the affidavit, because I've seen in my instructions, it was for, because Nazrul, there is another.
No, you
petition.
see the judicial
Yes, yes,
order.
I have seen, I remember.
So where is that affidavit which was sent for vetting, which was drafted and sent for vetting? 1 week was given because of that. Why is it not filed?
Lordship, I'll have to ask the council, Your Lordship, who had prepared the.
What is
affidavit.
this? If there is no
Because-
coordination amongst the councils, amongst the panel lawyers, the government standing councils.
Because there is another case of Nazrul Islam, Your Lordship.
Ms. Moshari, this court is not concerned about the other cases. In this particular case,
Yes, Your
you
Lordship,
have
let
made
me-
a specific submission before the court that you have received instructions.
Yes, yes,
Whereas the last judicial order indicates
yes,
that the
they are-
affidavit has already been sent for vetting.
Yes, Your Lordship.
So please be careful when you make a submission before this court. These are not some casual proceedings going on. Yes, what do you want now? How much time?
Lordship, 2 weeks time, Your Lordship.
No, not 2 weeks.
Then 1 week, Your Lordship,
Uh,
let me inquire with the council.
Heard, Mr.
As Gautam, Your Lordship.
As Gautam, Learned Counsel appearing for the petitioner. MSD Mushahari, Learned Standing Counsel, Education Department submits that she has received, her office has received instructions and accordingly shall file the affidavit within a short duration of time. However, upon perusing the last judicial order of this court dated 3/9/2025, it has come to the notice of the court that on the last occasion, Ms. MSP Das, Learned Standing Counsel, Secondary Education Department, has submitted that the counter affidavit has already been drafted and sent for vetting and prayed 1 week time for filing the same. It appears that based on the aforesaid submission, the matter was listed today. It is unfortunate that there is no coordination between the government councils and contrary submissions are being made before this court without verifying the same. Be it as it may, relist on such and such date, it is needless to be clarified that if the affidavit is not filed by the next date of listing, the matter shall be proceeded in accordance with law. Give a date.
Right here.
In October. Item 29.
Worship, the instructions I have received, the matter came upon 8th, and the worship directed to be listed today. In regards to the provisional pension, your lordship, it says that it will be sanctioned by next week. The letter itself. That
You are going to
is
grant the sanction?
the provisional pension.
Provisional pension. Yes, Mr. Gogoi?
My lords, this is my interim prayer. My lord, they have drawn up the disciplinary proceedings after my retirement and without the sanction of the government. Without going into that can be settled later on.
1 second. Yes.
That can be settled later on, my lord. Lordship will post it by next week, so we can ensure that he can ensure that
Next week, because here the consent of the.
Sorry, I couldn't follow what you were saying because of the
I retired in 2017.
huh.
Initially they gave a before my retirement there was a proceeding which culminated the inquiry and reinstatement. It was never disputed. By after 2017 2021, my lord, after almost 4 years, they initiated this inquiry against me, my lord, without the sanction of the governor. And by quoting Rule 21, my lord, they have withheld my pension as well as
Now
provision.
your this instruction says what?
The instruction says that with regards to the disciplinary proceeding, ex post facto approval of the governor as per Rule 21 of the pension rules is required. So we have actually the department that the office of the DC Nagaon has actually written to the governor seeking.
So that is awaiting.
That is awaiting. with regards to the other claim regarding pension, he's not getting any provisional pension. I agree that there is a mistake on my part, on our part.
So what do you want to do about that?
By next week, will be sanctioning. In fact, the letter reflects that in the.
The provisional pension.
Yes.
So heard Mr. D. Gogoi, learned counsel appearing for the petitioner, also heard Mr. D. Bora, learned additional learned government counsel for the state, huh? Stop. Mr. Bora places the instruction dated 9/9/2025 received from the office of the District Commissioner Nagaon, which indicates that as per the record available, the petitioner's provisional pension was held up. However, other pensionary benefits such as DCRG, GIS, GPF, leave encashment had already been sanctioned. It further appears that in the year 2021, due to the anomalies found as per the report submitted by the additional district commissioner, a fresh departmental proceeding was reordered by the Deputy Commissioner Nagaon Disciplinary Authority by order dated 9/11/2021. Stop. It further appears that the post facto approval for the same was sought from the Governor of Assam by letter dated 16/7/2024, but no communication has been received in this regard till date. It further appears that the provisional pension of the petitioner is stated to be sanctioned within a week. That being so, relist this give a date after a week or after 2 weeks. Relist on such and such date to enable the State Council to present the up-to-date status of the provisional pension of the petitioner as well as the
Governor's asset.
as well as the sanction of the governor.
All right.
Item number 30.
Yes, Mr. Khandigar.
Lordship, we have sent the affidavit for waiting and there was a correction to be made in the affidavit, Your Lordship.
Sorry, the vetting is come back.
Come back, but there is a slight corrections in the affidavit, Your Lordship.
All right. MS H. Tarangpi, Leonard Standing Council, Secondary Education Department submits that though the affidavit which has been sent for vetting has come back, however, due to some clerical correction, the same could not be filed today. In view of the above submission, she accordingly seeks a short accommodation to bring the affidavit on record. Prayer is allowed. Prayer is not opposed. Huh? Relist on such and such date. Yes.
Plus,
When?
Lordship, after 2 weeks or 1 week.
After 2 weeks on a date to be fixed by the registry.
Before vacation, any date, madam.
Yes. All right. Next.
On 24th.
Yes.
Madam, this come up day before yesterday. Since 30th June, my lord, there was a stay ongoing in my favor. In this application, I have also produced from record that how the council had acted against the advice of the client, but be that as it may, my lord, I must also.
1 second.
That's it.
Acha, this is that matter.
That matter.
You are Mr. Karla.
I am Mr. Kalga, my lord. The instruction to the council on that day was to simply take a passover, my lord. I put that on record with screenshots. It was not for an adjournment in any manner.
But that was not done before.
That was
this
not
court.
done, my lord. But what I'm trying to say is, therefore, I'm just
It
trying
was
to.
made a specific, a government was made, a specific statement was made before this court that you are unable to attend the proceedings of the court because of a health issue.
Yes, my lord, I was unwell. I was going through some medical tests.
So
Therefore,
there
I
was no
requesting-
request for passover for
I
the
was-
time being.
That's what I'm
Yes.
trying. I'm trying to.
Anyway, what
Yes.
has happened, Mr. Karla. Now,
Yes,
why
my
is
lord, I
this
was-
matter
it is my
listed today?
responsibility to clean the air.
That's all right. Yes.
So therefore, my lord, what has happened is, on that day, for whatever reason, the interim order was vacated, my lord. And I can show from the record that it was the government which sought adjournment at least 3 times.
Mr.
After-
Kagla, we are not on the adjournments. Why
As
is
I
this
said,
matter
it
come
is-
up today? Is this matter for admission
No,
today?
this matters for final arguments, my lord.
For
Final arguments, my lord. I am ready to argue.
this matter is fixed for hearing.
My matter is fixed for hearing, my lord.
No,
On the
it's at
last-
the admission column. That matter has not been admitted.
My lords, on the last date,
Is there an order for hearing?
on the last date, it was fixed for final arguments, my lord. Kindly see the order prior to the last one.
That was the understanding, Lordship, for final discussion.
For final disposal.
We are ready for any
What-
time, Lord.
What has happened is this.
All right, then we proceed with the impression that we are finally hearing the matter then.
Very well, my lord. But there is one development which I wanted to just bring to my lord's kind attention. That day we requested for 10th, my lord. Government did not agree, my lord. They agreed for today. Yesterday they issue a notice, my lord. Surprisingly, I am reading, my lord. Kindly have this one word. The notice on the top right is dated 10th September 2025. That is yesterday, my lord. The first paragraph is as under: the first provisional merit list for the post of assistant teachers of lower primary school and assistant teachers, which I am claiming a right upon, under the Directorate of Elementary Education, will be published in the official website of so and so from midnight of 10/9/2025. So, my lord,
Earlier, the stay was for not publishing the provisional list.
yes,
That was
exactly.
the effect of this.
That was the effect, my lord. But knowing that this honorable court is seized with the matter, knowing that the matter is listed today,
Can we come back to the order of? Please place the order of 39, 36, 2025.
30th June, my lord.
Yes, let us see that order one.
Indeed, my lord.
That was the order on which the notice was issued, right?
Notice was issued. Government
And
was
you had challenged, what is this notification
Yes.
17,
Can I
6,
just explain,
25?
Can I just give a brief background?
Yes, please.
Look, we are candidates who wanted to be government teachers in primary school, my lord. There was some confusion with respect to our eligibility because we did a Government of India course from NIOS.
You are what students you said?
We are candidates
For computer?
for assistant teachers in primary schools.
Assistant.
Assistant teachers in primary schools, Government of Assam.
Yes.
We have done our diploma from one institute, NIOS, under the Government of India scheme. There was some modification brought upon in RTE Act, Right to Education Act in 2015, which said that whichever teacher is in service in private school, etc., needs to take the minimum eligibility qualification as per the NCT, National Council of Teachers Education. That is the council regulating all the mandate for we as teachers, what should we get? So an amendment was brought in 2015 by the Government of India, saying that whichever teacher like us are in service in private schools need to take the minimum qualification, which is a diploma in elementary education. In short, DLED, DELED, diploma in elementary education, by April 2019. This was an amendment that was brought. Therefore, the Government of India in 2017 brought about a scheme saying that we, the people who are already in service, can take this online diploma from an institute recognized by NCT called NIOS, National Institute of Open School. So we are all those people. We took our course from there.
From an open university.
From an open university under the Government of India scheme, one-time scheme by the MHRD, Government of India, NCT, all recognized together. All those communications I will take.
And this is as per that OM.
This is as per that OM, Lord. Introduced by MHRD.
Which page is that OM?
Lord, I'll just show you.
Just give me the page.
Yes.
We'll go.
Yes, I will just
later
take you
into the depth of the matter,
yes,
but I'll just indicate me the page number.
Yes, my lord will just have there are two things. One is a writ petition, and the other is a convenience compilation that we had filed before the Honorable Supreme Court, because this matter
Which
comes.
is that?
So one is a writ petition, and the other.
Which is that compilation?
It's
this fat volume.
Yes, the fat volume. With the heading is second volume convenience compilation of pertinent acts.
Not this one. This is the writ petition.
Yes. Other than that, there will be a convenience compilation, my lord. That we have given.
Compilation as an.
Can you just show this to them? It says in the Honorable Supreme.
You have a copy?
Yes, sir. We had given it on the first day, my lord. It is like this. Yeah, it says in the Honorable Supreme Court of India. It is like this.
It's okay. It's okay. You stay there.
No,
Give the file to them. Give the file. Mr. Chesty. Again, just take out whatever you want to. No, it may be there.
This is
Just
like
take it
this.
out from there.
It is like. Extra pay, give it to you.
Otherwise, give a copy if it is
Yes,
not
sir.
there.
You can use.
If the earlier copy is
copy
there,
will be
you can
marked.
give it. It's there. Ekon Graduk.
I take my lord to each and every page.
So I take it that now I don't have to hold that volume and we can
Yes,
deal
sir,
with
Malord,
this volume, huh?
this is-
Mr. Sakya?
Yes, I agree with
Apart from this, my lord, there's only two orders of the Honorable Supreme Court which are there.
Okay.
Now, just let me, if my lord would permit, just the narration of fact for giving a brief
Yes.
background of the matter. So therefore, this one-time courts brought in for the entire country, my lord. There were teachers from across all states who were working as on 10th August 2017, 8 years back. One-time opportunity brought in by the government of India because of an amendment made to the RTE Act. That time, my lord, the responsibility, or I would say the ignition, to identify the in-service teachers, as in who were working, was cast upon each state, all the states across the country. The NCT, the MHRD, through these notifications and through these communications, which I will show, told each state, the education secretary, etc., that please identify the in-service teachers from your state. Give us the names of all these in-service teachers. And after that, once you confirm the name that yes, so-and-so is in service, then we will let them do this course. This was the arrangement made that time. So everything was state-based. State would give the name, state would have coordinators, and then a person would be eligible to take the course. 2019, we completed the course. Thereafter, there were two recruitments in 2019, 21, etc., where we, because we completed the course in 18 months. 18 months was through the online portal and 6 months internship because we were already working. The NCT said that the course should be done in 24 months. That is the normal rule.
And you did it in 12 months.
18 months.
18
months, because the time duration I will show from the documents was such that those six.
But are those things an issue?
No, I will. But it is important for my lord to understand the background, that because it goes to the Supreme Court, then it comes back. So why did it go to the Supreme Court is important.
No, but otherwise, I'm hearing you, so you can argue for days, no problem. But just indicate
Please.
what is the issue involved in this
The
writ
issue is this.
petition. It would be easier for the court to appreciate your arguments then.
Yes.
What is the issue?
The issue is
What is
this.
your grievance and why have you filed this writ
Yes,
petition?
the issue is this. There was some confusion with respect to whether we will be eligible or at par with the normal degree holders or not.
Okay.
Every state was misreading a Supreme Court judgment of Uttarakhand, saying that we, 18 months holders, will not be equivalent to 24 months.
Okay.
Supreme Court then in December 24 clarified that we are equivalent to the 24-month holders. Supreme Court
So
clarified.
in that OM, the time was given, 24 months.
Yes, 18
And
and
since you completed it before the 24 months,
Yes.
therefore that controversy came
Controversy
whether
came.
you are eligible or not.
Yes, controversy
Since
came
you
in for one
completed,
state.
since you completed
Yes, exactly.
within
Exactly.
18 months.
Exactly.
Yes.
So in controversy came for one state.
This controversy was put to rest.
Was put to rest, saying that we are equivalent. Prior to the controversy,
This was by Apex Court.
Apex Court in 23. The controversy started in 23. So we completed the course in 19. From 19 to 23, the state has recruited people like us. 23, the controversy came. From 23 to 24, December 24, the controversy continued because there were some reviews, clarifications pending in Supreme. December 24, the Supreme Court clarified that we are equivalent to the 24-month holder, but there were two conditions. The conditions were, in the order which I will show, that we should have completed a diploma within that April 2019, plus we should have been in service as on 10th August 2017. These were the two things Supreme Court says that yes, if a person has completed the diploma within the 20 period and is in service as on 10th August 17, they are at par. Then Supreme Court implements its own clarification for 3 states. One being Uttarakhand, I will show those orders also, West Bengal, and BTR. All these 3 cases I had the opportunity to assist the Honorable Supreme Court. Implement saying that yes, please, they are eligible, give them appointment. The advertisement, which is the subject advertisement, came in December 23, 26 December 23. The advertisement was ongoing. The present advertisement, which had 5,500 posts. There were writ petitions filed before this court that because Supreme Court has given a clarification, please implement the same for us.
In the advertisement, it says 24 months.
In the advertisement, it originally said nothing, but later on there was a circular saying that we are not eligible, relying upon the earlier Supreme Court judgment. So therefore, that circular was challenged in the writ petition saying that no, we have to be considered equal only and you can't treat us not at par with the regular ones. Supreme Court clarified, writ petition was modified. I had the opportunity to argue one of those writ petitions. Writ petition allowed in terms of Supreme Court order, we are at par. Then the process for these 5,500 vacancy proceeds ahead. Now this impugned circular comes in, my lord, where 9 documents have been asked to prove my in-service capacity. 9 documents which were not required in 2017, where I was not the one to show that I am in service, the state was the one. And 9 of these documents have been shown, say that if you give these 9 documents, only then will we consider you in service. And therefore, I filed this writ petition that, boss, first the responsibility, the first moot question for my lord's kind consideration on 30th June when I argued was that whether to be in service is my responsibility or the state's responsibility, as per the documents, as per 2017.
Is this matter a part-heard matter?
No, no, it is not really a
Then
part.
you said that when you argued on such and such date.
No,
So,
on the day of
so,
notice.
so now we are
On the day of
hearing.
notice.
So let us concentrate
Yes, yes.
from today.
Yes, yes.
Yes.
The point that I am trying to make is this.
Yes.
As on the notification that came in, my lord, which said that all you in-service people give these 8 documents. We are those NIOS.
So basically in this read, you are challenging the circular,
saying
whereby you are asked to submit 9
documents
documents
to prove my in-service
your
capacity.
in-service
That's the-
capacity.
That's the short form.
And earlier, it appears that it was the state
Yes.
who had to do it.
Yes, it was the state always which had to do it. State in their counter to the present writ petition saying
And which page is that Supreme Court decision whereby this 18 months have been allowed?
yes, my lord will
Let's
kindly
go to
have
that, please.
the fat volume. Sorry, now the fat volume.
Yes,
Please.
You don't have to be sorry. Yes.
Please see 567.
Page
567.
567.
Yes. Annex 4. In this Supreme Court decision, state of Assam was a party.
Yes.
Or-
Review petition.
These are review petitions and miscellaneous applications, my lord.
Yes.
The relevant, my lord, would see at 568.
Yes.
Kindly have para 2. We have already clarified in the judgment, may I read?
Yes, yes.
We have already clarified in the judgment under review that the one-time scheme was provided solely to safeguard the interest of those teachers who were employed as on 10 August 2017. We are therefore not inclined to entertain the present review petitions as well as miscellaneous applications. However, third is important. To avoid any confusion, we again clarify that the 18 months diploma obtained by such persons who were in employment as on 10th August 2017 and who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in the other institutions or for promotional avenues.
So these documents which they are now seeking
Hello.
are in connection to show that you are in employment as on 10/8/2017.
Indeed, my lord.
That
Indeed,
is
indeed, my lord.
that those documents.
Indeed.
Then what is wrong in those documents?
The wrong-
That
The
circular.
wrongness is this, my lord. As I said, 2 questions. First moot question is whether I was in service on 10th August 2017 or not was the duty cast upon state at that time. So it was the state to verify. If the state wouldn't have...
But suppose the state is not now the state wants you to show that. What is
Yes.
the wrong? How are you prejudiced?
Yes, I am answering that, Lord. That is number 1. Number 2, my lord, the documents at that time that was asked to show whether I was in service or not was an experience letter from the principal. That was the only document asked for.
When earlier.
In 10th August 2017, as per the Government of India circular and the approval recognition order that came in. Only one thing.
Now they are
I am producing.
now they want 9.
They want 9. I am ready to produce that one document.
And what are these 9 documents?
These 9 documents, my lord, directly please come to the impugned notification at page 54
Of the compilation or
of the same writ, my lord.
page?
54. The problem is this, my lord, that most of these schools have shut. I'm sorry.
Yes.
Page 54, my lord, would see the notification which is impugned herein. It gives the heading of in view of the judgment of Honorable Supreme Court dated so and so. This was the order we were just reading, my lord. So they derive that from this Supreme Court order we are bringing in the following documents. So and so against advertisement are hereby asked to attend the second phase of physical document verification in due course of time when notified with.
So you've been asked to attend the second phase of physical document verification.
Indeed, my lord.
With the following documents.
Yes.
Yes, which are these
The
documents now?
first is, my lord, appointment letter and accepted joining report of the applicant, which I'm not okay with, my lord, because I was never asked at that time.
But you don't have an appointment letter?
My lord, we only have an experience certificate, most of us. All of these are private school, my lords, where what was required at that
You
time.
don't have an appointment letter?
Some of us don't, my lord. Some of us only have an experience certificate because.
How many?
Look, what happens is, most of these schools, because we were not in government schools, my lord.
How
We were
can
in
that
private.
be?
But government schools, if we.
See, even if something has happened, you want the court to now perpetuate an illegality?
No, my lord, that is.
How can you, anyway, we will come to all
I'm
that
on a
later.
different footing altogether.
All right, Mr. Kala, let's go on.
I am on a constitutional bench judgment which says that the rules of the game cannot be changed.
So now I'm not on the rules of the game because now it seems that you have there is a judgment of the apex court which says that the 18 months, as far as the 18 months is concerned,
Yes.
to avoid any confusion, we again clarify that the 18 months diploma obtained by such persons who were in employment as on 10/8/2017
Yes.
and who have completed the diploma course of 18 months
Yes.
would be treated as valid diploma holders.
Yes.
Now the question is whether you have you were in employment as on 10/8/2017, number one.
Yes.
Number two, whether you have completed the diploma course in 18 months.
Yes.
These are the two questions.
These are the two
before
questions.
you are taken as
A teacher.
as a valid diploma holder, as a
Indeed.
valid diploma
Indeed.
holder, right? Unless you have 24.
Indeed.
So now for that, they have come out with a circular
Yes.
that these are the documents we need in
Yes.
terms of this order.
Yes.
So what is wrong? That is, you have to satisfy.
Yes.
I have not made up my mind.
No,
I am yet to hear the other side. But
every endeavor
you
to
see,
satisfy.
these are the queries that are coming, and I'm only sharing it with you so that you
No, I'll
can
address-
accordingly
I'll address all of them, my lord.
correct.
Rest
Only
assured.
for that purpose.
I am rest assured.
Yes.
So the first thing that they ask me is appointment letter and accepted joining report of the applicant. I have a problem with this. Second thing they ask me is minutes of school management committee of the school in respect of the appointment of the applicant concerned. My lord would make a mention here. Most of us were in rural schools. We are still paid salary in cash of say 3,000, 2,000 a month. There is absolutely no school managing committee in such schools. Then please see 3. Photocopy of the attendance register of the school during the service period of the applicant duly countersigned by the head of the institutions. Fourth is very important, my lord. Certificate issued by school authority specifying the service of applicant in this school as on 10th August 17, which all of us have. This is what was required at that time. Then please see salary statement stating that the pay band, basic pay, DA and other allowances of the applicant of the entire.
This also you have a problem.
Well, I am given, yes, I have a problem because I am given salary in cash. There is absolutely no basic pay DA that I get. And if they would have asked me for these things on 10th August 17, I understand, my lord, I have a right to satisfy them. 8 years later, my lord, someone turning back and saying that because you need to prove when the Supreme Court order later, we just read one order, my lord. There are 2 more judgments where the Supreme Court is clarifying its own judgment further. I'll show that for Uttarakhand and West Bengal. There is no mention of these documents. Nothing. Zero. I will show that. It is all part of my writ petition. So therefore, the second last document, salary statements, I am getting my salary even today in cash. 2,000, 3,000 rupees a month I get. There is absolutely no concept of pay band, basic pay.
Where are the amendments in relation to this?
Yes, I will show that, my lord. I will show it from the writ petitions. Then please see the last one, which is most important. UDICE records as a proof that the applicant was in service as on 10th August 17, my lord. UDICE, my lord, would note is the full form of UDICE is Unified District Information System for Education.
Unified
District Information System for Education.
System
For education.
for education.
To put it in plain words, my lord, this is like an Aadhaar card for a school. That every school will have a unique UDICE code. Even till today, my lord, forget 2017, even till 2025, the government of Assam has not made it mandatory. Even till 25. So therefore, asking for a UDICE code of 2017 of a school, my lord, which is not even made mandatory in the state till today. where is the source of power for any of these documents? And I go back to my first argument, my lord. The source of power needs to be seen because ultimately it's a recruitment. They are bound by NCT regulations. NCT has not asked me for any of these documents. Government is simply bound by the NCT regulation. I will show NCT has to prescribe the minimum qualifications.
Where is that 24 months requirement?
In the NCT, my lord. The NCT prescribed that any assistant teacher for primary school will have to have a 24-month diploma. That is, they say 2 academic year. In fact,
You don't have 24 months, you have 18 months.
well, yes, that is the confusion that was created.
And that was clarified by
yes,
the
NCT says 2 academic years, and Supreme Court clarifies that yes, this will be considered as 2 academic year. Why was it 18 months? Is also the government of India specifying, and this is not just me, my lord.
Various.
14 lakhs of people like me across the country have done it. 14 lakhs.
This 24 months figures which page in
NCT, my lord.
NCT, na?
Yes, it says 2 academics here. I will just show that from the compilation.
Just give me the pages.
Yes, I will just take my lord through all those pages.
No, you just give me the page. I just want to put in the note.
Yes.
24 months.
24 months, my lord, would get in the compilation.
Page.
It starts at page 40. Second volume.
All right. Yes.
And then second and third, there is no problem, my lord. Second, serial number 2 is not a problem. It is the admission record of NIOS. And serial number 3 is the diploma, my lord. So therefore, this I challenge, saying that 1, is it my responsibility to over and above what happened in 2017 to show that am I in service? Is that my responsibility? The only
In
thing,
which schools were you that time?
rural schools, my lord, we have experience letters of each.
And these are all under the state government.
No, my lord, these are all private schools.
Private schools.
Private schools. Kindly see, I will just show one experience letter. I have put it in the writ
So
petition.
you want the state to go to the private schools and get these information?
Indeed, my lord. In fact, it is not really.
In short, this is what you are saying.
I will just modify my argument, my lord. I want the state should check the data they sent in 2017 because NIOS state had a MOU. The MOU is on record. The MOU said, state, please give me the name of all in-service teachers. If my name would not have
What
been
do in-service teacher means?
in-service, my lord, what happened is
In private schools as well.
In private schools only, my lord. If I was in government, then I don't need to really come here for a better opportunity. One of the example, if my lord would see at page 68 of the writ petition.
But in-service,
in-service meant, my lord, what happened is.
no, because this court is trying to understand
Yes,
that
yes.
how can these how can you expect the state to go on inquiring from all private schools and find out who are the teachers?
Yes, the answer to that.
If any particular teacher is interested,
Yes.
he has to produce those documents and show that he is in service.
Yes.
The
Yeah.
schools are not under the state government.
Yes, the answer to that is this, my lord. The exercise that was put in force in 2017 from Ministry of Human Resource and Development to the Education Secretary of the state and through this NCT was that the state will go to each and every district education officer, and this district education officer of the state will ask each school.
Where are those?
Yes, I will show those documents.
Let's go directly
Yes,
there.
yes, my lord. Very well. Kindly have the second volume, my lord, of the convenience compilation, which I was referring to, my lord. It has directly come to page 47. One order of BPR of Supreme, and what BPR order of Supreme. Yes, yes.
Page?
47.
Yes.
My lord would have, it's dated 3rd August 2007.
Yes, I have it.
And it is by MHRD to all the secretaries, my lord. It's addressed to the secretaries. Secretaries including the Secretary of State of Assam. Please see, my lord, the opening paragraph to understand that why was this done, my lord. This is regarding training of untrained in-service elementary teachers to the government-aided, unaided private schools. It is apprised that the amendment to the section 23(2) of the RT Act to extend the period of such training to so-and-so has been passed by the Parliament. Further, it is reiterated that this will be the last chance to acquire the requisite minimum professional qualifications, any teacher in the aforementioned schools who does not have the minimum qualification mandated under the RTE Act 2009 would not be allowed to continue in service beyond 1st April 2019, and procedure for dismissal shall be initiated against such teachers. Then my lord would kindly mark the next heading, action to be taken by states/UTs. Kindly see Roman 1, my lord. States and UTs will be responsible for ensuring that all in-service untrained teachers, government schools and private schools in the state and UTs acquire the minimum qualification required under the so-and-so within the proposed extended period. Please see 2, my lord. At the state and UT level, very, very important, a committee under the chairpersonship of the Secretary, Elementary Education, needs to be set up to monitor the progress and completion of training of all in-service untrained teachers at elementary level within the stipulated time period as per the amendment of the Act so-and-so. Then please see 3, my lord. States and UTs will also appoint a state coordinator for the state UT to facilitate conduct of the program and for continuous engagement with the MHRD and NIOS. Then, my lord, may kindly come to the next page. Please skip 4, 5 and 6. Kindly come to 7. Roman 7.
Yes.
All states should prepare a database of such teachers in their state. Please mark this. 7. All states should prepare a database of such teachers in their state. Please
Yes.
see 8. For creation of database of untrained elementary teacher of DLED, there will be an online portal of
You have a better copy of this? It's very,
I'm sorry.
it's not very legible, the copy that is there in my compilation.
There is a note also that would have come as a up. Is this better?
Yes.
I am reading page 48.
Is
Roman-
this also a compilation, the same compilation?
Same thing, another copy.
Should I then keep this?
Yes, but keep that. All these are inconvenience here. There's one note with the guide with the tab. Okay, give it to the other.
Yes.
Yes, my lord, I was reading page 48.
Yes.
This is the initiation of the process, my lord, and Roman 7 was important.
Yes.
All states should prepare a database of such teachers, which is us, my lord, in their state, for creation of database, again, my lord, of untrained elementary teacher of DLED.
Yes.
There'll be an online portal of NIOS which will have the following options. Well, this is very, very important. Login/registration by the state coordinator. Login registration by the individual principal of the school. Lord may note there is no option of logging in by me as a candidate. I cannot log in.
This is for creation of database.
Database of us who are in service, my lord.
Database of untrained
In service.
elementary teacher.
Which is us.
There will be an online portal of NIOS which will have the following
option. So the options to create this database at that time in 2017 was with 2 people. One, the state coordinator. Second, the principal of the school.
But the information that they're asking is not about the database or anything. They're individual to these people. They are bound to have their own appointment letters, their own salaries. These are individual concern. If somebody is serving as a teacher in any school, be it rural, urban, be it any private school, there must be an appointment order. There has to be.
Well,
otherwise, how the teacher has been appointed? It could be an illegal appointment.
Yes. The answer to that is this, my lord.
And how can the salary not be given? How can it be given in cash?
My lord.
Generally, I don't know. These are things that is troubling the court.
Yes.
You have to clear all
Yes,
this
this
because the impression that is coming is that perhaps that is why I'm sharing.
Yeah.
That database is okay,
Yes.
but they are not asking anything for you to log into these databases and take out something and produce it. Those 9 documents doesn't talk about these.
The answer is this, my lord. But kindly see it as an example.
You are trying to say it indirectly by saying that, well, the state ought to have known it. So
This-
therefore, the state should not have asked for these documents.
That is my first argument.
This is
That
kind
the
of
first
what you're
argument.
trying to
That
say.
is the first argument. The second argument is, if all these documents were told to me in 2017, my lord, because most of these schools after COVID has closed. Most of these schools don't exist today. If that time these documents were asked from me, my lord, I would
No,
have.
but the appointment letter would have been with you.
Yes, the answer to
If
that
you
is
had
yes.
an appointment, if you are receiving salary, it would be you individual, it would be in your bank statement. You don't have to go after a school for collecting these documents.
The answer is this, my lord. Most of these schools are in rural parts of the state, my lord. I till today, forget 2017, till today get salary in cash, 3,000 rupees.
Is that
a month.
correct, Mr. Soikia? That position only.
Whether
I'll
it is
hear you in
internet,
detail.
Whether it is cash or or to bank transfer does not make any difference. Salary is salary.
But
No, there's a pay slip.
before asking me, my lord, and this is the proposition of law that I'm trying to face, these 9 documents which they have asked from me, my lord, the first thing they should have shown, my lord, in the counter is that these 9 documents are mandatory for a private school. That is the first question. Without the state making it mandatory for government schools, I understand.
You are saying that without any application of mine, they have
arbitrary, my lord.
they have just
It is arbitrary.
imposed these conditions, these documents, which are absolutely impossible for you to
Indeed.
produce. This is
Indeed.
what you're trying to
Indeed.
say.
Indeed.
In a way, they are trying to
Eliminate us.
deprive you.
Eliminate us, and that has been the trend from day one, which I'll just show. So therefore, what I'm trying to only thing that is missing is a selfie in a school, my lord. That is the only thing missing.
What?
A selfie in the school with me teaching, my lord, is the only thing they could have added to this. But please consider these daily workers, my lord, with all my humility, my lord. But these daily workers, the masons, we have them for one day, my lord. If we have to ask for their experience certificate, my lord, that they were getting 500 rupees a day or 400 rupees a day, and then we are asking for their experience certificate, the first question that I need to ask myself is,
These are assistant teachers we are
no,
talking
they're
about.
assistant teachers today.
The
Today we are-
teachers.
yes.
The teachers. They're
They-
not some
But-
daily laborers, Mr. Counsel.
But they may not be daily laborers, but the point that I'm trying to, the reference that I'm trying to draw is, they are unregulated. That's the most important part. Let the government show one notification by which they say that every government school should have a school management committee, every private school should have a school management committee.
These documents indicate that now the effort is to ensure that they regulate all this. Perhaps they are now trying to regulate.
In my humble submission, I will try and show that still they are not doing it because they're asking me. If they go to the private school and say that, boss, you should only give salary in cash, please have the pay slip.
What do you mean by boss?
The government goes, my lord.
Please don't use these kind of words in the court.
I'm referring to the government, my lord. The government goes.
Don't use these words in a
Very well.
constitutional court, kindly.
The government goes and tells all these private school principals, my lord, that I want to regulate all these 7 things, my lord, and says that now onwards, any teacher you keep, you should give an appointment letter. Any teacher you keep, you should have a school management committee. Any teacher you keep, you should give a pay scale. At least one document they should show they've done it till today. If that is not mandated,
All right, noted.
yeah, then please come. I was at 48, Roman 9, my lord. 9 is very, very important.
Yes.
State coordinator, please mark this, will enter the entire database of untrained in-service teachers in private and government schools on the portal, especially prepared by NIOS for this purpose. The state coordinator has to enter. This portal will also be utilized to monitor the progress of training in each state /UT. Now, 10 and 11 is most important, my lord. For teachers in private schools, a certificate from the principal would be taken to ensure that the teacher is serving in the school. These certificates will be collected by the state obliquity. Please pause there for a minute. In 2017, what is laid down, my lord? This is the first order of recognition, my lord, where the MHRD introduces this entire concept. I will show that how these things are being kept as it is.
Is this 3rd August 2017
17.
document communicated to you?
Me, to the secretary of the
To
government.
the secretary?
Of the government, if my lord would see on 47, it says, dear secretaries.
Yes, that's I've seen. And to principal secretary and secretary education, all
Yes,
states and
it is
UTs.
given to all the secretaries, including the state of Assam.
And the subject matter here is regarding training of untrained in-service elementary teachers.
Yes.
That is the
Indeed.
subject matter.
Indeed, ma'am. This is the first time when the communication started. I'm showing these documents. All of these have been referred to, interpreted by a subsequent Supreme Court judgment, which I will show for Uttarakhand and West Bengal. And therefore, change of rules of the game comes into picture, a 5-judge bench of the Honorable Supreme Court, which says that Yes.
You've been referring to the change of the rules, but what rules have been changed?
the rules have been changed is this, that
Because this is not the terms of the advertisement. This is not the term of the recruitment also. This is some internal communication of the secretary, of the additional secretary
Yes.
to the secretaries of the state.
Yes,
This is not to you.
the answer to that
There is
is
no
this.
rules here.
Yes, the answer to that is this. The advertisement says that I have to be eligible as per NCT.
So we'll go there, and
I
as
will-
per
I will-
NCT, it is 24 months.
As per NCT, it's 2 academic years.
24 months.
2
No.
academic years.
So we'll go there.
Yes.
We'll go there. If there is any change in that, we will see.
Yes, yes.
One
I will-
second. I'm just noting down this.
Yes, please.
1 second, please. In service elementary teachers. What is this RTE Act?
The Right to Education Act. Right to Education Act.
এইখানে affiliate হবো না? So this particular document at page 47 has reference to section 23(2).
Indeed, my lord.
What is section 23(2)?
This 23(2) was an amendment that was brought in, that whichever teacher has not taken the minimum eligibility qualification to continue as a teacher or get appointment as a new teacher, the time was extended till
31st March
19.
2019.
19.
Okay.
And I have completed before 31st March 19. So I was at 48, my lord, Roman 10. And then please see Roman 11 also.
11?
Yes.
Yes.
Once the above information, which is the above information? The experience certificates. Once the above information is provided to the state coordinator, by whom? The principal. Then NIOS will provide the following to individual principal for entering into the system, that is school code and password. Once the school principal receives the password and the school code sent by NIOS through SMS, then the school principal will log into the system for online registration of the untrained teachers. So I am the untrained teacher, I am the end. In this entire flowchart, my lord, I come at the end. Everything to train me is beyond my control, if I put it in this way, is beyond my control. If the above flowchart is completed, only then would I be eligible to be part of the course, is what the secretary, this would now be converted to a recognition order. I will show that. Therefore, this is very, very important. And then please see, my lord, page 49, the next. May I read, my lord? 49?
1 second.
Sorry. Yeah, you meanwhile will it come or no? That will be. Or even though you report your land, can you check?
Right now, you are holding the post of,
I'm not holding any post. I'm teaching in some private schools till today.
and you have applied
As an assistant
as an
teacher
assistant teacher for this.
for the government school, primary level.
Yes.
So I was reading a lot that at page 48, Roman 10 was the foundation. The foundation was experience certificate from principal, not to be submitted by me. The state needs to collect it from the principal. That was the mechanism at that time. On that foundation, could I get this course? Then please see 49, the next very page. The MHRD reaffirms that 49, the very
Yes.
next page. Here number 4.
Yes, timeline. Yes.
Timeline. The timeline which is most important is the third last one, my lord, by 20th August 17.
Yes.
States and UTs will submit complete database of all in-service untrained teachers in government and private schools to NIOS. NIOS is that institute. The cutoff date for me to be in service was 10th August 17. 20th August 17, the state and UTs need to give my name at that time to NIOS that these are the people I want you to be trained. I want the NIOS to train. And all states did this, my lord. All states went ahead and gave their names. And then please come, my lord. To the recognition order, which is, so this communication, my lord, ultimately culminates into a recognition order by which my course was recognized. Please come to page 63.
Yes.
22nd September 17. This is by NCT, which is the nodal agency, my lord, for deciding the qualification of all teachers across the country. The RT Act says so.
Yes.
And then my lord would see the reference which has been given to the communication which we were just reading, my lord, at the fourth paragraph from top. In view of the above mentioned directions of MHRD, Ministry of Human Resource Development, under section so and so, the letter dated 22nd September 2017, following instructions of NCT regulations for ensuring that directives of, so it was a directive, my lord, that letter that we were reading, for implementing the amendment to the RT Act 2009 are duly fulfilled. Please see from 1 onwards, my lord.
Yes.
Any provision related to online submission of the application on the NCT application portal. Any provision related to the duration of program so as to reduce it to 18 months instead of 2 years, and the requirement of 6 months internship to be
So what is this letter 23/9/2017?
23/9/2017, my lord.
A letter dated so and so to the following provisions in the NCT
22/9.
for ensuring that the directions of so and so.
Which we just read, my lord.
That is that letter.
22/9.
That is the 22/9.
By MHRD, which was a directive given.
Page 47.
47.
All right.
Starts at 47.
Okay.
And then the most important part of this is, my lord, kindly come to 65. Everything regarding the course is given, my lord. And 65 is important.
Yes.
Roman 8. This program shall be only for those in service. Very, very important. Untrained teachers in government aided private unaided schools appointed on or before 10th August 17.
And these program is basically training of these teachers,
It's
right?
diploma in elementary education.
Diploma and
Elementary education. That's the only thing. Because the NCT said that any primary school teacher should have diploma in elementary education. There were teachers who were working at that time when this amendment was.
and they did not have this.
They did not have. They
Diploma.
had B.Ed. They had some equivalent course, but
You are entitled to get it from any open university,
I am entitled to do it as a 24-month thing.
which can be also 18 months.
No, as a 24-month thing, I can do it from any open, from Jawaharlal Nehru, etc.
Okay.
But as an in-service teacher, this was the only portal one-time scheme. It was
That
not
is 18 months.
18 months. It was a one-time scheme.
This is under that this particular notification, right?
This particular notification is on the basis of the directive of MHRD.
This
is the
is
recognition
any
order.
provisions related in the duration of the program so as to reduce it to 18 months
Yes.
instead of 2 years and the requirement of 6 months internship within the duration of 18 months.
So these are all the part of the recognition order for my
What
course.
does it say number 2 at page 63?
It's 63.
For implementing. Now, where have they implemented? Where have they amended the RTE Act?
They have amended the RT Act, which we read, my lord. Earlier, the date to complete this recognition was 2015.
Okay.
Then they made it 2019.
Okay.
So therefore, they say here that because, so it was like this, my lord, because we were already in August 17. The eligibility had to be completed, or the minimum qualification had to be taken by March 19. The duration from September to March 19 was only 18 months.
18 months.
So therefore, what came out at that time, my lord, that because these teachers are already teaching,
So therefore, that
therefore that
relaxation.
6 months of internship will be within those 18 months.
A kind of relaxation.
Relaxation, kind of submerging. That is what the word is used.
Anyway, this
Yes.
is settled.
This is settled. And therefore, prior to the present recruitment, my lord, whenever the government has taken people like me, they have never asked for any of these documents. That's very, very important. This is not the first recruitment where I am being appointed or I am being considered. There were recruitments in 2020, 19, 21 by the same very state. And I was considered, people like me are working. None of these documents were ever asked for.
Okay.
Because the foundation is this. Their reliance is on the Supreme Court order, which I'll show does not really come from the Supreme Court order. So I was reading 65, my lord.
Yes.
At 65, my lord, as I said, this program, Roman 8, this program shall be only, that is very important, for those in service untrained teachers appointed on or before 10th August 17. So this 10th August 17 in the Supreme Court order comes from this. And all the present petitioners before my lord have the experience certificate from the principal, which was required at that time, of being in service prior to 10th August 17. It is annexed to the writ petition also. All of us have it. There is no quarrel about that in any manner whatsoever.
That's an admitted position.
That's an admitted position. And then, see, my lord, another communication by MHRD to the state at 69. '69, my lord, the earlier recognition order was of September, my lord, and 69 is October 17. Again, dear secretaries by MHRD. Please have para 3 of this, my lord.
Yes.
It is reiterated that the verification of all unqualified / untrained teachers registered. So first was documents to be given.
Verification.
Then there is a verification also at NIO's portal should be completed by 30th October 17.
30th, 10,
17.
17.
Now, for a minute, if I have to argue against myself, Lord, that if a state has not done this verification at that time, for whatever reason, my lord, there could be two reasons. One, they have done it, then they have not done it. Can 8 years later, my lord, without a statutory backing, that's very, very important. Without a statutory backing, my lord, can they reopen this verification when the entire premise of me doing this course was state's information, state's database, and verification by the state at that time? There is absolutely no averment in the counter or the reply filed by them that what happened to the verification that was done at that time? What happened to the database that was done given at that time? There is nothing. I understand, my lord, if their case was that, see, we had given the names, we had verified at that time, but your name is not found. I understand if they raise that as a ground today. That we have checked our database of 2017. All the petitioners who have before this court, their names are not found in that database. Even then, I can have a counter argument to it that I couldn't have done the course if you didn't give my name. But there is no averment which I will just show. So whatever happened in 2017 as a part of the state's activity, the state in their defense is silent about it.
All right.
Then please come, my lord, page 70. See how foolproof, my lord, in my humble submission, this entire scheme was made. Please see page 70.4, para 4. The NIOS and state government would need to sign a MOU for which a pre-vetted format of the MOU is enclosed. In addition, state would also be required to organize workshops in November, December for the learners of which norms and remuneration is given at annexure so and so. And then see 72, my lord, the MOU. The MOU starts at 71. That how every state had an MOU under which all this had to be done and was done. 71, my lord, is the format of the MOU. It is between NIOS and Department of Dash. It will be the specific state, my lord.
Yes. All right.
So this is one thing in this, my lord. 72 is important. Clause 1 and 2 are important, my lord, of the MOU, which the state would have signed, and it is not on record today, but please see clause 1, my lord, of 72. Work in close collaboration with the Department of, it will be SAM here, to open the study centers as per so and so. 2 is most important. Very, very important is 2. Enroll the learners with NIOS after necessary documents are verified by the Department of so and so.
Yes.
So the responsibility at that time, as I said, was on them, my lord. And then my lord would kindly see that how, so these are the documents which I wanted to show. After that, my lord,
These verification is only for
in service.
huh?
In service. Whether I'm
Correct,
in
but
service.
to ensure that whoever these teachers are working wherever, whichever unneeded government schools, as unneeded private schools and all, are also having the due qualification of
Indeed.
diploma. This is the purpose, isn't it? These verifications.
This verification is for this purpose.
Is to ensure that those teachers have
are actually working there. As
are
simple
no,
as.
not working there. The
Hello.
fact that they're having these qualification, I think qualification is important,
But unfortunately,
isn't it?
document that doesn't come in. What comes in from the documents?
No, the verification process is otherwise to ensure that they get the training.
Yes, the verification.
Correct.
We just let us read it once again, my lord, for my convenience, or in fact, my lord's convenience. Let us read it once again.
No, this whole process started from that first document you showed.
Indeed, my
This
lord.
is all for the training purpose.
Training of 18 months.
Training of 18 months. Now, this purpose is for what? To ensure that these teachers who are working in these private schools
Yes.
have the requisite diploma training.
Indeed.
Correct.
Indeed.
So, basic purpose is for their qualification.
Indeed. Indeed, that is one purpose. There is also a second purpose. That someone who is not working, someone who is actually required to take a 2-year regular course should not come in here. That was another purpose. Because everywhere the emphasis is untrained in-service teachers. That's very, very important. The emphasis is not on any teacher. It has to be untrained in service. So this
So,
verification
whoever is already doing the training will not come in here.
will not come in here, or
So these are the reasons why that verification is required.
Or a person who was not teaching but wanted to take this course should not come in. That is also another very
Followed.
important aspect.
Followed.
So therefore, the provision is, or the clause is, enroll the learners with NIOS after necessary documents are verified by the Department of the State. Documents whether I am teaching in that school or not. In service was the only thing to be done by state. And then my lord would kindly come to the writ petition now. And I wanted to show that there is a Supreme Court clarification. The Honorable Supreme Court then implemented its own order. Let us please see that. That will just throw some light upon, because the entire argument of the state today, which they will canvass before my lord, is Supreme Court empowers us to do this. And I will show from these orders, my lord, that the Supreme Court, rather, in one of the cases of BTR, my lord, has said that please go ahead and appoint. There is absolutely no question of verification. I will show that order, my lord.
There's an apex court order.
Apex court order saying that please directly appoint them of June 2025. So please now have.
Where is that order?
This is the last in the line, my lord. There were two orders prior to this, but let us see this first, because this concerns state of BTR actually. Yeah. BTR. Lord, may I read?
Yes.
These transfer petitions have been preferred by the petitioners who have preferred writ petition before the High Court seeking appointment to the post of assistant teacher on the strength of 18-month diploma in so-and-so, conducted by so-and-so. The basic proclaim was the order passed by this court on so-and-so, and the clarification issued by this court from time to time. Mr. Ankit Roy, learned standing counsel appearing for the state of Assam, fairly states at the outset that similar writ petitions preferred by other candidates remain pending, and those have been decided by High Court granting relief similar to the ones which the present petitioners have prayed for. Then please have the next, which is very, very important, my lord. Learned counsel appearing for the state of Assam prays for sending the matter back to the High Court. However, considering that the similarly placed petitioners have been admittedly being granted relief, which they have been prayed for, it would be necessary to relegate it unnecessary to relegate the petitioners to the High Court. Therefore, we dispose of the present petitions by allowing the writ petitions preferred by the petitioners in terms of the orders passed.
Which is that other the decision of the High Court that has been referred here.
And then please see the last part. In addition, it is directed that since the petitioners have already participated in the counselling, they shall be issued appointment letters, orders based on their merit position / result of the counselling.
But where it is said that without insisting on verification of the documents.
Yes.
Where is that?
That will come, my lord. There are
No, that is not there in this order. You
show
had given the impression that it says without insisting on the verification. If I heard you correctly, I
Yes,
don't
yes,
know
it
what
does.
Mr. Saikia had heard, but
Yes.
I heard that. Yes.
The distinction is this, my lord. This is for BTR. For Uttarakhand and West Bengal, the Honorable Supreme Court says verify the claims. I will show that. Here, there is no concept of verifying the claims. They say they shall be issued appointment orders based on the merit position. Why is the distinction, my lord? Once we see those two orders, it will become clear. Can we just have those two orders in the next 5 minutes? It will become clear that why those two orders cast upon a verification. Here, there is no verification required as per the terms. In fact, they are proceeding ahead to
Mr.
issue.
Counsel, what is the arbitrariness or illegality? On what basis? Because it is the state who is deciding the terms and condition of the recruitment. They have issued that circular. What is your ground, basic ground?
The basic ground is this, my lord.
They are the ones, they want to verify the credentials, they want some testimonials. What is wrong in that if they're asking? Whether you have whether they had done a similar exercise earlier during the training part or not, that is not the question. If you have been teaching in a school, you should have had these documents. They only want you to produce those documents. What is wrong?
The answer is
This court is exercising extraordinary writ jurisdiction. The state, in order to ensure, because ultimately this is for the benefit of the larger public interest is also involved. It is not per se only the teachers. So many things are involved. The state wants to ensure everything, and they are asking for certain documents. What is wrong about that?
The answer is
Ultimately, that has to be
Yes.
decided,
the
isn't
answer
it?
is this, my lord.
Now, this training and all understood. At that time, verifications have been gone into to ensure that these teachers who are in service receive these training, that 18-month benefit, who are already in training will not get it, all understood. That has been done. That's a different exercise. Now, as per this is concerned, for this particular recruitment in question, they say, after, and that also after the Supreme Apex Court's decision, which says if they are in service so and so. Now, in order to verify whether you were in service to that particular cutoff date, they want these documents.
The answer is this, my lord.
Just because you are, according to you, the how many petitioners?
171.
These 171 petitioners does not have it. That is why you are saying it is only because of that, isn't it?
No, it is not really because of that, my lord. There are multiple more things that I will show, my lord. The point that I am trying to make is this, my lord. State at best, my lord, kindly. Allow me to frame.
When was the first advertisement issued?
26 December 2023.
26
December 2023.
I'm sorry if I'm breaking your flow.
Not at all, my lord. I am. It is
It's just that I have this habit of
Not
asking
at all.
questions, so don't get intimidated.
Not at all. My lord. This is my duty.
Please give me the date of
26 December 2023.
26
December 2023.
23. And the Apex Court judgment came on when?
The Apex Court judgment of clarification comes on 10th December 24.
Before. And the circular?
The circular, the present impute circular, my lord?
Yes.
Impute circular comes on 17 June 25.
17?
June 25. There is one more date which will be important.
Yes,
my lord.
please.
The Apex Court clarification comes on 10th December 24.
10?
December 24.
10 December 24 you have given. That is
But
that is the Apex Court judgment you said?
clarification.
Yes, yes.
But it is made effective from 28th November 23.
20?
8th to 8th
Yes.
November 23. It is made effective from that day.
23.
Yes.
Right. So therefore, this
Advertisement is covered.
is covered.
Yes. Now the question that my lord put to me, that if state wants to verify etc. these documents, my lord, in my most humble submission, my lord, state has the power and the ability to fix the eligibility. That too relying upon the NCT guidelines. The NCTs decides the eligibility of an assistant teacher, which is common across the country. The state uses those NCT regulations to fix the eligibility. The question really is, my lord, am I fulfilling that eligibility criteria? Yes. They can have 10 more things to ask me on the eligibility criteria. Having these 9 extra documents for which, one, they need to describe the source of power, my lord, because they are Article 12 state. They need to
Source of power for what?
for asking these 9 documents.
The Apex Court decision?
Because the Apex Court does not say that verify the in-service status.
One of the condition is
Yes.
One of the condition is
that I should have been in service.
yes.
The in-service.
Now the Apex Court doesn't have to write everything in clear. That now you start a verification
Yes.
process. You start asking for ABCD
Yes.
documents.
Yes.
That it did not spell
It will not
everything. Anyone who read that order will understand these are
Yes.
the two conditions. Now
Therefore-
how the state wants to satisfy these two, whether these two conditions have been fulfilled or not, it is their prerogative.
Yes. The
What is wrong in that?
answer to that is
They are doing it. They're following the order of the Apex Court.
answer to that is this, my lord.
If they don't do that, another batch of writ petition would have been filed, saying that they are not verifying. Without verification, they are allowing it. That could have been also a situation, isn't
Possible.
it?
Much possible.
Mr. Karla?
Much possible.
Yes.
But the way this clarification order has been interpreted by the Apex Court, again, for Uttarakhand and West Bengal will throw some light upon the query that my lord posed. That is point number 1. Point number 2 is it is not just the state of Assam which is implementing the Supreme Court's order. There are at least 8 states plus KV implementing the Supreme Court's order. I had the good fortune of assisting in almost 7 of those.
Those, they are not.
0. I have example of one of that. KV, my lord, Kendra Vidyalaya Sangathan.
Just because they are not insisting doesn't mean that the state of Assam is precluded, Mr.
My
Counsel.
lord, the state
They are
of-
trying to be more vigilant.
The answer is this, my lord. that if any of the Honorable Supreme Court's own interpretation can show, which they have interpreted later, that you please verify the in-service status over and above the experience certificate. That's very, very important. All these writ petitions, etc., that were filed, because I had the opportunity of filing them, Lord.
So you want to say because the petitioner has the
experience certificate, all of us have it.
which was one of that condition in that
Only
earlier
condition.
only condition.
Yes.
Therefore, that is sufficient.
Sufficient. There can't be more things to it.
Noted.
That is my
Noted.
primary argument.
Noted.
That I am producing. If I don't produce that certificate as an in-service thing, I'm out. Absolutely no quarrel on that.
Noted. You please give me the reference of these pages of these experience certificates.
Indeed. Can I just show one?
You
for,
can give it that later on. You can
for example,
give
can I
a
show
short
one?
note indicating all this
Very
later
good.
on.
We have made a written submission. Can I just show one as an example?
Yes, yes.
Please see 68, my lord.
Yes,
for the
just
first.
read it.
68 is by Christo Jyoti High School, Post Office, Golaghat District, Golaghat, Assam. Says experience certificate issued by the principal.
Page
68 of the writ petition, the fact volume. And for each of the petitions I have produced. '68.
Yes.
Christo Jyoti High School, my lord. Post Office,
Date is blank.
It's written on the bottom, my lord, 23/6/25.
Where?
On the bottom, above the signature, my lord, by the principal.
Yes. Why that date column is blank?
That the principal would know on the school. But in my humble submission, my lord, if we get on to the fact finding, my lord, my lord, but see,
Yes.
please see this, my lord. Experience certificate. It is hereby certified that Mr. Dilip Bhandari so and so has been working.
All right.
It is not their case. This is very, very important.
All right. I've taken note of your argument.
I'm
You are
going a
saying
step
that you
further.
have the experience certificate. Therefore, there was no occasion for the state to ask for further documents because anyway, a verification has already been done.
I'm going a step
Correct.
further. It is not also their case that these experience certificates are
not
fraudulent. Are fraudulent. It is not their case. It is not their case that we have looked into these experience certificates. We have checked with the concerned school and they have said no, they never issued such certificate. So the correctness of my experience certificate is not in question because they have not disputed it. That's very, very important.
Have you been not allowed? It is your apprehension that because you don't have these documents, you will not be allowed to participate in the
The
further
list has
process.
come yesterday, my lord.
There you are not. You're not there.
Most of us have been withheld, and most of us have not been considered, despite being higher on merit. The people that are featuring in the merit list
Withheld perhaps because of verification.
withheld because of the fact that the case is pending.
There are some back office verification is.
Sorry.
There are some back office verification. I have the complete figure. I'll place it, Lord.
And then another example, because my lord asked me the date. Please see 100 also for every.
Right, that's all right. I've understood.
So
Joining date is there.
Joining date is also mentioned at 100. So for each, and I understand, my lord, a supporting document or a subsequent document would be relied upon if there is a credibility doubt. Please take my words, Lord. Credibility doubt to the main document, to the foundation document. It is no one's case that there is a credibility doubt to the foundation document. Or the supporting document in any government scheme, my lord, or any government recruitment will be required if the first is not available.
All right. Next point, please.
Then, my lord, will come
You
that.
don't have to repeat the point. I've understood.
Very well, my lord. Please come to how the Honorable Supreme Court applies its own clarification. Please come to writ petition, page 585.
Page
585. This is March 25, my lord. I'll take maximum 20 more minutes, my lord, and
No, it's all right. Yes.
page 585, my lord would see. This is the Honorable Supreme Court applying its own clarification for Uttarakhand. We'll have to just go through this judgment, my lord. This will throw some light upon whether this in-service concept can be looked into again. Kindly have para 1 at page 585, my lord, to understand what was there before the Honorable Supreme Court. May I read, my lord?
Yes.
By way of this application, the applicants have approached this court for a direction on the respondent, which is state of Uttarakhand, to permit the applicants who are holding 18 months DLED qualification from NIOS under the open and distance learning mode to participate in the ongoing counseling process and to subsequently be appointed to the vacant post in the ongoing recruitment. This case has a checkered
What
history.
is counseling process? That is that training process.
The counseling is the state recruitment that was ongoing in Uttarakhand. So like the state recruitment is ongoing here, my lord, there also state recruitment was ongoing when
And
this.
there is some counseling process.
Yes, counseling. This verification appointment is a part of the counseling. So together they put it as a counseling process. And now 586 gives the entire history of the documents we read, my lord. Everything
Yes.
is put in here from para 3 onward.
Read.
It will be important, my lord.
Read.
In 2017, an amendment has been carried out to the Right of Children to Free and Compulsory Education Act 2009, wide which clause 2 was inserted in section 23 of the said act. The Right to Free and Compulsory Education Amendment Act of 2017 was made retrospectively applicable from so and so. It was provided that every teacher who had been appointed or was in service as on 31st March but did not possess the minimum qualification of 2 years as laid down under the subsection 1 of 23 would acquire such minimum qualification within 4 years from the date of commencement of the Amendment Act, which was 15. Then please see para 4. In view of the provisions of the second proviso, to subsection 2 of 23 of the RT Act, MHRT, this is the letter we read, my lord, the first letter, had issued a letter of 3rd August 17 to all the Secretary of States and Union Territories directing that all teachers in government school must possess minimum qualifications as mandated under the RT Act, and a last chance was being given to all such teachers to acquire minimum qualification till so and so. Failure to acquire the said qualification within the stipulated period would result in dismissal from service. Since the time gap between 31st March 2015 as provided in the 2017 Amendment Act and 31st March 2019 as specified in the direction issued by MHRT was 18 months, the NCT issued a recognition order of 22nd September 2017 for conducting DLED program through ODL mode by NIOS through Swayam portal of MHRT for in-service untrained teachers at elementary level working in government aided and unaided private schools.
What is ODL mode?
It means online distant learning.
Yes, please.
The said recognition order.
Online distant learning. All right.
This
Yes.
is the recognition order we read, my lord. Then please see, we can skip para 6, my lord. That may not be of relevance. Kindly come to page para 7.
Which is para 6 is which one?
Subsequently, the state of Uttarakhand that we can skip because that is relevant to specific to Uttarakhand. That is not required to be gone into. What is next important is, my lord.
Let's read the whole order.
Very well, my lord. Subsequently, the state of Uttarakhand issued district-wise advertisements for the post of assistant teachers in primary schools in accordance with Uttarakhand Government Elementary Education Teacher Service Rules, for short 2012 rules, framed by the government of Uttarakhand, which provided that for being eligible to appointed as a teacher, it was necessary to have a diploma course of 2 years or equivalent. Initially on 15 January 2021, the Secretary Government of Uttarakhand issued a letter to the Director, Elementary Education Uttarakhand, to permit such candidates who passed 18 months diploma of NIOS through ODL mode to apply for the post of assistant teachers against vacancies issued through the aforementioned district-wise advertisements. This was done in compliance with the letter dated 6th January 2021, issued by NCT to the Chief Secretaries to all the states and Union Territories, requesting them to consider all those candidates who had completed DLED course of NIOS through ODL mode. However, shortly thereafter, upon realizing that 2012 rules did not recognize the 18 months diploma through ODL mode from NIOS as a minimum qualification for eligibility, the government of Uttarakhand issued another communication dated so and so, whereby its earlier letter dated so and so was withdrawn. Then please see para 8. The aforesaid communication dated 10th February 21 was challenged in a bunch of writ petitions before the High Court of so and so. On 14th September, the High Court held that 18 months DLED training conducted through ODL mode by NIOS cannot be said to be a lower or inferior qualification as compared with the 2-year DLED program, and the same was valid for applying against the post of assistant teachers primary in the state of Uttarakhand. Challenging the aforesaid judgment and the order passed by the High Court, a batch of appeals came to be filed before this court. The said appeals were decided on so and so. In the such judgment, one of us, the Honorable Justice, the Chief Justice is saying this, my lord, this court have held the validity of the 2012 rules. In the aforesaid case itself, the court had clarified that the scheme which was framed by the Government of India, while the aforementioned recognition order was done in order to provide a one-time opportunity to such of the teachers who were already in employment as on 10th August 2017 to get a qualification of a diploma course as required under 23(2) of the RTE Act, which had been inserted by the 2017 Amendment Act, with retrospective effect from 1st April 2015. It is also, this is the primary judgment that they are relying upon, the earlier judgment. It has also been held by this court that the period of 18 months has been prescribed in order to meet the deadline for appointment of teachers as specified under 23(2) of the RT Act. Noticing how this was a one-time opportunity to ensure that in-service teachers remained in service, this court had held that it would not be equivalent to the 2-year diploma, which is the requisite qualification. Now, 12 is important, my lord. It appears there was some confusion in some of the states and therefore review applications were filed. This court had declined to entertain the review petition miscellaneous application on the ground that the judgment was clear enough. It held that the one-time scheme was provided solely to safeguard the interest of those teachers who were employed as on 10th August 17. This court had clarified by paras 3 and 4, which is the order we just read, my lord. Para 591, if my lord could come. Para 3 is the order of we read.
Yes.
And para 4 is the retrospective
Yes.
applicability.
Yes.
Now 15 is the grievance in the present, matter.
Yes, please read. I'm reading.
Very
You don't have to give on the commentary.
Very
Just read.
Para 15.
Yes.
The grievance of the applicants herein is that though they are eligible as per the original judgment of this court dated so and so, and the clarification dated 10 December 24, inasmuch as the advertisement in the state of Uttarakhand is dated 29th May 2024, that is after the judgment was delivered on 28th November 2023, the state of Uttarakhand is not considering their claim. It is submitted that in the reply given by the state government, it is stated that the selection process is almost complete and therefore the claim of the applicants cannot be considered. Shri so-and-so, learned senior counseling appearing for the applicant, submits that the information received under RTI so-and-so would reveal that there are 279 posts vacant and the number of applicants are 239. In present case, my lord, entire 5500 is vacant in today's case, my lord. Shri Sankarnarayan fairly states that the applicants do not intend to affect the selection process already done. Ms. Vanshida Shukla, learned counseling appearing on behalf of the state, on the contrary, submits that while the judgment dated so and so, this court has upheld the 2012 rules of state of Uttarakhand, which provided that a diploma of 2 years or equivalent was necessary for being appointed as teachers. She further states that any interference at this stage would cause the complications in the selection process already completed. 20 is important again. No doubt that this court has upheld the 2012 rules framed by the state government while the judgment dated so and so. However, at the same time, this court had clarified that such of the teachers who were already in
Para 23 is important. I have come. Come to para 2023
we therefore direct the state government to consider the claim of the applicants
in accordance
with
the clarification
Yes.
dated 10th
10th
December
December
2024. And if the applicants are found to be eligible
Indeed.
to appoint them in accordance with law,
Indeed. So therefore,
there is no dispute.
there is no dispute. So therefore, here the claims are to be considered
Yes.
qua the 10th December 24.
Yes.
10th December 24 says you have to be in service.
Yes.
In service concept as in August 17 was you should give the experience certificate. So this exercise, my lord, was completed and those Uttarakhand teachers have been appointed. On what basis? Only one document, which was the foundation, which is the experience certificate. To the best of my knowledge, my lord, if I would submit, unless there is a gate opened that in addition to what was sought in 2017, you can ask for whatever you want. How can the state read between the lines?
All right, I've understood. Anything else?
Yes. Then there is one more judgment because that was the defense taken on the day of issuance of notice by the state. I will show you that, my lord. But please see this one judgment. This is for Uttarakhand. I read. The next is for West Bengal.
Yes. Page
This starts, my lord.
595.
It starts at 597. Just 2 pages I want to show in this, my lord. The entire judgment was on similar lines, but 2 pages would be important.
Yes.
If my lord would first have
Yes.
Page 624. The direction.
Yes.
Direction 6 is important. We
Yes.
direct the respondent authorities to consider the candidature of such of the
Yes. Same.
So
There's no dispute to this.
there's
And that who on verification are found to satisfy the eligibility criteria
Indeed.
shall be appointed within a
Now,
period
what
of
is
3
the
months from today.
Yes, what is the eligibility criteria? That is very
Same Uttarakhand and West Bengal, the direction of the apex code is same.
Slightly.
That as per that clarification, if they are entitled, and this in fact emphasized on verification as well. In the first judgment, the word verification was not there. If the petitioners are entitled, so entitled, then here it is added after verification.
Kindly
Yes.
pardon me.
Now
for
you
reading.
see the problem is here.
Just give me 60
The problem is here that the state has devised its own way of verifying.
There's
And they have asked for few documents.
Kindly pardon me, my lord. I would want to read this line
Yes.
once again.
And that appears to be in line with the judgments of the apex court.
Well, kindly pardon me. I will want to read it once again. Please read it with me, my lord.
The entire, it has to be fair and transparent. They are trying to adopt a fair and transparent method. What is wrong?
Well, kindly have it with me once again. I'll be able
Yes.
to. I have the confidence that I'll be able to satisfy, my lord.
Yes.
Please see Roman 6, my lord. We direct the respondent authorities to consider the candidature of such of the appellants who are in service as on 10th August 17 and who on verification are found to satisfy the eligibility criteria.
Yes.
Not the verification.
Eligibility
Yes,
criteria,
yes,
which eligibility criteria?
Yes, please come. That is the question.
The,
Please come.
the eligibility
Yes.
criteria is already there on
No, no,
10th August order.
No, no, no. The eligibility criteria is at para 10. Please see 605.
Para 10.
605. This
Para
is the
10.
eligibility criteria. And the present eligibility criteria, I'll show, my lord. I have no problem in verifying the eligibility criteria. That's the point that I'm trying
All
to
right,
draw.
para 10.
This is Shri Gupta is appearing for West Bengal, my lord.
Yes.
It is submitted by, this is the eligibility criteria. It is submitted by Shri Gupta that not only a valid diploma, but also other requirements such as clearing TET, teacher's eligibility test, in terms of recruitment notification dated so and so, issued by so and so, West Bengal Board of Primary Education, my lord, have to be fulfilled so as to be considered for appointment to the post of a teacher in a school. It was
So
how
in addition to diploma, the other requirements
diploma.
also.
The eligibility is this.
All right.
And the eligibility has to be seen in my advertisement, my lord.
So it was therefore fairly submitted by the learned senior counsel that such of the appellants who fulfill the eligibility criteria in terms of prevailing recruitment notification can be considered for appointment.
Indeed. And please see the recruitment notification in the present matter. Nothing like this is mentioned.
Where is that notification?
Yes, ma'am. Kindly have
Eligibility criteria?
this one. Please see 54, my lord. So 54.
Yes.
Oh, this is the advertisement. Just 1 second, my lord.
This is what? 54
This
is
is the
what?
impugn notification.
This is the circular.
This is the impugn notification,
Yes.
my lord.
Where is the
I'm showing the advertisement, my lord. This one. Please see 574.
5?
74.
574.
Indeed, my lord. $574, my lord, is the advertisement.
26 December 23. Yes.
Indeed, my lord. And then please see the eligibility criteria, which is mentioned at 575.
1 second. Page?
575,
Yes.
para 15.
Para 15. Yes.
Eligibility criteria for LP schools as per Government and Department of School Education, notification dated so and so.
Yes.
Assistant teacher for lower primary is the second column, my lord, category of post. And
Yes.
please see the essential qualifications.
Yes.
Higher secondary senior education with at least 50% marks.
Yes.
And 2-year diploma in elementary education.
Yes.
And Assam TET or Central TET.
Yes.
And non-essential. So they have given essential, which is the first 3. And they have given the non-essential ones.
Yes.
Where does any of these 9 documents find place in the eligibility criteria is the question that I put to myself. The eligibility criteria, I repeat, my
No,
lord.
no, Mr. Counsel, those documents are not for eligibility.
No.
Those documents are only to verify whether you were on service on that particular cutoff date, if I have understood it
Indeed.
correctly.
Indeed.
Subject to correction, of course, but it appears that those documents are in connection with the Supreme Court's order.
Indeed.
That
So
is not.
therefore, the power
Yes.
and the scope of verification is limited. Let us see the Supreme Court order once again. It is limited to verifying the eligibility, not verifying whether I am in service or not. Let us see that order once again. Let us please read it with me once again.
Which order? The 10th?
The Honorable Supreme Court's order
The
of
10th?
March 25 of West Bengal. Page 620.
That I've understood.
Are-
That I've understood. That is in context of that case.
None of
I've
this-
understood, Mr.
Yes.
Counsel. Yes.
Even
Next,
in
any
Uttarakhand
other
case,
point?
yes. Even in Uttarakhand's case, my lord.
That I've understood. Any other point?
Yes.
In addition to all this?
Then please see, my lord, how has one of the authorities, my lord, written submission? How has one of the authorities, my lord, KVS, followed the Honorable Supreme Court's order, and what have they asked for?
So, Counsel, that is not material. If somebody else is not asking something, that doesn't mean the others are precluded. Is that some kind of a precedent?
Well, there has to be a source of
If another school or another authority is not asking for few documents, that becomes a precedent or what?
well, the question of parity would come in.
No, I have understood your point.
Please see
Yes.
in the convenient second.
I have understood that according to you that these documents were not required because firstly they were already available and all that they need to see is whether these persons were in service or not. For that the eligibility, the experience certificate itself is there, which is already there
which
on
was asked
record,
at that time.
which you have asked, we have all, and that you have given. That is sufficient. You don't need anything more.
In the second volume, my lord, of the convenience compilation, please have page 6 for a minute.
Page
6.
Yes.
Now, this is the table of all.
One second. In that compilation.
Compilation.
Yes, page
6, my lord. This is a table, my lord.
Yes.
This is a table of all, if I may read, annexure referred to in so and so, asked by the honorable members of parliament, Shri so and so, teachers holding diploma in elementary education by NIOS. So similarly placed teachers like me, my lord, in 35 different states, including the state of Assam, my lord. So number 4 is Assam.
Yes.
And admission confirmed, my lord would see is 1,33,878.
Yes.
So in the entire country, my lord, the system of inducing me or having me in this process, in this NIOS scheme, my lord, was common.
Was?
Common. It was common because of the MOU being common to everyone. Because the letter of MHRD being common. My lord put a question to me that because one state is doing, can you really draw an argument that because they are doing, why should this state not do it? Can there be a comparison to that? The answer that I'm trying to make in that context is this, my lord, that when the system of having me for the course was identical, the letters, communication, recognition orders, MOU was common, my lord. Plus, my lord, there is no express provision of law or order. Very, very important. It may be different to say, my lord, that the Supreme Court says, please verify the in-service status. I have no problem. Please verify. But the question really comes is, what was not really sought for as an experience or an in-service proof at the stage of relevant time can today it be sought? Because, my lord, therefore, I say that it is changing the rules of the game.
All right.
When an admission is sought, my lord, it is like this today. If my
Mr. Counsel, you don't have to repeat.
Then please have, my lord, the affidavit in opposition filed by the government. I wanted to show 3 things from that. That what have they said in their reply?
An affidavit.
Opposition.
Go ahead. File to go.
Affidavit in opposition.
Yes. Which para?
Para 3, my lord, they choose not to give a para-wise reply.
No. Page.
Page, sorry.
Sorry.
Page will be 640.
640.
640.
Oh, no, he filed to you.
Affidavit in opposition.
No, I thought it's part of this. No, good to filed it. এখানে রূপক এখানে actually ইয়ার part right? It ইয়ার part.
Oh, yes.
Yes, page
640. Para 3.
640.
Yes. After this, I will also want to show the grounds because they don't reply to my grounds and my
640.
power that I asked for. Instead, what they say at para 3 is because my lord will have to decide as to the pleading also in my humble submission.
Yes.
At 3, they say that dependent, instead of giving para-wise reply to the writ petition at this stage, deems it appropriate to disclose the stand of the department against the relief sought for in the writ petition. However, the dependent craves leave of this court to file a detailed para-wise affidavit later. So, in my writ petition, I will show the grounds I have asked for their source.
All right, please carry on. Yes.
Please have para 5 now, my lord, at 641. I'm reading para 5.
Yes.
That before replying to the contention of the merit, the answering respondent raises a preliminary objection to the maintainability of the instant writ petition, as it is based merely on an apprehension and is therefore premature. In this regard, it is stated that in compliance with the order dated so and so, and the Director of Elementary Education issued the impugned notification dated so and so, directing the candidates to submit the documents in support of their claim of being in service as on 10/8/17. The first thing here is, my lord, the Honorable Supreme Court's 10/12 order does not.
Mr. Counsel, can we just read now because you have already emphasized those points? No point in unnecessary reiterating all that. Let us just understand first what the state wants to say. You are placing the state's affidavit, so continue reading it. In your summing up of the argument, you can sum it up.
Very well. Now, please come to 643, last part.
Yes. 642, complete that paragraph you are placing.
It may not, if my lord,
It's not necessary.
not necessary.
All right.
If since we are short on time, my lord, I'll push it.
No, I do not want to cut you. I am ready to hear you.
No, my lord, I
But
understand.
there is no requirement of repeating the same things.
Very well.
Repeating is not going to help you. You clarify the doubts, that's all, and then place whatever you want to place. At the end of the argument, you can also sum it up if you want.
Please come
But
to
every
643.
second minute, if you start repeating the same thing, then you see the court loses track of the main issue. That is why I'm saying. So follow the hints coming from the court.
Very
You
well.
place everything what
Please
the court wants.
come to 643, last 3 lines, my lord.
Yes.
The Honorable Supreme Court.
Where?
Last 3 lines at 643.
Last 3 lines from the bottom. Yes.
The Supreme Court has further granted liberty to the employer to verify the in-service status of such candidates.
Yes.
There is no basis for this. No, there is no liberty further granted by the Supreme Court. This argument doesn't really stand.
Okay.
Then please come to next page, 644.
Yes.
At para 8.
Yes.
That the answering respondent humbly begs to state that there must be necessarily be a reasonable and transparent mechanism to ascertain whether candidates were in service as on 10th August 2017 at the time they enrolled for and completed the 18-month diploma course. Employer has the discretion to find out whether the candidates have fulfilled the relaxation granted by the NCT and have they fulfilled the observation made by the Honorable Supreme Court in the case of Jaiveer Singh and others was a state of so-and-so. Order passed by so-and-so. The reluctance to furnish service particulars creates doubts regarding the eligibility. Please mark this, eligibility, and runs contrary to the spirit of verification process. It is inexplicable as to why the petitioners are reluctant to furnish their service particulars, which are essential for ascertaining whether they were in service candidates as on 10/8/17 and had duly completed the 18th month's course so as to legitimately claim the benefit of the relaxation granted by NCT. Please mark 2 words here, my lord. Essential for ascertaining, and employer has the discretion. Then please come, my lord, to page 645.
6, 4, 5. Next page.
Yes,
It is stated.
645. They have reproduced the documents that are
Yes,
required, my lord.
yes.
The last document is the most
UDIS.
problematic one because, as I say, that even till today, some of the schools do not have it because the government has not made it mandatory across the state. If the government had to make this core mandatory, and
UDIC records. What is exactly this UDIC?
because this is basically like an Aadhaar card for a school,
Hmm.
that you will have a unique identification number and you have to register with the government.
This is under some provision.
This is by the state, my lord. They are doing it as per their own powers under the RTA Act. But some states have done it, Assam has not done it. Whether it is mandatory or not mandatory is the first question that we need to ask ourselves before making it mandatory for us to give. Lord, I repeat myself. I'm sorry.
Understood. Yes.
Then please come the last 5 lines at 645.
Yes.
However, the honorable courts nowhere in the judgment held that all the petitioner candidates who obtained 18 months DLED through NOS were in service. This is the most problematic thing, my lord.
Okay.
Why
Next.
so, my lord? Because what I showed through the, in fact, I'll submit at the end.
According to you, there was no nothing
I-
said about how to verify, or verification also not said.
Slightly different, my lord. According to me, every person who has done course through NIOS was in service because they were the ones who gave the name.
Who gave them?
Unless my name wouldn't have been there,
They were not there.
I couldn't have taken the course.
All right.
That is what the circulars say.
All right.
And then please come to 646.
646. Yes.
Sir.
You file a reply to this?
Yes. Rejoinder, yes, my lord. Reply. Please see 646, my lord. The first paragraph, last 3 lines.
Yes.
Now the stand of the state changes. Now, earlier they were saying they're essential documents. Now they say
Where?
646, last 3 lines, first paragraph.
Para 10.
Moreover, the documents asked
Yes,
for.
yes.
Moreover, the documents asked for in the notice dated so and so are very basic only and rudimentary for a person to submit who is in service. And then para 10, which again I say is an averment not supported with any support with any evidence. Please see 10.
Yes.
That the answering respondent submits that the petitioner's plea, if accepted, would nullify the employer's statutory and judicially recognized discretion. Please mark this. Statutory discretion and judicially recognized. In the present case, they both are missing. To verify the service status of candidates, thereby defeating the very object of NCT's conditional relaxation. The documents sought are standard employment records ordinarily maintained by any genuine in-service teacher, and failure to produce the same raises doubts about the authenticity of the petitioner's claim. Now please see the next part. The verification exercise is an essential administrative process aimed at ensuring fairness and preventing fraudulent claims, particularly in view of the reported instances across the country where NIOS DLED candidates were misused by person not in service as on the cutoff date. Let them show one. They say that entire basis of we verifying is because NIOS course was taken by people who are not in service. Let them show at least one. There is not even a single.
All right.
And then, my lord, please come to their committee, which is constituted after the interim order passed by this honorable court, which again in my humble 648.
What is this committee?
Yeah, they rely upon a committee of the internal government, which says that the committee suggested please verify these documents. Okay. This committee's date is very important, my lord.
14/7/25.
Yes, the impugned notification is 17 June. Interim order passed by this honorable court is 30th June.
This is July.
This is 14 July. Subject is committee for verification of 18 months of DLED from NIOS. With reference to the subject cited above, I would like to inform that in view of the judgment of Honorable Supreme Court in case of so and so, the applicants who have successfully submitted their online applications in so and so against the advertisement dated so and so are allowed to attend the second phase of physical document verification starting from so and so. In this connection, a notice was issued on so and so, which is the impugned notification, wherein the following documents were asked for. And as such, they say at the last paragraph that the committee is constituted
For verification.
for verification.
Because by that impugned circular, the documents were asked from you.
Indeed.
And by this, the committee is set up to verify those
In
documents.
the reply, they have said that the committee has suggested to ask for these documents.
This but whatever that is that there are not, the document at page 648 speaks for itself. Yes.
And then just 3 grounds in my writ petition, which they have not replied to, where I've asked for their source of power.
That's all right. It appears that they have answered to that. They have indicated their source of power to the apex court decision. Whether that is right or wrong, this court will decide. Yes. Now you show me from your averments, where have you said that you will not be in a position to give these testimonials? How are you prejudiced? Which are those paragraphs?
Please come. To page 25, para 5.
Paragraph?
5 at page 25.
Page 25.
Indeed, my lord. My lord also read that in the reply, they have not questioned any of my eligibility
Yes.
in terms of explicit certificate.
That I shall take a note.
They have not said that because
That you are not eligible.
that is one thing. They have also not said.
So which paragraph have you said about your experience here?
Yes, please
Just
come to
to
page
give me that paragraph also.
Page 5 may be seen.
Page 5, na?
Page 25, para 5.
Page?
25,
Yes.
para 5.
This is the experience.
This is the eligibility and the experience, both.
That certificate of the principal.
Indeed.
So this reply, but there was no paragraph reply.
There is no paragraph reply. I
So
say
not
that-
denied.
not denied. I say I meet
Not
the-
denied or not disputed also.
Indeed.
All right.
Para 5 is where I say I meet the essential qualifications.
But they say that they want to be more careful because there were instances where in some cases they have misused. That is how they tried to.
That is what they say, my lord. But
No, I'm just trying to
best of my
understand.
knowledge,
Correct.
as I said,
That's all right. You have already said there is no instance.
9 states I have dealt with, not even a single
All
one.
right. Yes.
And just 60 seconds departing from this, my lord, there are multiple judgments to this effect, my lord. The question of a secondary document comes into picture once the primary or the foundation document is doubted.
All right. Next. Come to
Then
paragraph
please
5.
come, my lord. Para 5 I was reading. It is respectfully submitted that the eligibility of a candidate under the norms of NCTE and the state government is primarily based on 2 essential qualifications. Possession of a recognized teaching qualification such as DLED, which I have done.
So this
Being
is
in-
okay. Para 4 is understood. Now, where have you, para 5 I have understood. Where is that paragraph where you are saying that you don't have these documents and you will not be able
Para 8,
to.
my lord.
Para?
8 and 9, both can be seen. Please see para 8 first. May I read?
Yes, yes.
The petitioners respectfully submit that the imposition of additional documentation requirements, particularly the demand for admission records and admission slip of so and so, is without any statutory foundation and is arbitrary. The petitioners already possess their DLED certificates and mark sheets issued by NOS.
All right. You are only saying the same thing. You are saying that it will serve no rational because you already have this. Understood. And para 9, anything more you have said?
Yes, my lord. Please see 9 also.
Such documents were neither mandatory. They shall submit that the service certificate is by the school authorities who were their actual employers should be deemed sufficient. All right.
Please see para 9 now. Likewise, the demand of SMC minutes or attendance.
But you are not saying anywhere that you will not be in a position to give these documents. Where have you said that?
All of them, my lord.
Where have you said that you cannot?
Please.
Which line?
Please see 12, my lord.
12. No, this you are saying that the requirements are disproportionate and such conditions were neither communicated at the stage that whatever you've argued, but you're not saying that you're not in a position to give your prejudice. That you have not said. I was just trying to figure out if there is a averment to that effect, only for that purpose, for whatever worth it may be. I was just trying to find it. Yes,
Please see para 10, Lord. The last 5 lines.
para 10, yes.
In fact, I'll read the entire para 10 if my lord would permit. The petitioners respectfully submit that the insistence on production of UDI's records as proof of having been in service is wholly arbitrary, impractical, and unfair, especially
This is
for...
that UDISC.
Yes, my lord. This is the most important one, in fact. Is wholly arbitrary, impractical, and unfair, especially for those working in private, government-aided, and unaided
So
schools.
this is only talking about UDISC. All right, understood.
Many of the...
There is no response to this averment, the UDISC.
There's none of the governments are...
No, but otherwise specifically to this UDISC, whether that is mandatory or not mandatory, there is nothing.
There is no, to the best of my instructions, my lord, to the best of my knowledge, there is no mandate even till today. In fact, my lord, when this application...
All right. Yes.
And then see 11 also, my lord. The petitioner further submits the demand for salary statements indicating pay band, basic pay, DA, and other allowances equally irrational and discriminatory.
Okay. I did not issue salary slips or paid. All right. So averments are there.
Just
Okay.
one more thing, my lord. Many petitioners were engaged as contractual or part-time teachers in institutions that either did not issue salary slips or paid consolidated amounts without detailed breakups. So where do I understand, my lord, if they have to ask me something for today, that because in 2025 September you are working at a place, please get it.
But if you're a part-time teacher or contractual, then
But there is no law, my lord. There is no law which says that government, private schools have to have all of these things to me. There is no law.
no. But if you are a contractual, whether you would come under that criteria.
Yeah, there are 3 criterias: government, private unaided, private aided.
That is the school.
Yes,
Okay.
whether I'm contractual or not contractual is not a distinguishing factor in that scheme.
Okay.
The only thing is that I should have been in service and within those 3 criteria.
All right.
And then, most importantly, my lord, it is not here. No. Most importantly, my lord, and I'll just sum it up in next 5 minutes, my lord. Before lunch, I will sum it up. My lord, why these 8 documents? Why not 10 more documents? Why not 80 documents? Who will decide that, my lord? The question really is, my lord, we are today
Court
dealing...
will decide or you will decide? Or
No.
it is the state?
My lord, I would go
State
step...
will decide.
My lord, there should be a statutory backing for every action of the state. That is my primary argument. My lord, the MHRD writing to NCT is under the RTA Act. This notification of advertisement fixing the eligibility is under the NCT Act. Why these 8 documents, my lord? Plus, my lord, my difficulty is not that is that these documents are not available with me. It is one of my difficulties not available with me. Another difficulty is I was working in 2017. In 2019, after COVID, most of these schools have shut. Now, where do I reopen those schools from? It is going back in time, my lord.
All right.
And most importantly, as I said, the primary document
UDIS.
is not the experience certificate, my lord.
Primary document?
It's the experience certificate.
It's
The
already there.
experience certificate is not discarded or disregarded by anyone till date.
All right.
And most importantly, my lord, I'm sorry, my lord, at the cost of
It's all
repetition,
right,
it's
it's all right.
important. The Honorable Supreme Court, in multiple cases, my lord, the 3 that I read, my lord, everywhere the verification claim is regard to the eligibility. In services, not my eligibility, my lord. Plus, most importantly, I come back to this point, my lord. See the prejudice that is being caused. I understand if these 8 documents were mandatory for admission. It is like this, my lord, that if I take admission in a school as a student, the school says that we only need 2 documents. Later, to prove my admission, school says, no, give me 10 more documents. Is it possible? Can we go back in time? Specifically, when the court does not say, even for a minute, my lord, assuming that they are right, Supreme Court empowers them. Can they go beyond the scope of the course? Beyond the document that the Supreme Court relies? The Supreme Court relies upon the letters. And most importantly, my lord, All these petitions, because I said with responsibility because I filed these petitions. I am the advocate on record there. All these petitions have only one experience certificate on record, nothing more than that. All of these, including the one where BTR order has been passed. The only proof of in service was the experience certificate. So, assuming for a minute that they are right, can they ask for something over and above which the Supreme Court does not prescribe? The first question really is, does the Supreme Court prescribe?
Noted.
Therefore, my lord, this short written submissions I have made with relying upon some judgments of the Honorable Supreme Court, and we've already given them a copy, my lord. Kindly have, my lord, page 2, convenience table. Just 2-3 things I wanted to show, my lord. Just one more minute and I'll be done. Page 2, my lord, the convenience table. My lord, all these states, my lord, including KVS, Punjab, Uttarakhand, Bihar, Odisha, Telangana, have done it after the Supreme Court order, my lord. And what have they asked for, my lord? Is only the experience certificate from the principal, because that is what was required. If the understanding, my lord, of a state authority is to be seen, if all of them are following one line, my lord, unless there is a statutory backing, my lord, to show, and then this is the entire list.
That experience certificate which you had shown was that 2017, that initial
That I
for
was
training where
I was working
that was that part, isn't
of
it?
the principal. And for every petitioner I put, for 171, it is on record that I was working, which I had given at that time.
No, but that requirement was there, right?
That requirement was there to enroll as a teacher. Let us see that.
Where in the NCT that 24 months thing is there?
Yes, my lord.
That you have not placed. The 24 months requirement?
It's 2 academic years, my lord. I'll show that. Please come. Just 2 things you let us see, my lord, once again. Please see 48 for a minute of the convenience compilation.
Of the compilation. Page
48.
Yes.
Subclause 10, my lord. For
Yes,
teachers,
this you have shown, but this is part of that.
MHRD letter, my lord.
Correct. What I'm asking is,
My lord.
where is it in the NCT? The 24 months. You
My lord.
said,
My lords would kindly come.
where do we find the initial requirement that as per NCT you must have this
My
diploma?
lord, kindly have
Where do we get
45.
that? Page 45.
Yeah, same volume. Unfortunately, the appendix is not, but it is mentioned, my lord. Kindly have 45 for a minute.
Yes.
Kindly have in the table.
What is this document at page
No, this is the
55?
NCT regulations. It starts at page 40.
Page 40.
It 40 it starts, my lord. It's called the NCT regulations, recognition norms and procedure of 2009.
Yeah. 2009, it page 40 says 2014.
Lord, the regulations, it is enacted in 14, but the regulations are of 2009. If you please have
Yes,
the
regulation.
opening lines.
2009. Yes. Then
And then please have page 45.
yes.
Kindly have serial number 9 of the table, the row number 9
Yes, diploma
in elementary education.
program through open and so. Appendix 9.
The appendix 9 unfortunately is not annexed, but I'll get copy of that.
You have a copy of appendix
Wait.
9.
We'll show it.
And just keep it.
I'll just need 5 minutes, my lord, after the lunch. Right? Just 5 minutes post lunch, my lord.
In the appendix 9, the 24 months figures.
It says 18 months. I'll show 24 and 18 both. Then please see.
1 second.
Please see 36 is the answer.
1 second. Yes, Mr. Kalla,
My lord, may I kindly have page 36.
page 36. Yes,
Kindly see short title and commencement 1-1 at page 36 bottom.
yes.
These regulations may be called the National Council for Teachers Education, determination of minimum qualifications for persons to be recruited as education teachers and physical education teachers in pre-primary,
So this
primary.
requirement starts from here
Starts from here.
and
my
then those clarifications.
Yes, and then the
Alright.
relevant is at page 37.
Page 37 also.
Yes, ma'am.
All right, we'll resume after lunch.
Just 10 minutes by clock I'll take.
It's okay. It is you who has been referring to some time constraint. This court has not asked you. You've been referring to the times. Mr. Saikia has also been very patiently sitting since you started. He's not even gotten up once. So I don't know why you are referring to that. You will take 5 more minutes, 10 more minutes. You take your time. We are not asking. We are not stopping you.
Very
But all that this court is saying that don't repeat your point. That makes no sense.
Very well.
Mr. Saikia, after lunch. এই গোটেইটোৱে দি দিয়ক নহ'লে গ'লে কনফিউজনে হৈ থাকে। This is your notes, na?
None. During the lunchtime, my lord, my learned friend apprised me about the situation of schools that was unfortunately going on in this state some years back and how the recognition to some private schools has not been there. My learned friend was apprising me. And I also got what the questions that came from my lord. Therefore, my lord would just have the impugned notification with me for a minute. I'm just trying to restructure my argument so that to match what was flowing from my lord, that are we trying to run away from the verification or do we want to cooperate? So therefore, I'm just trying to restructure so that
All
I
right.
satisfy my lord's conscience that we don't want
Yes.
to run away from anything. Please have page 54 for a minute.
Page 54 of the
Writ petition. The impugned notification.
you carry on, but sometimes we keep thinking as it always the saying goes, the other side that the lawyer's mind never sleeps. It applies this side also. So I'm still confused as regards that from where exactly that 24 and 18 that originated. Apart from the Supreme Court's
I will
decision,
show from the NCT
so
regulation.
that particular there is because you see at the end of the day I'll have to author a judgment, so I need to be sure. So you just have to point that out
Yes,
at
yes, I
some
will show it
point
from
of
the
time.
NCT regulation.
How it originated, from where it started,
Yes, the
that
NCT
part, huh?
Yes, yes, I will satisfy.
So
Don't
I'm
worry.
just letting you know.
Yes, yes, very well. Please don't forget.
Yes.
Now, please have page 54 for a minute. In this page 54, my lords, let's dissect it for convenience of everyone.
Yes.
Point number 3, my lord. Mark sheet through NIOS of the applicant.
Page 54.
54 is the annexure which is impugned in the writ petition.
Point number 3.
This is the notification which has been challenged before my lord
Point
today.
number 3 is 18 months.
Yeah, 18-month DLED certificates and mark sheets through NIOS.
And mark sheet. Yes.
This there is no controversy with, my lord. This can continue as it is. This all of us have. Then let us come to point 2. Let us go backwards that what is the problematic aspect.
Yes.
My lord would see that admission records oblique admission slip of DLED course through NIOS. In practicality, what I've been told is, my lord, I checked with all these teachers, my lord, the aspiring teachers, that when they went for document verification, my lord, despite there being an oblique, the authority concerned is asking for both.
Where is that environment?
Well, it is the document verification has only happened after the writ petition, my lord. If required, I'll file an application.
But
to that.
unless there is an averment to that effect, this court cannot
We will
take.
file an affidavit to that effect. my lord,
Because you
that-
see, your case is not that you have this and you don't have this and that you went and this was not. That is not.
my lord, that has happened.
That is
only
not
after.
correct. So you focus on what is if you want to bring something, then there's no point of going ahead with the hearing, because I am investing the judicial time only to so that, because I understand there is urgency from both sides,
Indeed, my lord.
and I am trying to finish the hearing so that an endeavor can be made to
Indeed.
give the judgment at the earliest.
Indeed, my lord.
So now, if you start relying on or making submissions which are not on record, this court cannot go into all that.
That the answer to that is this, my lord, that if I can be permitted to, because it has happened.
If you want, that is a different thing. But I am making myself once again
I
clear.
understand. my lord.
It is not on record. You have not stated anywhere about this part. So don't make statements which are other. And if you want time to bring that, that is a different aspect. That is your call. That is for you to take a call.
The
Right?
problem is this, my lord, I'll be very candid about it. If my lord could consider whichever day, if that is what is important, my lord, the interim protection needs to be.
No, I am not going to I'm making you very clear that as of now, I don't see any prima facie case. Unless I'm sure that there is a prima facie case, I'm not going. In the event of the matter, the provisional list is already out. So there is no question of giving you any interim right now, because the final list is not going to come out in the next week or
My lord,
so.
They have said so. They have said so by the 10th of October.
That provisional list itself says
My lord, please see the
after the
notification.
provisional list, there's going to be another.
No, I'm sorry. Please see the notification, my lord. Please see the time and date. In the bottom, my lord.
Where's that list
Correct.
gone?
Correct. Pass over one more copy.
I think I have it. You had given in the morning.
Pass on another copy.
It's all right. Just 1 second. Just let me take my copy. I had marked it there. Yes, yes.
Yes.
Yeah.
There's been a article which I'll bring on record, my lord, by the concerned education minister. In the bottom, my lord would see the time and date, 15, 16 and 18.
Anyway, I think you had enough time and we've started with the hearing. We'll finish the hearing.
Oh, very well, my lord. But I'm just trying to dissect this for
If
convenience.
you wanted to bring that, you should have brought it by now.
Very well.
Yes, which page were you in?
I was at page 54, my lord.
Yes.
Point number 2, I'm showing, my lord. Admission records / admission slip of DLED course through NIOS. Now, in the verification, my lord, despite there being an oblique here, as per their own circular, both of them are being asked from me.
There is no averment to that effect, so I'm not taking that that part of your submission. Yes.
My lord, I will just clarify.
That is not there on record. I cannot
I-
take these submissions on
Can I just
record.
put it-
I'll note it, but I will indicate that there is no averment to that effect.
Can I just rephrase this?
Yes.
Whatever is mentioned in the circular should be followed as it is. At least that much my lord would consider.
Yes.
The circular says this or this.
Yes.
And that at ground level is not being followed is by instructions. I understand it's not on record. I will
Yes,
put it.
yes.
That's number 2. Then please see the first part, which has 6 documents. 6 documents.
Yes.
In the first part, my lord, point F, the UDICE record is the most problematic one. Why do I say so, my lord? We'll have to go slightly back in time.
It's all right. You have already said that they have not made it mandatory.
No,
Yes.
there is one more aspect to it. More than the government making it mandatory, because if this UDICE is removed, 80% of my problem is solved. When the registration was being done in the NIOS portal, my lord, I've got those official records. It says that if someone has UDICE, what is the procedure? If someone doesn't have UDICE, what is the procedure? So UDICE at the time of enrollment in NIOS was also not mandatory, something that I'm trying to show. Which is important.
Something.
NIOS at the time of 2017 when enrollment was being done, it had 2 options. If you have a UDICE, then this is the way to fill it. If the school does not have a UDICE, this is the way to fill it. So UDICE in 2017 in terms of NIOS registration was not mandated by them alone. So a school which did not have UDICE in 2017 could still have registered at the NIS portal. The NIS says so. So that is the second leg of the argument, that apart from the state making it mandatory across this in the entire state, the NIOS at that time also did not have UDICE as a mandatory provision for anyone to enroll. That is something that I wanted to show, that in 2017 something which was not mandatory, because UDICE is not something which I can generate. UDICE is something which the government will give to the school.
This circular came on 17 June 25.
25.
And did you file any representation saying that about this UDISE and all that stuff?
There was no representation.
There was no
There was no representation.
And you are seeking a mandamus
I'm seeking a mandamus. I'm seeking
without any demand.
indeed, my lord.
Okay.
Because
I'm just verifying.
no, very well, my lord. We have not filed any representation. Of course, the prayer is mandamus, certiorari, any of them, my lord.
Very well. Yes.
So please have this.
And in the writ petition, which paragraph you have said this thing? Just
What
now
it
that the submission which you made just now about the UDISE,
Please.
that you had taken me in the morning.
Just I stand corrected at 48. I'm not asking for a mandamus. I'm asking for a certiorari. Please see 48, my prayer. That question may be relevant for my lord to adjudicate. Please see 48.
40. Certiorari. What is SMC minute attendance register?
School Management Committee, which is one of the mandatory documents that they have asked for. School Management Committee.
All right. Yes.
Then my lord wanted to see the UDICE. Please come. Para F. Let us please see the ground, my lord, at page 40. E and F. UDICE is F.
F, na?
Yes, because UDICE is a school level data collection system that is managed by administrative authorities and is not within the control or custody of the individual teachers. It was never envisaged as a personalized service record. Moreover, many unaided institutions in 2017 were not even registered under UDICE. The demand for such record is therefore misplaced, particularly when the petitioners have valid experience certificates from the employing institution. And para 10, page 28 also says so, my lord.
Para?
10, page 28. Page 28, para 10.
28.
28.
This I think I've already marked.
Indeed, my lord.
28. Yes, you have already shown
This
me.
has to be read with this one.
So this and that.
Along with this NIO's document, my lord, which is an official record. Excuse me.
Have you given to the other side?
This one, and this one. Okay. The Lord will have on the top NIO's portal for online registration and monitoring of untrained in-service teachers. That is the heading. My Lord would kindly have the first part at in the first page, last part.
The teacher.
Login registration entry by the untrained teacher. And then please have the most important part, which is at page 5. I'm sorry, it's unnumbered. 2.2 is the important part.
Which one?
2.2. There are 2.2.
2 point. Yeah. 2 point.
2. 2 and 2.2.
Yes, not 2.2 here. Oh. Registration.
Registration, login, registration, authentication by principal of the school. First 2.1 is registration by the principal of the school having UDICE code. 2.1. And then 2.2 is important. Registration by the principal of
Without.
school without having UDIs.
Hmm.
And then see 2.4 also, my lord, on the next very page.
Next, which one?
2.4, the very next page.
Yes.
Authentication of the teacher record by the principal of the school. All the data of the teacher registered with this UDIS code or with the same school name or which she is his principal will be displayed in a grid form with authentication button.
Yes.
And then one last thing, my lord. Please have the second page.
Just one
Sorry.
minute, please.
18 months. Okay.
No, just ask Vita, the NCT.
So this UDISC record is maintained by the school authorities,
By the state.
by the state. You correct. Now, what are they asking for you? You are in that impugn.
They are
Let's just turn to that impugn notification once
54.
again.
54. They're asking for the UDIS records, as in the number.
UDIS records. How will you give that?
That's my problem, you know, that how can I give that? Because I don't have to maintain it. I am nowhere involved.
So it because it is something which the school has to
give,
maintain.
And plus, school's registration is not mandatory even till today. We have to check
So whether mandatory, not mandatory,
Yes.
but it is a
something the school
it
has.
is a document, if I have understood, subject to what fails from the other side, that this is perhaps an data entry base where they must be recording the head of the institution must be recording system managed annually by the data must be recorded annually.
This
Correct.
Yes, it is basically like
Huh?
a recognition code, my lord. It's like a recognition code which the state gives to the school, saying that you are within because we'll recognize you by that code.
See, I'm trying to understand. You
Please,
see,
please.
what is required? List of testimonials, documents, paper related to proof of so and so. This is UDISC records.
Please.
Now, this notification doesn't say that you have to follow. Does it say that?
It does, my lord.
Where is it said?
Kindly see. Please see the top two lines, my lord. The applicants who have submitted the first three lines at page 54.
Yes.
The applicants who have submitted their online application with so and so against the so and so are hereby asked
To attend the so and so in due course of time with the following. All right, with the following documents. One photocopy of all documents, so and so. Now, UDISC records.
And
So, what is UDISC records? It will be for the school.
it will be for the school. Plus, it has to be as on 10th August 17. It's not as of today.
I think some more light you have to
On the UDIS, my lord.
on this UDISC.
Can I just read out, my lord?
Yes.
UDIS is really meant for.
From where?
From some of these circulars, my lord. As this,
Yes.
it is common to the country, my lord. UDIS is a comprehensive database and management information system for school education in India, providing data on various aspects of school students and teachers. The system has been updated to UDIS Plus, an online real-time data collection platform that helps in monitoring educational progress, improving data quality, and facilitating better analysis and decision-making for the school education.
You give a print of that, huh?
I will do that.
Yes. Okay. All right. Noted. Next.
Plus UDICE alone is not sufficient. It says that the applicant was in service as on 10th August 17. So today's UDICE is irrelevant.
That
They
time.
say that UDICE should have been done in 2017. But I just showed from that NIS notification, my lord, that UDICE was not mandatory at that time. If it was not mandatory at that time, can it be made mandatory today? And if my lord would just, I will trouble once again, my lord. Please have the first and second page also,
You are saying it was not mandatory that time from this document.
which is the registration.
This is
This
of
is
2017.
this is a 2017, my lord, because
Where is the date?
my lord would kindly have.
Where do I get the date?
Please see process flow of on the first page. Process flow of DLED online registration. The DLED online registration has happened.
Where?
The third line on the first page, my lord. Process flow of the DLED online registration.
Yes.
This has happened only once. There has been no two.
When?
In 2017 to 19. There is only one time course. The course, my lord, was only once. There has been no
Alright.
two courses.
Okay.
So if F alone goes, my lord, if I am able to convince my lord on F alone, 80% of my problem is solved. The second aspect is, my lord, from A, B, C, D, and E. There are 5 documents. Today, the position is, my lord, all these 5 are mandatory. This is like saying that if I have to prove my residence, I should have Aadhaar also, I should have PAN also, I should have driving license also, I should have passport also. The question that I put to myself is, in any government authority that I have to apply, my lord, at best they can say any 2 out of the above, any 3 out of the above, any 4 out of the above. And I'm coming from a place of genuine difficulty, my lord, because I say that most of these schools have closed. I say that on oath, my lord. Most of the schools that I was teaching in have closed. If it was their case that, okay, experience certificate we will not agree with, give us one supporting additional document.
Counsel, your reference to PAN cards and others doesn't fit the context of this particular A to E. These are, you see, I understand the difficulty you're facing. I understand. But otherwise, they are only trying to ensure that the concerned person was in service during that time.
Okay.
How does the state now ascertain this? Obviously, by the appointment letter, by the salary slip, by the minutes of the school managing committee in respect of the appointment, because these are the procedural requirements. Otherwise, it will be an illegal appointment. If the appointment is
Exactly.
legal, then
Exactly.
these A to E must be there. Now, you see, I am not saying anything else.
No, I get your
But
point.
I'm just trying to say that if you see that from the point of a reasonableness, it appears that state is being reasonable.
My lord,
A to E. F for the moment we may keep it on hold, subject to what falls. But otherwise, A to E, how can you say it is being unreasonable when state is asking for these documents? When the
Two
Supreme Court
answers.
decision is saying that
Two answers.
as in service as on such and such date,
Two
this
answers.
appears to be in conformity with the apex court decision.
2 answers, my lord.
Yes.
First answer, my lord. Whether it is reasonable or not, my lord, needs to be tested back in time, not today, my lord. I repeat this because we are in 25 today. I was in service in 17, 8 years back. I am being asked for these documents 8 years later, my lord. Whether the school which has given me this employment, my lord, was it mandatory for them is the first question I put to myself. Unless the state makes it mandatory that private school, whichever teacher you will have from 2010-17, you should have a school management committee, you should have an attendance register, you should have a pay slip. Till such time the state makes it mandatory for the school, how can it come back to me? That is the first question that I put to myself. Number 2, my lord, very, very important. The note that I have given, I have annexed an RTI of the state in that. Please see the RTI reply. The state now is taking a different stand qua the RTI. Please see that RTI at page 18. I have given a note.
Page
18 of the note that I have given, note on arguments.
The note, yes. You have enclosed something in your written argument also.
Just the RTI.
Huh?
Just the RTI.
This is not enclosed. Otherwise in the pleadings.
Not in the pleading. It is after the writ petition.
Mr. Counsel, we don't follow such practice here.
I understand.
Where written arguments don't contain any annexures.
I will put it again to an affidavit if required now. Please see page 18.
Where is the scope of putting things through affidavit when the matter is taken up for hearing? Matter is taken up for hearing with the consent of both sides.
Indeed, my lord. My lord,
Yes.
then the only option will be to discard it.
Exactly. Unless, of course, Mr. Soikia is generous enough not to object to this document
Mr.
on page
The
18.
learned AG was also generous enough last time to say that we will reserve these posts for the petitioners as an interim measure, but I'll not go into that, my lord.
Yes.
Learned AG has been very, very cooperative, no doubt, my lord.
What
Please-
is this document on page 18?
This
Yes,
is
Mr. Soikia,
We
any
have given it to
objection to page 18?
First time I am going to it.
Have a look at it.
My lord, I had given
We
it
can have a look at it together.
4th September.
Yes, yes. What is this 18? Tell me.
4th September, I had given it to them. This is an RTI reply, my lord.
Hmm.
It is to one of the petitioners before the High Court.
Hmm.
Please see, dear applicant, this is 17 July 25. Dear applicant, this has reference to your application dated so and so by this office on dated 23rd June 25, seeking information related to NIOS DLED program for 2017-19 session. The information sought is appended below. On the left side are the questions, my lord. The right side are the answers. Please see the relevant questions. Roman 2 is important. If a school does not have a UDICE code issued by the state government at the time of DLED admission 2017-19 session, then how did the teachers of that school complete the DLED course in 2017-19 session? Kindly be supplied. Please see the answer to information point 2. As per the verification by the concerned authority. So the verification by the concerned authority of a non-UDICE school was done, my lord. That is the state's stand in this RTI. Then please see, my lord.
Yes.
4 is important.
What
Yes.
qualification documents were required for a candidate to get admission in DLED from NIOS 2017-19 session? The answer of information point 4 is on the right side. The qualification to get admission in NIOS DLED program for the session 2017 was senior secondary with minimum 50% marks at the time of registration. Then please see 6, my lord. Very, very important.
Yes.
Did the state government verify the in-service documents? Other documents of each school teachers provided by each school teachers? If so, when was it done? Please see the answer to point 6, which is the second last on the right side, my lord. The documents were checked by the state authority and it was during the registration process. So today, my lord, the question is of re-verification. I would be permitted to reread, my lord. Did the state government verify the in-service documents?
The documents were checked by the state authority and it was during
Registration process. This is of NIOS, my lord. And then he's the last one also, 7. Name and address of every school of Assam that had completed the DLED course by collecting UDICE code from NIOS. The study center list was recommended and the list was provided by the state authority. And just for my satisfaction, my lord, if you could kindly have just one page 12, just for my satisfaction, I wanted to show the KV notification on this reasonableness test, my lord. Page 12, my lord,
of this note.
of this note.
This is also a new document.
This is just a notice, my lord. It's a KVS notice.
No, but these are not annexed.
The KVS notice I will check, my lord.
Mr. Counsel, we generally do not have this practice of looking into documents which are not part of the pleadings. Then what is the use of filing pleadings? You had filed your reply affidavit as well.
I understand.
You should have brought all this on record.
Only brought to my notice at a later stage, but please see for a minute, Lord, just to assist. A reference is made to advertisement so and so for the filling up of post of primary teachers. While judgment dated 28/11/23 passed by the Honorable Supreme Court in the matter of Javeer Singh versus State of Uttarakhand and others, the Honorable Court has held that the candidates having qualification of 18 months DLED from NIOS are not eligible for the post of primary teachers. Accordingly, the offer of appointment to 176.
Those things are not required. 1 and 2. The candidate must bring following documents. This is one you want to show.
Indeed, my lord.
Service certificate of working as primary teacher.
Indeed.
An affidavit on stamp word so and so duly signed by the candidate and authenticated by first class major and so and so.
Indeed.
Yes, this is what the authorities of that particular institution have deemed appropriate and they are doing it.
And,
Yes.
and other states have also done this.
Okay.
So therefore, if we come back to the impugned notification, my lord, at page 54.
So in short, the state has to now do an inquiry and find out which authorities and which states are doing what kind of a verification process, what are the documents, and accordingly follow. Is that what you're trying to say? Then
my argument is this, my lord, to check the reasonableness, because
that's all right. I have understood.
what I'm trying.
But relying on that will not take you here and there.
It may just-
Ultimately,
it may just
it
assist
is
that how are different authorities interpreting.
yes.
Plus, my lord, I come back to this
Because you see, at the end of the day, it is the administrative decision which is being tested by this writ court.
Indeed, my
The
lord.
decision itself cannot be set aside unless and until the decision making process or unless and until this court finds that there is arbitrariness, right? Now this has to be seen. These are
Please test it in this manner, my lord.
correct. The touchstone
There
of reasonableness, arbitrariness, fairness. This is what has to be seen.
Yes.
Now, on the face of it, it appears that this is. I'm also now repeating. Let me not repeat it.
No, well, I
But
understood that. I have not been able to conclude, my
it
lord.
is in terms of the decision of the apex court. Now, what you're trying to impress is that it is too onerous.
My
And
lord,
that is why it is not reasonable. But then there are no affirmance that they are doing this to intentionally deprive you. They want to benefit someone else. Their interest is to get the best teachers.
okay.
This is why they are ensuring that they are qualified, and plus they don't want anyone who has been illegally appointed at some stage also to get the benefit. They have also said that in their affidavit, misuse and all that. Now, they may not have given instances here, but the state has taken a conscious decision. This court doesn't find anything, and you see, to that, because as far as UDISC is concerned, all right, you have demonstrated it before this court. That it appears that that is impossible because you cannot have that record. This is how you have demonstrated right now. Now, I'm waiting to see what comes from the other side. But so far you have demonstrated that this record, how will you give it? It is not in your hands. That is okay. But A to E.
Even B, my lord.
Hmm?
Even B.
B.
PCB.
B.
Minutes of the school management committee. I'm not a part of the school management committee.
Okay.
UDICE is at a better footing for me to target for this reason that, of course, it is not something to do with me. Plus, it is not mandatory. It is like saying, my lord, just an analogy being drawn that for income tax return, if you don't have an Aadhaar card, you can't file an income tax return. First, the government has to make it mandatory for attaching it with a PAN card only. Then can I file my income tax return?
Noted. You will have a right to reply also. Yes.
And please see 46 also, my lord. I have taken this as a specific ground. Page 46, my lord.
Yes.
Ground X. I say that the effect of the impugned condition is to reopen settled issues. That is what my main concern is. My lord put me this question that how is it unfair to you? I say this with responsibility that KVS notification that I just showed. The people who have been selected are also there. It is annexed in that. My lord may not take it on record because in the written submission. They are candidates.
No, written submission annexes.
No, my lord, I am
taken
fairly,
on record in that manner.
I am fairly saying so, my lord.
There is some procedure. We must follow that. Yes. Yes. Anyway, that doesn't change anything. Yeah, that
It
submission I have taken note of you.
But what
Yes.
happens is, in that list, there are some candidates from the state of Assam. Now, that candidate, because he was asked for a document which was required at the time of 17, has been given appointment. But the same resident from Assam, my lord, because these extra documents are being asked for, will not be given. And I go a step ahead. My lord, if a person was not in service for a minute, all this would sound good, my lord, if the verification was not cast upon the state in 17. Is the
Just
state
because state of Madhya Pradesh has certain parameters and criteria, and some resident of Assam goes and apply there, whereas for that same kind of similar post, his state of Assam has something else. Now the rest of the residents cannot complain. Look, that he's got there, we can't get it here because of this. That can't be.
that will apply if it was a state specific recruitment. Here the NCT, the MHRD, the NIOS is a country uniform scheme. That is very, very important. The rules that have been framed for A state is same for B state. It's not different. I understand, my lord, if it is a recruitment which is state oriented. Here, it is not a state oriented recruitment. Why do I say so? The eligibility is decided by NCT. It's not decided by the state. State is simpliciter implementing the NCT regulation.
That those eligibilities are met with.
Indeed, the state has no power to decide the eligibility. I can show that. The RTE Act appoints NCT as the nodal agency. And that 2 year will come in that
All right,
notification.
noted.
Plus, my lord, that 2 year I am directly showing. Please see that 2 year because that is something that was troubling my lord since the beginning.
Where,
Please see
where?
that. Please come to the second convenience compilation, my lord.
Yes.
Kindly have page 24.
Yes.
My lord would see this is a notification by NCT at 24. I'm on the convenience compilation. My lord, see the opening lines. In exercise of the powers conferred by subsection 1 of 23 of the right to RTE
1st
Act,
March 2010.
issued by so and so, the national NCT hereby lays down the minimum qualifications for a person to be eligible for appointment as a teacher in class 1 to 8 in a school referred to in so and so. And
Yes.
then please see minimum qualifications.
Yes.
Class 1 to 5 is senior secondary from so and so, and that is very, very important.
2-year diploma.
Diploma in elementary education from whatever name.
Yes.
And then please see senior secondary or so and so 2-year diploma by whatever name in accordance with NCT regulations 2022.
Yes.
So this is where 2-year comes from.
Yes. Hmm?
And then please see,
Hmm.
this is the same thing as I was showing, my lord.
Hmm.
Thereafter, my lord may kindly see. $28.1. That I have shown. I'm sorry. Yes. So this is where the notification prescribes the 2-year format, my lord. And then please have the last thing before I conclude, my lord. At page 37. This is that, so we were reading this before lunch, my lord. This 36, the notification started. From the notification, the regulations come at page 36.
Yes.
And then 37, my lord,
Yes.
is the minimum academic and professional qualifications.
Where? At page 37, no?
At page 37, my lord, in the table,
First schedule.
first schedule, my lord.
Okay. Okay.
Row number 3 is important.
Yes.
Minimum qualification as laid down by NCT, while its notification dated 23/8/10. 23/8/10 was the one we read just before this.
Yes.
I'm reading row number 3.
Yes.
So here is what the qualification is laid down, which is followed in the advertisement, the current advertisement.
Yes. Yes.
And then one last thing, my lord, that as I said that prior to this also we have been recruited. It is not as if they are recruiting us for the first time. See what was asked for in the previous document verification for a different recruitment by the same state. Please see 638.
That was prior to the apex court decision.
Prior to the apex court decision.
Not required.
The reason is, very well, I'll leave it there, my lord. Then
Anyway, you tell me. I will not stop you.
6:30. No, my lord, I'll stop myself. I understand what is putting, my lord. I think that is more important. So therefore, my lord, the sum and substance of my argument is this, my lord.
18 months.
Where is that 18 months?
Page number 58.
58. Yes.
So
Where in 58?
My lord, this is the approval that was given to the course, my lord.
That this is that from the compilation.
This is from the compilation.
Diploma. There is some okay. This is the MHRD.
Had entrusted the task of conducting DLED ODL to NIOS for approximately 10 lakh untrained teachers recruited till 10th August 17. Mr. So-and-so NIOS made a detailed presentation on the NIOS proposal on so-and-so. The objectives of the program, eligibility criteria, operational plan, curriculum structure, roles and responsibilities of the project managers at different levels, monitoring.
Para 1.
Please. The NCT regulations, qualification and elementary school teachers 2010 developed as per the mandate of RT Act stipulated that all untrained teachers in so-and-so. The NCT regulation prescribed 2 years teaching experience as one of the eligibility qualifications for admission to so-and-so. The MHRD has issued a memorandum dated so-and-so to grant.
This is where that 10 August 2017 originates. The junior is right. Yes, page 58. To enroll for the program and complete the training within 18 months. What is that? What is this word? 18 months?
Subsume, my lord.
6 months internship in compliance with the GOI direction under section 29 of so-and-so. Okay.
This is recorded in the recognition order which I had shown, my lord.
So this is the first document from, I think, bringing this date, 10th August, and then those are following this, right?
Indeed.
Isn't it?
Indeed.
Okay.
This is the recommendation made and then everything follows this.
Very well.
The last part of my submission, my lord, nothing looking into this.
No reiteration.
No reaction.
You will have a right to reply. Otherwise, I'm not giving you the right to reply.
So can I take 1 minute now?
Yes, yes.
My lord, I made that example of Aadhaar, PAN, etc. to prove my residence to see what will be the consequence. If a government opportunity, my lord, says that unless you have Aadhaar, PAN, driving license, voter ID card, if you don't give me all 6 of them, I won't consider you as a residence. The effect is important, my lord. Here what they are saying is that if you don't give me these 5 documents, forget my verification, forget whatever was done previously, I will not consider you eligible to participate. They are ousting me on this ground, my lord. And what is, my lord, in all fairness, I should say, my lord, what about the schools which have closed? For them to get into this, my lord, that these 6 documents are required, they need to first show that as a private school in 2017, these 6 documents were mandatory. Today we are rolling back the clock, my lord. If something is asked from me today, I understand that yes, I can go and get it. I have no problem. But 8 years later, my lord, reopening something which as per their own RTI reply, they say that we have verified. So, my lord, at best, if they want a supporting document, which they have a right to verify, so be it. And my lord put this very pertinent question to me. They want the best. On merit, I am much above. There's a cutoff that has come in the provisional list. That comes to my aid, my lord. On merit, I am much above than the people they are selecting. If it is about meritorious teachers, my lord, because this is about verification. This is not about eligibility. Eligibility, I am right. It is not, I repeat, it's not about eligibility, it's about verification. On merit, I am higher. It is not my case that leave others and take me. I say take the best 5,500, no problem. But the result of this notification, all put together, is that even though I am higher on merit, even though I was verified by them in 2017, even though I have the documents which were required in 17, but because the time has passed because of COVID, I don't have these documents that they now have first time made it mandatory. I will lose the job. What is the consequence? I will lose the job. So therefore, I come back to this, my lord. I am not testing their fairness. That is very, very important. I am not on the fairness. I am on the impossibility. I am on rolling back the clock 8 years later. And I make this concession, my lord, with instructions. Even out of this experience, they say no, we don't trust the experience. We don't whatever verification we have done. We don't trust that. Apart from the experience, give me one of those documents to prove that yes, you were there. I have no problem. I have no problem. The question really is, how do I get those 5 documents? Some may have 4, some may have 3, some may have 2, some may have none. 0. And plus, it is coming as a surprise today. So therefore, in my written submissions, my lord, at least judgments, my lord would permit me, I have highlighted the doctrine of legitimate expectation. From 2017 till 16th June 25, I had a doctrine of legitimate expectation that I'll be considered. Because I was never told till 16 June 25. And plus, my lord, what stopped? Because maybe I can assist my lord on this point, that what was there before the Honorable Supreme Court, because all these matters I've dealt with, my lord. If it was so that these documents had to be referred to, the Honorable Supreme Court would have said that please verify the in-service status. Therefore, I was trying to draw a distinction. They say you verify the eligibility, which I have no problem. Please verify my eligibility. In the reply of 30th June order, my lord, see the order passed by this Honorable Court. In that
Yes. Rupak. Pani ji diba.
Thank you. So nice.
Pani diba.
In the
Yes.
30th June order, my lord, please have that interim order that has been passed by my lords.
Which
30th June, the first order, my lord.
in the writ petition?
In the writ petition, my lord, the first order. Thank you. So nice of you. th June order. Para 7 may be seen, my lord, which is at page 32. The relevant part.
Yes.
Mr. So-and-so, learned counsel for the petitioner, submitted that all the petitioner are the in-service teachers who obtained their 18-month diploma in elementary education through open and distance learning from National Institute of Open Schooling and have been serving since 10/8/17. He further submitted that at the present the matter has arisen out of advertisement so-and-so, where the respondent 1 and 2 invited applications to fill 5,500 vacancies for assistant teachers in lower primary schools.
Yes.
However, on 2nd January 24, the respondent authorities arbitrarily issued a disqualifying notice excluding candidates with 18 months diploma in elementary education from NIOS, wrongly interpreting the judgment of Honorable Supreme Court and so-and-so. Despite the fact that the such judgment pertains only to fresh candidates and had no bearing in-service teachers enrolled through state-facilitated mechanism.
Is that your submissions?
But please see the finding. I wanted to show the entire picture. No?
Yes, I have seen. It says that time the verification was not done in para 11.
Please see
Upon
para 10
consideration and submissions made by, but these are just submissions recorded.
Just see
You
para
have submitted elaborately before this court.
Just see para 10, my lord.
Yes.
Mr. So-and-so, this is for the state,
Yes.
submitted that the Honorable Supreme Court in case of Kaushik Das has held in para 40 of the judgment that respondent authority shall consider the candidature of the applicants who are found eligible after verification of their candidature. I showed in that Kaushik Das, the eligibility could have been tested. My in-service is not eligibility, please.
All right. We are hearing. We will.
So therefore, my lord, I
yes.
humbly pray, my lord, that at least the notification may be set aside in part, if not full. UDICE and any 1, 2, my lord, whatever, my lord, we are not running away from anything. But making all 5 mandatory is coming as a surprise after 8 years, my lord.
UDIS and then SMC.
Yeah, UDIS and SMC, even if that goes, my lord, we are
UDISC and
SMC, my lord, that's school management,
school
committee,
management
which I have nothing to do with, my lord.
Okay.
I'm so grateful, my lord.
Yes, Mr. Saikya.
Before I start my submission, I just want to give 2 figures, which I have just obtained. Total number of NIOS who had applied.
Total number of NIOS.
NIS DLE degree 18 months. Total application came 7,852.
7,852.
52.
Yes.
Out of which, on the basis of marks and all, we have called for physical verification of documents. Total number of candidates who were called is 1715.
1715.
15.
Yes.
Total physical verification and verification as per notice done, it was total 1405.
Yes.
All criteria of the notice were fulfilled by 384,
Yes.
and out of which in the first provisional list
247.
247 have cleared the cutoff marks.
And these petitioners, they didn't even given
Uh,
anything.
No, because their petition is based on apprehension. If
No,
not-
but they have not given any of the
I do not
documents.
know, because maybe some of them have got it also. It is very difficult for us to find.
Mr.
out.
Karla, any of the petitioners have given the documents? Did they participate or what?
Because they have participated, but these documents, all of them, they have not given. Some, whatever document was available, they have given.
They have given.
Yes.
And none of them is in the list,
Some of them are in the list,
in the provisional list.
but withheld. The
Who are those? I think that should be also clarified, isn't it?
Each individual has their own separate cause of action. So they cannot club all 173 into one writ petition.
This is how many? One?
It's 171.
one
So
And after
171 have
171?
different stories to tell before this honorable court. They do not have a common factual background. So amalgamation of various causes of action itself makes the writ petition non-maintainable. On that ground, that is my first submission.
they will not be met in the con.
I have gone through their certificates, and one certificate which they have relied
Yes.
today during the course of adjudication, page 68.
Yes.
This
That-
particular
The
certificate,
certificate which does not have a date.
no, yes,
That certificate.
like Cristo Jyoti High School,
60?
page 68. Cristo Jyoti High School, Boka Khat, Lordship. That is a school you always see while going through that highway. Here,
Yes.
the school has the UDICE code also.
Where do I get that?
The last line of the certificate, school UDICE number,
Yes.
so 11 digit.
So it has.
It has. That is why everybody has a different story to tell.
No, but tell me one thing, Mr. Saika. The UDI.
I'll go to that.
The record.
That
What is that UDI's record?
this is a pan-India program. I'll give one notification.
No, because I just simply
Yeah,
want
that-
to
that- that is
understand
it. Earlier for-
whether an applicant can give this record or not.
No, the school authority.
The school has to
School
give,
authority.
right?
We have a separate unit in SSA, Service Shiksha Abhijan's office, Lordship, for
Hmm.
UDICE recording. And
Okay.
this is done as per the central government's notification. It is a pan-India exercise. Earlier to UDICE in 2012, we have a DICE code, DISC,
Hmm.
district-wise, this same code.
So this
Because of the
document.
elementary and secondary, there are two different systems. Therefore, it has been combined as UDICE.
Now this I let me be
Very clear, Lord. Yes, sir.
yes, let me be let me clarify this, because that impugned circular says the applicant must provide the following documents, right?
Yes.
And one of the document, I think G, right?
Yes.
F or G.
The UDICE code, because
is
here
UDICE
this
records.
certificate itself has the UDICE code.
Which certificate? It says UDI's records.
UDICE record as a proof of the applicant.
Now,
if
my
we-
question to you
Yes, Lord.
is whether the applicant can give this record, because he will not have it. It is either the school authorities will have it.
Absolutely, Lord.
Correct.
I fully, because we have to correlate, we have to collate here. When the school, that 11-digit number is given, if we click the portal, we'll get details of all the teachers, all the students, the subjects in that particular school, all particulars, including pupil teachers ratio. Because if this, Lordship is pleased to look at this, may I read it?
This one?
Yes.
Yes.
This is of 18 September 2012.
12, yes.
The school education statistics is presently being collected separately through DICE and SEMIS for elementary and secondary sector. To avoid duplicity of efforts, the ministry has decided to merge these two systems from the year 2012-13 towards UDICE, through UDICE. This would ensure that one school fill up only one data capture format and data is entered into a single software. The implementation of UDICE would entail taking following steps at state district level. So this is a central government notification, and it is for the purpose of formulating the educational policy throughout the India, pan-India, Lordship. this exercise was done. Earlier it was dice and the semis. For secondary semis and for the elementary school, it is dice. So it is nothing new in 2007 or 2025. This is the system which we have to follow, like a law school. They have to have a registration with the Bar Council of India. Identically for any other institutions. For suppose a college, they have to be affiliated to a particular university. So a school without a UDICE or without a DICE code is something fishy. And Lordship knows the background in Assam. If we look at all those venture schools, one family, three brothers have three schools in the same campus. And when they went for this provincialization, all these things came up. So we have a different system in Assam. So my submission is that from this certificate, UDICE is nothing alien. It is nothing very surprising. We are not asking anything from the space. Whatever is there, the certificate which they have annexed in their writ petition itself. What their submission? That all these schools were closed after COVID. This is their submission. And if you look at the certificate, most of the certificates says that they are still dead, they are serving. Till then, I'm taking their writ petition. My whole argument will be based on their writ petition, rather than taking my affidavit. Now, Lordship will kindly come to paragraph. How they are trying to mislead this honorable court. They are playing fraud with this honorable court in my humble submission. And I will prove it from their documents. Page 23. Paragraph 2. So when the fraud is going to be unearthed, all this that we do not have statutory power, we don't need a statutory power. The Constitution of India, Article 162 gives us that power. I'll go to every detail.
Page 23.
Page 23, paragraph 2.
Yes.
That the petitioners beg to state that they are working as teachers in private, government aided and unaided schools in the state of Assam. So they belong to not only private, they belong to government schools, aided schools and unaided schools.
Yes.
And now their application form, which they have applied, page 63. When they have filled up the application for their recruitment, page 62, 63.
Yes.
This is the application form in the portal for this job. They have submitted that category, lower primary, etc. First page, page 60. Now, Lordship will kindly come to page 63. Here, experience details. Lordship will see in the middle part.
Yes.
Are you working as a teacher? No. So how they are giving two different versions before this honorable court. In paragraph 2, they are saying that they are working, and the applications which they have submitted before the elementary department, they said, oh, we are not working. And the certificate says they are working from 2007, 10th August till date. Three is different stories, three different facts. So this is a serious offense. Lordship may be pleased to direct the registry to lodge a case against all these writ petitioners.
This are you working as
As a
teacher?
teacher?
As a
And
no.
the reply is no.
No. This is what? No.
Yes.
Yes.
So what more is required, Lordship? They are giving three versions before this honorable court, and they have dared it. And my learned friend was saying, on oath, they are stating everything.
And
we have to believe everything.
I was under the impression that all these petitioners are working in a private school, because that is the kind of an argument is coming. But your paragraph 2 indicates that they are private companies.
The word
Anyway.
before this honorable court, they are misleading this honorable court. I should not use that word before.
And there is this
Misguided.
averment
Misleading.
bifurcating which petitioner is working in a private. Those averments are not there, no, Mr. Finger? That is why you said clubbing,
Clubbing
of
is
course.
not permissible. Amalgamation of separate causes of action is not permissible. They
Yes.
have amalgamated, mixed up. It's a
Hmm.
mixer. The writ petition is not maintainable in that form, Lordship. I have a different story, my cause of action, because I do not have a UDICE school. I do not have an appointment order. Can anybody believe, Lordship? In this today's world, for last 30 years, 40 years, a person will score. In the 90s, we heard that honorary school teachers, no salary, but I am serving. No appointment order, I am attending the school as a part of my social duty, social service. That thing is not happening with the present generation. These are all young generation students. So those things, those stories will not convince any court or any judicial scrutiny process. So 3 different stories I have just identified. And everything is on oath. So if page 63 is correct, paragraph 2 is wrong. If their submission, the council's firm submission is that there is no UDICE code, the certificate which he relied has a UDICE code.
So he was, if I'm not,
He was
if
for
I'm
a
correct-
different context, he said.
Yes, he said that the UDI's record is since are maintained by the school. So how will he get hold of that
He don't have to.
certificate?
The school will give. If
No.
I go to my school, kindly give me the UDICE code. Will the school not give it? The certificate, why does this gentleman, this principal, Father Anil Kumar Lakra, why Father Anil Kumar Lakra was that UDICE code was asked for? No. Father was asked for to give a experience certificate. In the experience certificate, he himself said UDICE code. Why?
Where is that? Where is that?
Page 68.
That is an experience certificate, page 68.
It says experience certificate. And my learned friend was very strongly submitting that all these schools were closed after COVID. And this certificate was issued when? 23rd of June 2025. And this school is all along standing. I can give personal submission because this is right on the
And this is one experience. Are all the experience certificates on record or only one?
Now, there are different certificates. Lordship will find not all have the UDICE code. Lordship may kindly come to page
No,
128.
but I understand you're saying that even 2021, the principal can give this experience certificate. Why not the others?
Yes, now page 128. Page 128, how this certificate is fraud, I'm telling. Lordship.
128.
I have indicated all this. I have all gone through every page. This
Yes.
certificate issued on 6th of March 2025 by Pradhana Acharya of Sankardev Sisu Niketam Abhayapuri, and where he has said he has joined the school on 26 August 2014 and till serving school and is still serving. That means till this date, till March 2025. If this is correct, then his application form where he has said, are you working as a teacher? No, that is wrong.
That is by this person only. Huh?
All the applications have the same no.
No.
All that. There is one common factor.
That just give me that page number once again. I'll just put the page here,
Lord.
page number where that no was. Just
No.
give me the page number.
Yes, Lordship. I'll just 1 second. Lordship.
Page application, no?
Yes, page I have noted. Page 62, 63.
63.
63.
No figures at
Yes.
page 63, right?
Yes. Then Lordship may take any other application. Page
Okay.
70, another one.
No.
Another one. No. Then Lordship may go to page 75. Another no. Or
Sir.
no.
Miss Barwa, just try and find out Rakesh Ranjan Paul's application while we are hearing this. Just try and find out if
Yes.
you can. Yes, Mr. Saikia, you may continue.
Another certificate, page 83. Here also an assistant teacher and till now he is working.
No, I've understood this.
So it's a general pattern.
Hmm.
A cost may be imposed on the petitioners here.
Hmm.
And because of that interim order, we have got delayed. And we did not play foul with this honorable court. Yes, day before yesterday, I was also terribly ill. I came because all these students,
Anyway, that's okay, Mr. Saikia.
for the interest of the state, we do not want to delay this whole process. And today also I'm not well.
Your reasons for
Yes.
that I think is there in that affidavit which already has been read out, correct? Those are the reasons for incorporating these conditions, isn't it?
No, Lordship. Oh, which conditions, Lordship?
The documents that you are now asking.
No,
the
that
impugn
is, that
circular.
is in terms of the Supreme Court's
Correct.
direction.
Exactly. So,
At last, they have shown that particular paragraph, 623 or that. There's a specific direction of the Honorable Supreme
no,
Court.
what I'm saying is that your explanation to that is in your affidavit in opposition, that those paragraphs, isn't it? You have explained in your affidavit in opposition
Yes,
that
yes.
this is in terms of the Supreme Court
Yes,
directive.
page 624.
Yes, that's
There
what
are
I'm
two-
asking.
Yes, page Lordship will kindly come to page 623 of the writ petition also.
620,
23.
623, I think is your affidavit.
No, of the writ petition.
Read
My whole case will be on their writ petition.
623. Yes.
Here, Lordship will kindly see paragraph Roman 5. We therefore pass the following orders. I am coming to 5. We clarify that such of the teachers who are in employment as on 10th August 2017 and who have completed 18 months DLED program through NIOS before 1st April 2019, Lordship will also mark this date. There is a reason why this particular date is there for completion of the 18 months DLED by 1st of April 2019. I'll give that background also. Shall be considered as valid diploma holders for the purpose of applying in other institutions and for promotional avenues. Next page, we direct that the respondent authorities to consider the candidature of such of the applicants who are in service as on 10th August 2017 and who on verification, we cannot do verification in the air. There should be some subjective or objective parameters are found to satisfy the eligibility criteria shall be appointed within a period of 3 months from today. So there is a specific direction from the central government, from the Honorable Supreme Court, that we have to verify whether these particular batches of 18 months diploma holders were actually working on 10th of August 2017 or not. A duty cast upon us. If we do not do it, it will be in violation of this order. It will be in conflict of this order. This experience certificate, Lordship, is like experience certificate of non-existent school, because their own contention is that these schools are no more in existence after COVID.
Then how did the principal
in March, in
still
June,
working?
in June, and this school is not in existence. It is in existence. That Bukakhat school. It's a very famous school, Lordship. So some principal must have given some certificate at the time of registration. I do not know. I do not want to make a comment on that. But something fishy had taken place. A school of that category, Lordship, will not allow anybody to work in that school without an appointment order or without salary. And what they're saying, we are getting 3,000 rupees, 2,000 rupees in cash today. From which school? From Christo Jyoti or some other school, or some unnamed schools. So they have to be clear. And it is not a case that all of a sudden the state government has done it. In West Bengal, large scale fraud had taken place already in the domain, in public domain. Large scale, this kind of persons who took benefit of that special relaxation. What is this special relaxation? 2010, I'm not taking the same documents once more. I have, in fact, marked all these documents in my book also. In 2010, under section 23(2), the notification was issued by NCT on the basis of the RTE Act of 2009, laying down the detailed qualifications or eligibility criteria, which Lordship will find at page 24.
Page 24.
24. Let me go chronologically.
Yes, yes. Of the writ petition?
No, of the I'm
That
grateful to the
compilation.
other side,
Compilation.
convenience compilation.
Yes.
In fact, otherwise I was asking my, in fact, every time I was helped by my Lord Justice Rajesh Majumdar. He is a big help to us. After shifting his side, we are a little bit handicapped now. Just like the COVID affected schools on a lighter vein. So on 23rd August 2010, This particular
Sorry,
page
page.
24 of the compilation.
Yes.
Here, these are the eligibility criteria in exercise of the power conferred by subsection 1 of section 23 of the RT Act to free and so education, and in pursuance of the notification of 31st March 2010 issued by the Department of Schools and Literacy, so and so, the National Council of Teachers Education hereby lays down the following minimum qualification for a person to be eligible for appointment as teacher in from class 1 to class 8 in a school referred in clause so and so. So here the qualifications are given. Everywhere Lordship will see there is first is that senior secondary with 45% and 4 years B.Ed degree, or secondary education with 50% and 4 years B.Ed degree, first page. Next page also Lordship will see, or senior secondary with 50% and 2 years diploma in elementary education. That is the 2 years course. So everywhere either 4 years B.Ed or 2 years DLED course is required. Thereafter, what happened, Lordship? All these schools, this 2000, 2009, no, I have my own. I am deeply obliged. So 2009, when RT Act came, all these new parameters came regarding the qualification of the teachers. These schools were in existence prior to 2009. In those schools, and we have the state regulations also from 1977. There was no prescription of B.Ed. So a lot of teachers were enrolled, or it's not enrolled, were engaged or appointed who did not have this professional qualification. This is the professional qualification.
Have your what?
This is the professional, not the educational qualification. So after RT came into force in 2009, and this notification of 23rd August 2010, the central government found out that in most of the schools throughout the country did not have this professional qualification of the teachers who were teaching the tiny tots. That means the first stage of the students. 2015, they made a notification that also is here. 2015.
This 24 is 2010.
Yeah, 2014.
The 2000 not
page 36.
Page 24 is 2010.
Yes. Then there is a.
Then comes 2014.
Then people kindly come to page 36.
Yes.
This 12th November 2014 also stipulates the same thing.
Yes.
If Lordship will see page 37.
Yes.
Primary and upper school minimum qualification as laid down by the NCTE by notification dated 23/8/2000, which I have just placed, as amended from time to time in exercise of the power under so and so for free and education. So this notification they have relied upon. So that same requirement was there. Thereafter, they have sent it to their board. And that ODL board, that notification Lordship will find, no, that is not a notification. That is a communication at page 47, 3rd August 2017.
Yes.
This is a.
This is what? This is the communication.
Yes, communication. It is apprised that the amendment to the section 23(2) of the RT Act to extend the period of such training to 31st March 2019 has been passed by the Parliament. A particular document, Lordship, that amendment, what the other day I saw it, somewhere it is there, that the last date of acquiring that qualification was fixed as 31st March 2019. All these were recorded by the Supreme Court in their judgments also. I'll take this honorable court to that. Further, it is reiterated that this will be the last chance to acquire the requisite qualification, professional qualification. Any teacher in the aforementioned schools who does not have the minimum qualification mandated under the RT Act would not be allowed to continue in service beyond 1st April 2019, and the procedure for dismissal shall be initiated against such teachers. Then what is the subsequent action to be taken by the state and union territories? State and union territories will be responsible for ensuring that all in-service untrained teachers. Government and private schools in the state and union territory acquire the minimum qualification required under the RT Act 2019 within the proposed extended period of 31st March 2019 through the ODL system of NIOS. So, why it has been done? There was acute shortage of institutions who provide B.Ed or DLED courses. In Assam also that shortfall is there. In other states also. Even if a teacher wants to go for and obtain this degree or diploma, the institutions are not available. In that situation, the central government, this is of the Ministry of Human Resource and Development, MHRD. So they found out this option that through ODL system NIOS, this can be done. And what is the date here, Lordship? 3rd August 2017.
Yes.
Lordship, you kindly mark this. 3rd August 2017, a decision was taken that through ODL it will be done. And
Yes.
the last date of completion is for 31st March 2019. By that time, all the untrained teachers must acquire this degree,
Must be
otherwise they
trained.
will lose their job.
Yes.
Therefore, the government in their wisdom, next page, Lordship will kindly now come. It is mandatory for all in-service untrained teachers to undertake DLAD program through ODL and through on NIOS unless already enrolled and undergoing training in a recognized teachers educational institute prior to the amendment. The state will reach out to school principals, concerned school authorities of all government-aided, private, and inform them about the extension of the deadlines and publish large-scale advertisement for wider coverage. State must undertake the awareness programs amongst the teachers also, clearly indicating that this would be the last opportunity for application and enrollment of the courses, failing which their service will be terminated with effect from 1st April 2019, and also advertise to the last opportunity on a large scale. All states should prepare a database of such teachers in their state. For creation of database of untrained elementary teachers for DLA, there will be an online portal of NIS which will be the following option: login registration by the state coordinator, login registration by the individual principal of the school. The state coordinator will enter the entire database of untrained in-service teachers on private and government schools on the portal, especially prepared by NIOS for this purpose. The portal will also be utilized to monitor the progress of training in the institution. Up to here, let me pause here for a moment. A particular coordinator has been given that responsibility or the principal of a school. So who can come? If I am a teacher, I can come, I can approach and give my details. This is my thing. Is there, the other side said that a verification had taken place, whether the duty cast upon this notification, because he was relying upon this, whether the coordinator or the individual principal is entrusted with the duty to verify whatever particular is given to him. He should verify, then only he will have to enroll. A portal is ready. This course starts sometime around 16th of August 2017. The date on which the person should be working was 10th of August. By 13th or 14th, the last date of registration was over. And the decision was taken on 3rd of August. So 3rd of August, 10th of August is the cutoff date. On that day, he have to be working. By 13th or 14th, I have all those documents also. Today, I am not placing, and this is not required also. From here, it is very clear. And from immediately after the independence, the course starts so that it can be completed by 31st of March 2019. Whether, and one letter shows how many persons have, these are enrollment or registration. There is no stage of verification. Just 1 second, Lordship, that document.
No, even Mr. Saikya,
Lordship.
whether these petitioners
Yes.
their cases was verified, not verified. That is also we don't know.
Absolutely. Lordship will kindly come to page 69. This is a letter from Anita Kanwal, Additional Secretary, MHRD, to the different state secretaries.
Yes.
First line, as you are aware, 12,91,880 in-service elementary teachers have registered and made payment on the NIS portal as on 30 September 2017. So everybody who comes, they got the registration.
And then the verification starts.
No verification.
No verification.
No verification. It was on good faith.
And what about these petitioners? They have the registrations.
They must have done, but they must have fooled that particular person. Either the school authorities are hand in glove with them, they may not be working there, but still the principal was convinced to register them. That is the thing.
Once again, at page 48, that
Yes.
state coordinator, no?
State coordinator will prepare the database. So whoever brings a slip that Devajit Saikya wants to get enrolled for this 18 months DLS, and this is my fees, kindly enroll, and I belong to this school. He will note everything and he will put it in the portal. It is not his duty that he will go to that particular school and verify. And that is not indicated in this SOP sort of communication. It is not feasible.
And this
Within that 2 days, 3
and
days
the
time.
10 says for teacher in private schools, a certificate from the principal would be taken to ensure
And
that.
this is very important. This I am going next point, Lordship.
Yes.
For teachers in private schools, certificate from the principal would be taken to ensure that the teacher is serving in the school. These certificates will be collected by the state union territory. So certificates are coming from all corners. Now,
And
when
then-
we say that to substantiate that certificate, you must produce these documents. Now, we are not disbelieving. My learned friend was correct. We are not objecting to this
Experience
experience
certificate.
certificate. But to get that experience certificate in March or June 2025, you must have a background. You must have a history. You must have a legacy. What is that legacy?
You're only verifying that.
We are only verifying that. So the school must be in existence. Non-existent school will not allow any teachers to teach, and there will be no students also. So this has made it very clear that no role was entrusted to the state coordinator to verify each and every person's about the credentials of the applicants. The credentials were not required to be verified by him. Whatever credentials they are creating, on good faith, he accepted it and placed it on the portal for registration. It was not physically possible also in 2 days' time. He will either enroll, and for the whole state, how many person? One person, one state coordinator. He will have to do it in Dhemaji also. He will have to do it Dhubri also.
And 12 lakhs?
That is
90,
pan
huh?
India. That is pan India.
Oh, this is pan-
Suppose let us see in Assam also there are about 50,000. Let us assume, or let us 20,000 also. Let us 10,000. Let us assume that 10,000 in Assam. Is it possible within that 2-3 days time? And that duty is not casted upon him. If this SOP sort of communication is there, Lordship, then one more paragraph would be there, that the coordinator, state coordinator will not enroll anybody without proper verification about his in-service status.
You are saying that that doesn't mean that his credentials have been verified.
No, it was not.
It only means that he has been registered.
And nobody will think that I am not, because this is a one-time scheme. I will place more documents. This is a one-time scheme to allow only those persons who are in service and who are not having that professional qualification.
So that they
they do
ensure
not lose
that-
their job.
Correct.
And why this?
That is why that object of that was different.
Absolutely.
That is to only ensure that these teachers
why-
have the requisite qualification.
Yes.
Only for that. And if somebody does not have it, then after that date, he or she shall be
Lose their job because he
correct.
will not be he will be not in alignment with the notification of the NCT.
It is only for that purpose.
Only for that purpose, very limited purpose, with the objective that to so that they can sustain their service.
Yes.
And
Whereas
and
now,
why and the
now,
logic also.
now the thing is that now you want this present recruitment process is for the assistant teacher's post, and you have certain criterias which you want that the applicants.
No, why actually initially Supreme Court after a lot of deliberations gave this. In fact, Guwahati High Court, Tripura High Court, and Bihar said that 18 months DLED cannot be equated with 2 years DLED. Why? The reason is very simple. That 6 months practical training should be a part of the DLED or BEd qualification, that course curriculum. As they are working, as a special consideration, the central government MHRD gave that relaxation. It has subsumed with the 18 months course because they are already going, because they are in service. Normally, a person who does BEd, he is not in his service. He is a
So
normal.
that is why he need that experience.
That 6 months is required to have it a full-fledged course and full-fledged qualification. That is why 24 months course is prescribed, not 18 months. And Supreme Court at the last diluted because initially we wanted to do it. Then we saw Patna and Bihar, Tripura said that cannot be equated. If the regulation says 2 years, we have to go by 2 years. And I argued for the other side also on behalf of the state when we allowed the 18 months to be at par with 2 years. Then there was cases. Then we said that no, Supreme Court, that time Supreme Court was not in session of this matter, the high courts. The different high court, 2 high courts supported that state government's decision in Assam that 18 months is at par with 2 years, it is permissible. So first 2 rounds in 2021 and 2022, those recruitment process, this situation was not there. Thereafter, this Uttarakhand and West Bengal cases went to Supreme Court, and the Supreme Court says that it is for if they want to go for other services, for press recruitment or for promotional, that will be considered. Therefore, we are now opening it up. And but while opening it up, the Supreme Court says that you verify whether they are genuinely in service candidate or not. What is the reason? If a non-in-service candidate procures this 18 months period, that means he has not gone through that 6 months training. There is a shortfall. He will be a half-baked cake. So that is the reason the Supreme Court very categorically and reiterated word verification after due verification that this gentleman or this writ petitioner or this candidate must be in service. By fraudulent means, they have bypassed certain situations. At that time, it was at the nick of the moment, this whole thing came. Otherwise, there was no point of giving relaxation. The parliament said that 2014 amendment, parliament said that by 31st March 2019 is the last date. Till that time, the relaxation is permissible. Beyond that, it is not permissible. So there was a rush. So now, then Lordship will kindly come to page 51.
Page 50.
There is the amendment of the RTE Act.
51.
Page 51. Right to Education Amendment 2017. May I read it? Paragraph section 2. In the right to children's of free and education, in section 23, subsection 2, after the proviso, the following provisos shall be inserted, provided that further that every teacher appointed or in position as on 31st March 2015, who does not possess minimum qualification as laid down in subsection 1, shall acquire such minimum qualification within a period of 4 years from the date of commencement of the right to education, free and free compulsory education 2017. So that 4 years started here. From 31st March 2015 4 years, that is why 31st March 2019.
31st March
2015, from that day, 4 more years.
19.
That means 31st
That is
March.
how this
Yes.
date has arrived.
Exactly, Lordship. Thereafter, a communication was issued on 21st August 2017. May I read it, Lordship? The first, it was issued from the MHRD to the chairman NCTE. Training,
That is page
page 53.
53. Yes.
21st August 2017. Subject: training of untrained in-service elementary teachers in government aided, unaided schools. Lordship will kindly come to next page, Roman 2, page 54.
Yes.
The DLN course will commence from 3rd October 2017 to 31st March 2019. The duration of the course will be for 18 months.
You are reading page 54.
54, Roman 2.
Roman 2. Yes.
The DLED course will be from 3rd October 2017 to 31st March 2019. The duration of the course will be for 18 months. As DLED program is of 2 years duration, NCT shall allow subsuming 6 months internship period within the duration of the proposed online course through the SWAYAM portal, as all the teachers are in service and are already teaching. This is the reason, Lordship. The next page, page 55, 4th September communication from the MHRD to the chairman NCTE. Here also it is said, Roman 2, may I read it? NCTE is already directed under section 29 that it shall provide relaxation relating to the mandatory 2 years teaching experience in government recognized primary elementary schools in order to allow all untrained teachers appointed till 10th August 2017, which is the date of Gazette notification of amendment in the RT Act 2009, to apply for DLED program conducted by NIOS.
Yes.
So from where this date emanated? 10th August. Then Lordship will kindly come to page 58. That is my learned friend has already placed it. The MHRD has
So,
entrusted
according to it, is page 55 from where this date has originated.
it has originated from the Gazette notification of amendment of RT Act 2009.
Okay. Yes.
That notification, may I just go to back one for a moment?
Yes, yes.
That page 51. This amendment was given retrospective effect.
Correct.
Lordship will kindly say the date of notification 9th August 2017.
Okay.
So that is why the 10th August it came.
Got
That
it.
is the whole chronological and in sequence.
Got it. Yes.
Then there is this here on 21st September 2017, page 58, the meetings.
58. Yes.
The MHRD government has entrusted a task of conducting DLED program through NIOS for approximately 10 lakhs untrained teachers recruited till 10th August 2017. Serial number 1. The NCT regulations 2010 developed as per the mandate of RT 2009 stipulated that all untrained teachers in service shall have to acquire teachers education qualification before 31st March 2015. The NCT regulations norms and so 2014 prescribe 2 years teaching experience as one of the eligibility qualification for admission to DLED ODL program. The MHRD has issued a memorandum under section 29 of the NCT Act 1993 directing NCT to grant relaxation in respect of 2 years teachers experience as an eligibility qualification, permit the untrained teachers recruited till 10th August 2017 to enroll for the program and complete the training within 18 months, subsuming 6 months internship. In compliance with the Government of India's direction under Section 29 of the NCT Act, it becomes incumbent upon the NCT to issue appropriate executive orders. Now coming to Roman 3. The NIOS may enroll all the untrained teachers. So the enrollment is allowed, who were in service as on 10th August 2017. The state government and schools were required not to recruit untrained teachers after the notification of 2010, and as a special provision was made to clear the backlog of untrained teachers for which the ODL mode was permitted. However, the states continued with the practice of recruiting untrained teachers. The MHRD and NCT should impress upon the states not to recruit untrained teachers after 10th August 2017, and NCT shall not accord approval in future for the training through ODL mode. This is a one-time exercise. Then page 60, 21st August 2000.
Also summarized in, I think, in the decision of the
Yes,
apex
Lordship.
court, no?
So everything is there in the decision. So I'm just giving that.
Anyway, it is getting clarified now. So
Yes, Lordship.
you carry on. A lot of things have become cleared. Yes.
Now, 22nd September 2017, page 63. This is from the NCT. This is the main regulatory authority, Lordship. The recognition order.
Yes.
The second paragraph. And whereas the NCT has received directions under section 23 of the NCT Act 1993 from the Ministry of HRD, later dated 21/8/2017 and 4/9/2017, the project proposal for recognition of diploma in elementary education program through ODL mode has been submitted by National Institute of Open Schooling. The proposal is for conducting online DLED program through the Swayam portal of the Ministry of HRD for in-service untrained teachers at elementary level working in government aided and unaided schools in the country. So who are giving this opportunity? Next page, Lordship will kindly see Roman 6, second one.
Yes.
Allow NIS to operate study centers manned by staff, academic and others as per the instruction of MHRD to enable NIOS to complete the training of in-service teachers numbering around 11 lakhs by 31st March 2019.
Yes.
That is how this 31, all these things are coming into place. Now, Lordship will kindly come to page 69. I have already said the central government recognized that.
Page?
Page 69. Here the central government, as you are aware, 12,91,880 in-service elementary have registered and made payment for the NIS portal as on 30th September 2017. So that figure also pan-India, and there is an agreement also, page 71. I'm obliged to the other side that they have incorporated this also in their compilation. MOU between NIOS and the state government. That means the department is the state government. Their collaboration, etc., is for Article 2. Article 4 is responsibility of the NIOS. I am coming to Article 5, responsibilities of the state government. The director, Department of Science, will identify the nodal person from department to coordinate the work. The department will select the study centers and also coordinators, resource persons, supervisors, mentors for conducting the face-to-face personal contact programs and practical activities for the enrolled untrained teachers, providing assistance in monitoring the training facilities, etc. There is no scope for the state to verify the credentials of the persons who want to pursue this course. So what my learned friend is saying is not there in the scope of work.
Sorry, but can you rephrase this again? The last.
The submission from the other side was that the coordinator have to verify, after verification have enrolled them. This was their submission, sum and substance. What my, under the agreement between NIOS,
yes,
as well as the state government, this scope of work for the state government is very plain and simple. Number one, the director of elementary education will identify the nodal persons from the department to coordinate the work. Coordinate the work with who? NIOS.
Yes. Then to
The
select
department study centers.
and also
Then monitoring the course progress.
And monitoring. Yes. Then conduct the examination.
So there is no such thing that we have to verify and give it. lot of things happen with trust and faith. Nobody contemplated that non-in-service candidate will enroll for this 18, because if a person is not enrolled in service, he have the option of having 2 years course. So there was some fraud element at some point of time, and which is now coming to light. Once this notification, which is impugned in the writ petition, has come into place, because now they cannot run away. Whatever they have hidden from the coordinator, or they have not acted bona fide, there is every possibility that it will be now come into the light. I'm not using very harsh word. Then another notification 6/9/2019. So these are basically from the compilation. Now, if we go, what is this page 50 for the immune notification? Let me place it, Lordship, once.
Yes,
Page 54, this is the impugn notification of 17 June 2025.
yes.
We have issued the certificate, we have issued the advertisement on 26/12/2023. At that time, and one of the submissions from their side was very clear that whatever was there in the advertisement, it should be strictly followed. If that is correct, and if Lordship accepts that, then that advertisement clearly says 24 months or 2 years
Where?
course.
Where? In the advertisement?
Advertisement.
160 something, no?
Just one second. Yes, Lordship, I give.
Yes, 574.
574. Yes.
Am I correct?
Yes. Yes, the serial number 15. My friend was harping upon this clause, page 574.
Yes.
He was saying that while highlighting the essential qualification and experience, he was saying that where is these 9 documents or 6 documents here? This was their submission. My submission is that those 9 documents were not there. But if we have to abide by this,
Then 24 months.
24 months, they are all out.
That is here.
After that, the Supreme Court does this, no?
Correct.
After that, the Supreme Court give this relaxation.
The 24 months is mentioned where here?
2 years, first page.
Where,
2
where?
years diploma in elementary
Yes.
education, whatever name known.
2-year diploma in
No, if we have to strictly go by the advertisement, they have no case at all.
That is a relaxation
That is a
that has been
relaxation.
given
And
where
that is why in the relaxation.
now the Supreme Court has clarified that yes, but if so entitled.
If
Now
then
you are
after
verified.
verification,
Correct. So that
we have to
that-
verify.
How will you otherwise determine
Exactly.
that these people
Yes.
were in service or not? You are taking
Yes.
that exercise in
And
order to
Supreme
verify
Court did
that.
not pass that word verification out of the blue. Supreme
See,
Court also sent something.
There is also a argument from the other side that verification is to be read with the preceding paragraph, and that verification means verification of these eligibility, the other criteria, not this in-service training. This is what the argument is. If Mr. Karla correct, your verification argument was to that effect.
The verification of eligibility needs to be
Correct.
done.
All right.
Yes, if that argument will fall flat next moment now. If they are arguing that, Lordship will kindly come to the previous paragraph,
Yes.
page 624,
620.
Roman 5.
Yes.
We clarify that such.
But this is for the West Bengal, right? This is the West Bengal one, isn't it? No, I'm just asking.
Yes.
This is the West Bengal.
This is the main case from where the subsequent
No,
review.
that review was
Yes.
from here.
I'll go to the review also.
Okay, this is the case from which that review order had come. No.
Out of 10 states.
So, Mr. Saika, first the review. then the
No,
Uttarakhand and then the West Bengal.
correct. First
L-
review, then Uttarakhand, then West Bengal. Correct.
And it review all states for party, including Assam, including West
Now,
Bengal.
just for a second, Mr. Saikya, let's turn to the review order because that itself was also very clear,
yes,
if I recollect.
no, here also, because review.
Let's go by review, then
Yes.
Uttarakhand, then West
Yes,
Bengal.
Lordship, just 1 second, review.
No
order is-
problem.
Review personnel, yeah.
Mr.
Yes.
Color, review, which on
Yes, page
page?
568.
5-6.
Here,
5-6.
paragraph 2. Paragraph 2. We have already clarified that in the judgment under review, that one-time scheme was provided solely to safeguard the interest of those teachers who were employed as on 10/8/2017. We therefore not inclined to entertain the present review petition as well as miscellaneous application. However, to avoid confusion, we again clarified that 18 months DLED diploma obtained by such persons who are in employment as on 10
Who were in
who were in employment as on 10/8/2017 and who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions.
According to me, even this para 3 is very clear.
Very
Because there are two conditions. One is that 18 months diploma obtained by such persons
Yes.
who were in employment as on 10/8/2017.
So two parameters are
And
given.
who have completed a diploma course of 18 months.
Yes.
So two things, he has to be also there.
Absolutely.
Now, how will you know whether this person was in service as on 18/8/2017?
Yes, that is a Supreme Court. Not only suppose the first condition is not there,
Correct.
then what my learned friend was arguing is correct.
Hmm.
But Supreme Court says that who were in employment,
That part is to be verified.
that has to be verified.
Even if that word verification doesn't
Yes.
appear at 568,
Yes.
it has to be read into it.
And-
Otherwise, how will you know?
Absolutely, Lord.
Now, Mr. Saikya, just for my benefit, can you point out in which page this judgment 28/11/23, the main judgment against which this the review
was filed.
is that enclosed here?
Yes, Lordship will give me 2 minutes. I'll find it out.
I will just put it that page number also.
Yes, 22 was judgment. And if we have to read this judgment, it is clarification along with page 623.
Yes, of course. That is West Bengal.
West Bengal.
Before West Bengal, Uttarakhand also
Yes.
comes. Uttarakhand is
Here we clarify. Here also a clarification.
yes, in page 593.
No, if 623.
No, before that, page 593 is Uttarakhand. We therefore direct the state government to consider the claim of the applicants in accordance with the clarification, and if the applicants are found to be eligible, to appoint them in accordance with law.
Yes.
So that is also a saying. So there has to be some
Some fact finding exercise.
correct. And then which page? Page
Page 623.
620.
If we read this jointly,
Yes.
then one more condition is also there.
Yes. Yes.
We clarified that such of the teachers who were in employment as of 10th August 2019, and this is another condition, who completed the 18 months DLED ODL program through NIS before 1/4/2019.
Oh, this is again.
This is again the third condition.
We have to
Shall be
complete it
considered as
before.
valid diploma for the purpose of applying either institution or for promise. Now, let us see one of their certificates. Lordship will kindly see 1st April 2019. Now, let us go to their certificate. All these certificates were issued after 1st April 2019. Page 60. Lordship will kindly see page 60. Last line, date 22nd May 2019.
60.
Page 60.
Date 22/5/19.
All certificates are post 1st April 2000. If Lordship goes to page 67, this was issued on 18/9/2019. If Lordship goes to page 86,
Yes, so this is after. Is
this
after.
is in 2023, I think. 21st March 2023,
Which one?
page 86.
Page 86.
86. This is of 2023.
So this also they don't qualify. 86.
So I am not on those hard facts. So my whole case is based on their repetition.
Twenty-one, 723. Yes.
So for a specific purpose, that relaxation was given with a specific requirement that they have to go through that 18 months course and they have to complete it by 31st March 2019. So with that intention, the NCT under section 29 of the RT Act give that relaxation. That power is with the MHRD.
Yes.
So that is a statutory power. Now let us look, because I can go on and on with this case, but the case is in a very small narrow campus. So let us see what this impugn notification, Lordship.
54, no.
Page 54. In view of the judgment of the Honorable Supreme Court passed on 10/12/2024 in review petition so-and-so in civil so, in the case of Vishwanath and others versus State of Uttarakhand, the applicants who have successfully submitted their online applications with 18 months DLA from NIS against the advertisement dated 26/12/2023 are hereby asked to attend the second phase of physical documents verification in due course of time when notified with the following documents in original and one photocopy set of all documents for the proof of in-service teachers as on 10/8/2017. List of documents, appointment letter and accepted joining report, minutes of the school management committee, then photocopy of the attendance, certificate issued of the school authority specifying the service of the applicants in the school as on 10/8/2017, salary statements, UDI's record. Now, their argument today was that they are all from private institutions. From their pleadings, it is totally different. They are from all verticals of the school system. Now, if it is a private school, they said that they cannot have managing committee.
1 second. Yes.
We have an act called Assam Non-Government Educational Institutions Regulation and Management Act 2006. This act says, preamble, the declared aim of this act is to exercise certain controls of the government over many non-government educational institutions which have grown up like mushroom in every nook and corner of the state. Without caring for real interest in the education, the object of the act is to very ideal and its early implementation with eagerness will serve as a great public purpose. Statement and object of the reasons. The unplanned and the mushroom growth of non-government educational institutions of primary, secondary and higher secondary level in the urban and semi-urban areas in the state have necessitated to make law to regulate the establishment and management of the non-government educational institutions, that is educational institutions established and run by individuals, associations of individual society, trust or at primary, secondary and HS level without receiving any grant in aid or financial assistance from the government. It is observed that there is an increasing trend for commercialization of education and many educational institutions have been established with the sole motive of earning profit with scant regard to the standard norms of land, building, classroom, furniture, library and laboratory facilities, fire safety measures, playground, etc. The teaching and non-teaching staffs are paid meager salary and their services are terminated or dismissed on falsy grounds without giving reasonable opportunity to defend themselves. The state government at times have remained a silent spectator in spite of large-scale resentment expressed by the public. Here, section 2, regarding various authorities under the Act. 3, power of the state government to regulate non-government educational institutions. Then serious section 4 says prior permission for establishment of non-government educational institutions and registration. So there is a process to get permission and registration of the private schools. Don Bosco school, every school. I'll give this book. That section 4 says prior permission for establishment.
Give it to them.
Yes.
At 72 please.
Prior permission for establishment of non-government educational institutions and regulations, detailed process is there.
Just flag mark and mark that provision.
Yes.
Yes, you read.
Yes. Then administrative recognition, section 5. Section 6, registration and administrative recognition of existing non-government educational institutions.
So it's all are there.
All are there. Then school management committee, my learned friend was saying, then procedure for opening higher schools, sections 8, academic permission and recognition by the board and council for governed by own regulations. So they have to take permission from the boards. Then section 10, as requirement for establishment and administrative recognition of non-government educational institutions. For establishment, they have to do certain act. Scheme of management is section 14. Power and function of the managing committee is section 13. Constitution of managing committee is section 12. Facilities to be
Managing
provided.
committee section 12.
12. Constitution of the managing committee. So these are all in place. The state government is it's not that doing arbitrary action, or they are so oblivious of the existing educational system in Assam. So while we formulated this, the 6, every document is very important and easily available if you are a genuine. That is why 400 and some, they have submitted all 6 documents. If it was so arbitrary, not a single person could have submitted those all documents. And a submission is made before this honorable court that I do not have an appointment order. This is something I'll not say laughable, but totally I'm finding shortage of my word. What can be sung? A person working for an institution, shaping the future of the next generation of our society, is saying that I am working there without an appointment order. Is it a voluntary service for Lotakil Bureau? For a volunteer also, there is a badge.
Even for any person joining a school on internship to teach also will have an appointment order.
Even for our lawyers, if personal student comes for internship, at the end, at least certificate is taken.
Certificate of
And STAM also request for giving that appointment order also. That from such and such that I am allowed to go an internship.
Because I so happened that after finishing class 10, when I was waiting for my results, I had tried to go to different schools to see if I can be taken as a teacher for a temporary time. Most of the school rejected me, but one school, Indarlaya school, I think it is in Chanmari. In that school, there was a vacancy and I was taken. There was an appointment order. Anyway.
So school, it is not. Maybe they are doing some tuition, private tuition, maybe they have done.
That is different.
That is different.
That is different. But
Yes.
a teacher without an appointment
Yes,
order,
Lordship. And
it doesn't inspire the confidence of the court.
Absolutely.
The fact that there is no pay slip, these documents are not there, and then to say no, it is the state who should have all these verification done, so therefore the state should not ask for this. That is not inspiring the confidence of the court.
You give on bluffing.
Something is
Now they are trying to do it with the court. They tried it with the government. Nobody buzzed.
And the other thing that has transpired is that these are not private schools.
Yes.
There are also government schools. Now there is no representation also by a particular teacher, one of the candidates, that this is the difficulty. he or she has faced. That this is the certificate he doesn't have, because of which he cannot apply. There is no such case singled out.
They could have come that this I have lost this particular document.
Nothing
in
is there.
class.
There's no, there's
Something like, which we have
specific.
accepted. We are not that.
In fact, one of
blind.
the documents shows that they have that, what is that? US
UDICE code. So the certificate which they have annexed, that certificate itself shows that the particular school is registered under the, captured under the UDICE. If they do not have the UDICE, they can give DICE. And what about these registrations, which I am just placing? Inspection or supervision. So the director or any officer authorized by, they will have to do regular inspection of these schools, these private schools. So private schools are something not that they can easily function in the society. Ruining
This is 2007.
This is 2006.
6.
Withdrawal of recognition order, closure, audit.
So that period which this people
This is
the
2006
petitioners-
and we are on 2017.
So those petitioners were, if they were really working, then these things have to be there.
Absolutely, Lordship. This is what I am trying to. It is not that it is not such a casual.
All right, all right.
So I do not see there is any arbitrariness, unreasonableness in each of these documents, which are easily available if you are a genuine and bona fide person. If you are not, then you can say
Just
that.
clarify once again that UDI's records. I'm still having a little bit of doubt there, because it says UDIC records as a proof
UDIC
that the
record-
applicant was in service.
Lordship,
Now,
I clarify here in this judgment, Lordship, UDS number is sufficient for us.
Yes,
Just
code
like a pen
number.
number.
Correct.
If I
That
get
is
the
not
pen number-
difficult. He will know the pen number.
Yeah.
But to say UDI's records,
Okay, Lordship, modify it. More
records would mean something more.
something more. Yes, Lordship, this language is not correct, but UDS code is required. UDS instead of record, UDS code. That 11-digit number. If this school
And which is the document which shows that all these schools must have this UDS code? It is compulsory, because there is an argument from the other side that it is not compulsory.
Fine, Lordship. Suppose they do not give us UDICE. This document, this central government notification of 2012.
Where was that? That DICE.
DICE.
DICE, correct?
UDICE.
Huh?
Initially it was DICE.
DICE and
Then now it is UDICE.
STEMIS and then
Yes.
UDICE. This is compulsory.
This is every year it is done, Lordship. 30th September is the last date.
And this is 12.
This is 2012.
So
And
this has to be there.
these-
This has to be
those schools which are functioning and the details of
All
every
right.
teacher is also captured here.
all right.
This is how the whole country's education system is running. There, every 1 or 2 years, there is a PAB meeting. In PAB meeting, all these data are analyzed and they change and formulate the educational policy of the country.
Mr. Kalar, you had also given one document on this UDSC. That was in that note of yours, or it was given separately?
Enrollment that had to be done.
Where is that? Oh, I've got it. Yeah, I can't read it. This one, right?
It was the enrollment to the course.
Okay, okay.
So, suppose a particular school is not.
What a whole clip document.
Now, the certificate which they have annexed in the petition, that school is having UDICE. So, I do not know about the other. I am not commenting on it. Maybe all are having UDICE. His father is, maybe he is a little bit smart. That's why he has put that word, put that number. So, my humble submission is that we are not asking
So
something
this
which is not available.
This UDICE that is reflected in clause F is the same U-dice.
Yes, same.
Same, right?
In common parlance, it is now UDICE in our educational.
What is the
And there
full
is,
form?
Sir Lordship,
What is the full form of this?
UDICE. I'll give you. Other day I wrote it, but anyway, just 1 second.
No
Lordship.
problem. Can give it later. Yes, you have it.
Unified District Information System for Education.
What is it called?
Unified District Information System for Education.
Unified
District.
District
Information system
system.
for education.
So it is a comprehensive database and management information system for schools education in India. It's a central system.
This can be recorded in your submission
Yes,
that
Lord.
the UDI's records that has been
I can give a
referred.
short note on this.
No, that records can be molded to UDI's code. That will be
Yes,
sufficient.
Yes. No issues. Only the UDI's code. That number is enough. Because if we click that number,
You
the
will
whole
get the
school's
information.
data will come into
You will get the
on the
information.
screen. Who are the teachers? Who is the headmaster? Number of students? Whether the pupil teachers ratio is as per the norms? All
Give
these
a
things.
small note on this.
Yes, Lordship, I'll give that, Lordship.
Yes.
So now, according to them, asking these testimonial or documents is arbitrary, unreasonableness, and without any authority. And he's asking that we must have a statutory backing. So for that, I'll place 4 or 5 judgments. And first is my lordship, the Constitution, Article 160. This is the simple executive power.
Judgment copy is this? No, judgment or copy would this नहीं.
My judgment, list of books we have given. I'm cutting short, lordship. Actually,
It's okay. It's all right. As
it's
it is, I don't think there will be any time for any other matter, so it's all right to take your time.
So Article 162, extent of executive power of
This is the first one is which one? No, oh, you're referring to the Constitution. The Constitution, yeah.
the judgment will be on the basis of this.
Right. I was given the case law.
Lordship.
That's why I thought Constitution of India. Yet nine.
Anyway, lordship, few lines I can read it out.
1 second. How come they will not have this book?
It happens in my chamber also. But in our LLB course, we did not give much importance to this constitution. I mean, a lot of other acts were given a lot of importance.
Yes. Article.
Extent of executive power of state, subject to the provisions of this
Article?
constitution. Article 162.
162. Yes.
Subject to the provisions of this constitution, the executive power of a state shall extend to the matters with respect to which the legislature of the state has power to make laws. Provided that in any matter with respect to which the legislature of a state and the parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this constitution or by any law made by parliament upon the union or authorities thereof. So the executive has some power. They can exercise the power. If there is no law on that power,
Yes.
then in that situation, in that vacuum, the executive can act. The same power, they can always make laws also. But if the law is not prepared at that point of time, so in many situations, lordship, all the situations that requires in any administrative action, there may be vacuum, there may be gray area. To fill up those areas, Article 162 is always there. It cannot prevail upon the existing laws. We cannot bypass any law or statutory provision by exercising 162.
But this anyway, this circular is only in terms of the apex court judgment.
That is number one. That one power is there. The other power, suppose the Supreme Court did not give that verification authority, then this power was there. Still, we can do it because we want to ensure that a genuine person who has undergone 6 months.
And by doing that, you're not changing any rules of the game. That 24 months requirement was already there in the recruitment. This was only a relaxation. So if you want to avail the relaxation,
In terms of the Supreme Court,
correct. So that is why if you want to avail the relaxation, in that case, you must satisfy that you have this in-service thing. And now for that, you have to give this document. Otherwise, you give the 24. Correct.
Abs-
Otherwise, you give that 24 months.
They have put the
Diploma.
options open.
If now you want to avail the relaxation.
Yes.
If
Now,
you want
they
to
want
the relaxation,
you fulfill.
you must
These are the
provide the
preconditions.
documents.
Preconditions you have to fulfill. Out of 5,000 plus recruitment, 400 will get from this channel. The rest will be from the 2 years.
Yes.
And if we strictly go by this, that their certificates should be issued prior to 1/4/2019. That we are not till now, my instruction is that not strictly followed by our department also. In that case, the figures which I am placing, that may come be a little bit lower also. But I am not entering into that debate or that dilemma. So 1982, 1 SCC page 39, paragraph 20.
1982,
volume 1 SCC page 39. Visambar Dayal Chandra Mohan versus State of Uttar Pradesh, paragraph 20.
paragraph.
Paragraph 20.
This is on.
This is on the executive power of the state. If
Yes.
Lordship is pleased to last 5 lines of
Yes.
paragraph 20. So long as the state government does not go against the provisions of the constitution or any law,
Yes.
the width and amplitude of its executive power cannot be circumscribed. If there is no enactment covering a particular aspect, certainly the government can carry on the administration by issuing administrative directions or instructions until the legislature makes a law in that behalf. Otherwise, the administration would come to a standstill. Then 1994, education auto did the election. 1974 4 SCC, page 788, paragraph 10.
Paragraph?
Paragraph 10.
Yes.
May I read it, Lordship?
Yes.
The contention relates to 28 textbooks printed and published by
Paragraph 10, no?
Paragraph 10, Lordship.
1 second.
801 page number.
Yes.
This contention relates to 28 textbooks printed and published by the Textbook Corporation. The state government prescribed these 28 textbooks for use in the primary and middle school classes at time when the Act of 1973 had not been enacted, and the question is whether the state government was entitled to do so. There was
Of course.
of whether the state government was entitled to do so. This was, of course, then no statutory provisions like Section 4, subsection 1 of the Act of 1973, which empowered the state government to prescribe any textbook, and the prescription of these 28 textbooks had therefore had no legal force. But that does not mean that the state government was not entitled to prescribe these 28 textbooks in exercise of its executive power under Article 162 of the Constitution. The executive power of the state government under Article 162 extends to all matters with respect to which the state legislature have power to make laws. And since education is a subject which falls within entry 11 of list 2 of the 7th schedule of the Constitution, the state government could apparently, in exercise of its executive power, prescribe these 28 books, provided that it is doing so, it did not trench on the rights of any person. It is now well settled by the decision of the court in Rai Bahadur so-and-so versus State of Punjab that the state government can act in this executive power in relation to any matter with which the state legislature has power to make laws, and even if there is no legislation to support such executive action, but such executive action must not infringe the right of any person. If the executive action taken by the state government encroaches on any private right, it would have to be supported by legislative authority. For under the rule of law, which prevails that in our country, every executive action which operates to the prejudice of any person must have the authority of law to support it. White paragraph so-and-so of Bennett Coleman versus Union of India. The executive action of the state in entering into the business of printing, publishing, and selling textbook in Rai Bahadur so-and-so, though not supported by legislative was upheld because it did not operate to the prejudice of the persons. So what I am trying to emphasize is that by asking this document like appointment order or minutes of the school management or any of these conditions, we are not affecting their private right. What we are trying to ensure that they were in service candidate as on 10th August 2007. It is as simple and clear. So that will not affect or adversely affect any of their rights. If they have actually done it, they can have no reasons to avoid these 6 documents.
Very well.
3 more judgments I'm not placing. I'll just give the citations. 1971, State of Andhra Pradesh versus Lalu,
Yes. Paragraph.
paragraph 7 and paragraph 15.
This is on.
Basically on education authorities, right? 162.
Yes.
Yes, and paragraph 2021 10 SCC page 519. Indian School Jodhpur versus State of Rajasthan.
Yes. Paragraph.
Paragraph 113.
Yes. This is also.
On basically government can make a mechanism in education. The earlier one was how to find out a person having more experience. So these are all within the domain of education and government administration. So part of administrative law.
Yes.
Like another certificate page 466.
Yes.
Lordship will see the letterhead of that school. Korak because Vidya
160.
460 repetition.
Mr. Sharma, you're waiting for that partnered matter. Mr. Fukan, I don't think there'll be time for your matter today.
May come up next.
Take a date from the court master. Yes.
So 466 there also after the school name, the UDICE code name is there printed on the letterhead.
Page.
Page 466.
Page 466.
So as they are trying to focus on UDICE, that's why I'm pointing out this. So the
Page
school
466?
proudly flashed this name, number 466.
Yes.
Korak begun Vikas Vidyagan. Next line is UDICE code number, 11-digit number.
Yes. On top.
On top. So the genuine school will have no issues.
Yes.
Then I think I have covered everything. The Supreme Court's in its detail, which I have placed, Lordship, from the compilation, page 599. I'm just giving Lordship references of a writ petition.
599.
What is the objective? What is the rationale which was considered by the Honorable Supreme Court? 599 paragraph 4.3, 4.4,
Yes.
4.5. I'm not reading it, Lordship. May kindly go through it. If that clarification is anything is required, then Lordship will also page 603, paragraph 6.
603.
Yes, Lord.
This is the Uttarakhand one.
Yeah, but for the factual parts,
Oh,
Lordship.
okay.
How the
603.
Supreme Court dealt with all the facts.
415.
Paragraph 6 of page 603.
Okay.
Then 7 also. Yes. Then paragraph 12, 606.
I was thinking there's a long weekend coming. It
Step-
appears that my weekend has gone.
Lordship is creating Lordship's own homework now.
Yes.
Yesterday, my Lord Justice Arundeep Chaudhary got good homework from us. But that homework did not fructify because the matter was to be heard today, and I was all along here. So he had to rise before 2 o'clock
Oh.
because he kept the whole afternoon and part of the morning up free for those eviction matters. But I was engaged here, so he is safe from his homework for the weekend.
He will be happy.
He will be happy. Maybe he's blessing me.
Yes.
So,
Para 7.
para 7, then paragraph 14, paragraph 15.
Paragraph 10, I think Mr. Kala had
Yes.
relied. Yes.
Paragraph
14.
15, why this 6 months was reduced from 2 years to 18 months. That narration is there.
Yes.
And finally, at paragraph 16 says 609, it appears that the appellant availed the opportunity of complete their 18 months program. So they availed it. Why it was given and why they have adopted it.
It appears that appellants availed.
Avail.
Yes.
So a
Here,
person.
that is also not there. That is why I asked
Yes.
but that appears whether they have availed or not, we don't know. That statement I don't think is there.
So paragraph 28
Hmm.
and paragraph 27, it is a one-time window.
Paragraph
27, they have, the Honorable Supreme Court itself has highlighted, one-time window was given. Paragraph 28, it says, it is clear that only such of the teachers who were in service as on 10th August
paragraph
2007.
28.
28. 27, regarding the one-time opportunity was given to a single window.
Yes.
Lordship may kindly mark this. 27 and 28, may I read it, Lordship?
Yes.
It is clear that only such of the teachers who were in service as on 10th August 2017, but who had not acquired the minimum qualification till then, could have availed the one-time scheme as sanctioned by the NCTA recognition order dated 22nd September 2019. I have placed that order. Having availed the one-time scheme, such of the teachers, even though they only undertook the 18 months DLA through NIS, they should have considered at par with 2 years DLA if they have completed their 18 months program through NIS prior to 1/4/2019. Any other candidate who were not in service as on 10th August 2000 cannot be considered to be at par with 2 years DLA course.
Yes.
So the distinction very clearly carved out. And on the basis of which the final order at page 623, which I have already placed, that 1st April is the cutoff date. Before that, they have to acquire. And next page 624, the verification. So in that view of the matter, my submission is very limited. My affidavit, Lordship, just important paragraphs I'd like to place. So paragraph 4 of my affidavit.
Paragraph
4. Their case, then we have what we have highlighted in paragraph 7. May I read this paragraph, Lordship? Paragraph 7.
Yes.
Takes 642 page number.
Yes, I have it.
The answering deponent humbly begs to state that as per the NCT norms, the minimum qualification for appointment of teachers for class 1 to class 8 is a 2 years diploma in elementary education. However, such 2 years diploma in elementary education was relaxed by the NCT by order dated 22/9/2017 in respect of in-service untrained teachers at elementary level working in government aided and unaided private schools appointed as on before 10/8/2017 by reducing the period from 2 years to 18 months, and such course to be conducted by NIOS through ODL mode through the SIAM portal of the MHRD. There is no dispute that for fresh appointment of teachers for primary and upper primary level, NCT notification dated 23/8/2010 and 29/7/2011 need to be strictly adhered to. The entire scheme of relaxation of allowing 18 months DLED was for the purpose of providing a window to the in-service teachers in as much as unless they would have acquired requisite qualification prior to 1/4/2019, they would not have continued to remain in service and would have faced dismissal from service. As such, the Honorable Supreme Court has clarified that such teachers who were in employment as on 10/8/2017 and who completed the 18 months DLA program through NIS before 1/4/2019 shall be considered as valid diploma holders for the purpose of applying in other institutions and for promotional avenues. The Honorable Supreme Court has further granted liberty to the employer to verify the in-service status of such candidates. My learned friend raised the objection regarding this line that we do not have the authority. The authority is Article 162, supported by the Supreme Court judgments, as well as the observations and directions given by the Supreme Court in page 623. That verification must be done, as well as in the review order. Paragraph 8. The answering deponent humbly begs to state that there must be necessarily be a reasonable and transparent mechanism to ascertain whether the candidates were in service as on 10/8/2017 at the time they enrolled for and completed the 18 months DLA course. Employer has the discretion to find out whether the candidate has fulfilled the relaxation granted by the NCT and they have fulfilled the observations made by the Honorable Supreme Court in the case of Jaivir Singh versus State of Uttarakhand and the subsequent review order passed by the Honorable Supreme Court in the case of Vishwanath versus State of Uttarakhand. The petitioner's reluctance to furnish service particulars create doubt regarding their eligibility and runs contrary to the spirit of verification exercise. It is inexplicable as to why the petitioners are reluctant to furnish their service particulars, which are essential for ascertaining whether they were in-service candidate as on 10/8/2017 and had completed the 18 months DLA course so as to legitimately claim the benefit of the relaxation granted to by the NCT. Then we have stated that these are not extraneous, excessive, or disproportionate, page 645. Yes, page 645, I am reading the second paragraph. It is stated that the above noted documents asked for are not extraneous, excessive, or disproportionate as claimed by the petitioner. The Honorable Supreme Court as well as the court categorically held that 18 months DLA obtained through NIS by the candidates who were in service as on 10/8/2017 will only be treated as valid. However, the Honorable Court nowhere in the judgment held that all the petitioners candidates who obtained 18 months DLA through NIS were in service. In view of the same, it is pertinent upon the authority to at least verify the documents the petitioner candidates who claim to have 18 months DLA obtained through NIS and to ascertain whether they were in service or not as on 10/8/2017. Moreover, the documents asked for in the notice dated 17/6/2025 are very basic only and rudimentary for a person to submit who is in service. Next paragraph. The respondent humbly submits that the petitioner's plea, if accepted, would nullify the employer's statutory and judicially recognized discretion to verify the service status of candidates, thereby defeating the very object of NCT's conditional relaxation. The documents sought are standard employment records ordinarily maintained by any genuine in-service candidate teacher, and failure to produce them raises serious doubt about the authenticity of the petitioner's claim. The verification exercise is an essential administrative process aimed at ensuring fairness and preventing fraudulent claims, particularly in view of reported instances across the country where NIS DLA certificates were misused by persons not in service as on the cutoff date. The steps taken by the respondent to verify in-service status are neither arbitrary, illegal, nor discriminatory.
This is the fraud you were saying.
Yes. There are a lot of instances all across the country. It's a very simple thing, Lordship, that I am asking these 6 documents, which are very basic, very primary. Appointment order. If the school he is working, so he will have to go and sign the register every morning, like we all do. If it is not registered, then we have that biometric. That record we are asking that on that particular period, whether you are there or not. What else? Your pay slip or some records of you are getting stipends or salary or whatever. Nobody's claim is that they are honorary teachers. If
And now
honorary,
these are all regulated under this. Even if
honorary
it's a
teachers are not regulated under anyone. Our Honorable High Court at one point of time
I'm
allowed,
talking about these private school.
yes, for private school, all these are mandatory. Don Bosco is a private school.
This
Don Bosco has a
2006 Act,
recognition
no?
from SEBA as well as now CBSE. Or any school,
No,
any
this
school.
act which you had relied is this, no? Non-government education institution regulation and
Yes,
management.
that is their claim, argued case today, that they belong to the private schools.
Hmm.
But
Which
they
is not correct.
Which is not correct, paragraph 2 of the writ petition. So in both situations, they are governed by some regulation. If it is a government school, they are covered by a separate statute. If they are unaided and private institutions, by 2006 Act.
Right.
You must have administrative approval, you must have permission, you must have recognition. You must have a school management committee. You must have a particular school infrastructure. All these are there. I'm not talking about the elite schools. The basic schools in which is growing or which are in existence in every nook and corner of the state. Every school must have that. Otherwise, from where their students will go and appear for the CBSE or SEBA or any other examination.
Followed.
So they are simplifying, they are making it very casual, which in my humble submission.
It's a little bit vague, that part of the.
Yes, it is vague also, Lordship. And we cannot allow the students to have teachers like them whose whole basic foundation is based on fraud. I'm using that word now. I'm compelled to use that word when on behalf of those petitioners, a submission is made before this court that I do not have an appointment order. If that is the case, I'm so sorry. He was not a teacher at all. He may be having some tuitions in his nearby area or at home, but he was not teacher. These 6 are very fundamental things. It is not like we are asking for Aadhaar card, PAN card or something like that. Or driving license also, no?
These are the basic things
These are
which a
basic
school
things.
has to have to
If you want to
legally
agree
run.
that 18
To
months,
legally run in the state of Assam. This is what you are saying, isn't it, Mr.?
Absolutely.
And that is why.
And nobody can escape these documents. By default, they will get it. By default. You don't have to do anything additional exercise for that. So in that view of the matter, Lordship may be pleased to consider our submissions and their submissions also. And in my humble submission, no case is there on merit and it deserves dismissal, not only dismissal, with heavy penalty, heavy cost. Why? In 3 pages, in the same writ petition, they have taken 3 different stands. 4th, the submissions made before this honorable court. So they are not only trying to mislead the department, they are trying to mislead this honorable court also. And that cannot be very lightly taken.
That Justice Kripal's judgment, I think.
Yes, Lord.
If
here,
any fraud
there
played,
are
then
instances.
repetition can be dismissed and liable to be thrown at the threshold.
What? And because of them, our whole process got delayed by 3 months.
This
In fact,
matter
there are
was pending
instances when
because of the interim order.
yes. It is not that because Lordship allowed day before yesterday overnight we have done. We have not burnt any midnight oil. It was everything was ready. And why it is midnight? They are trying to give some negative color. Why midnight? Because at 12 o'clock the system starts for the day. 00 hours.
Anyway, I'm not on all that.
My thing is that when that kind of submissions are made, we have to give our response. So this is my humble submission. So the writ petition deserves dismissal with heavy penalty. Deeply obliged for my
Yes, Mr.
patient
President.
hearing loss. Not if I'm taking leave, my
Yes,
colleague
Mr.
will be here.
Yes. You are taking leave, but now everything is the court. Yes, yes.
lot of future of
Mr.
the
Saikia,
education.
I think I'm going to close it now, but in case there is any clarification, I'll get it refixed.
No deal.
With that understanding, I'm closing it today.
Highly
Yes, yes, Mr. Kala.
Lords would be closing it by what time?
And you have Mr. Saikia,
Lordship.
that note, you will not
Oh.
finish your reply before the
You guys note, I'll give lordship.
4:45 the right.
4:45 or 4:30?
It's already 4:39 and we have
Would you finish in the next
I
minute
need,
or
uh,
otherwise
at
Monday?
least 30 minutes.
Mr. Then I will have it fixed on Monday and you have your notes also ready. A matter of but you can start a bit.
Very well.
I'll prepare the note and note will be given on Monday, lordship. Highly obliged.
It's
Uh,
first.
One second, Mr. Kala. If consent dates are there, then you give it to the court master for the matters. Both parties, if are there, it should be given. We did. Yes.
The Lord had mentioned.
See, can you first clarify those three as regards the contrary stand, referring to those 3 pages? Just clarify that because you see, Mr. Kalra, you had given a clear impression that these are all working in private schools, but your paragraph 2 indicates they are not private schools, they are also government schools.
Please come, my Lord, to paragraph 2 for a minute again. That is the first thing I wanted to clarify.
Yes.
Para 2, my Lord would find. At page
I have it, page 23.
23.
Yes.
The petitioners beg to state that we are working as teachers in private, government aided and unaided schools in the state of Assam. We have not stated that we work in government schools. There's a
Government
difference.
aided.
Government aided and government schools are different, my Lord.
But anyway, they are
The reason is
government
this.
aided.
The reason is this: for government aided, my Lord, there is no recruitment notification that comes out. And most importantly, under the RTE Act, I'm not treated as a government employee. I'm sorry. This confusion that was tried to be created, my Lord, that I work in a government school, the question that I put to myself is, why would I reapply? Why do I want to come down from my seniority? If I'm already working in a government school,
So you are saying some of the petitioners are working in government aided schools?
Indeed, my Lord, and I put their experience certificate, I will show that. A government aided is a private school. It's not a government school.
Mr. Karlan, lower your voice. Yes. Then?
So therefore, my Lord,
Hmm.
I stand by what has been stated in the writ petition. These 3 categories of school and the 4th is a government school. Nowhere in my petition do I state
All right,
I'm working in a
noted.
government school. The example of a government aided school. Please see page 147 for a minute of the writ petition.
Venture.
Page 147.
147.
47. Adarsha Ikra Academy, Buragaon.
Yes.
I've been instructed that this is a government aided school, but it is not a government school, it's a private school. This school, my Lord, is a
See,
government.
the difficulty is that none of these averments clarify anything. It is clubbed. Everything seems to have been clubbed together. Now, which are the petitioners who are working in a government aided school? Which are the petitioners who are working in a private school? Which is the petitioner facing what problem? Because one of the documents, 1 or 2 documents shows that these are the schools which are already having that UD. What is that?
UDI score.
UDI score. Some certificate shows it is not there. You see, because this is not like a PIL kind of a thing, right? It is, you are coming with specific grievances. It is a specific grievance, right? Now, in that situation, this writ petition should have had those averments. That is not there. But anyway, let's not, even if we don't get into all that also, but the sum and substance appears that yes, there has the whole requirement of the 18, this that date, that cutoff date, and that 18 months is because you are availing of some relaxation, right? That is a relaxation, in other words,
Not really.
that 18 months.
It's not really a relaxation. That is also
Because if you don't want that, then you will have to have the 24 months. Either of them.
indeed.
So that is in a way relaxation, because you otherwise you will have to have that diploma,
Indeed.
which is reflected in the recruitment. Now, because you want to avail this, because you are working, you are in service, and you want to avail that. That is why this has been given to you, which Supreme Court has also clarified that yes, if you are working, then you should be given that benefit. Right? Now, in order to check that so that it is not misused, the government has done it. This is the very short question. You see, we don't need to refer to all the history of these everything.
So I'll
Because
explain
that is the only thing now. Now, one thing this court finds that yes, the UDI's records. I agree with you. It is not fair to say that the candidate will get the UDI's records, because that record is not something you can give. What you can give is the UDI's code. But suppose that school doesn't have it, then it is for you to point out that yes, I applied, but the school has not given. This is also not your case. Where is that instance? You are only hypothetically you're giving examples that no, they will not have it. They will not have appointment orders. They will not have these UDI's codes. They're all rural schools. These are all your submissions. I am only saying, please understand, because I have to author a judgment, right? But there is no specific instances. These are broad examples you are giving. When it appears that some schools also have the UDI's code. Now, what is wrong in that? If the government wants that, they don't want it to be misused. That is why they want to be extra careful. They are saying that, all right, now in terms of the Supreme Court's judgment, if you are in service, you satisfy whether you're in service or not, and you give us these documents. If you have these documents, good enough. Now, suppose you are having a difficulty, you could have approached also to the government. That also you have not done. Even in this petition, you have not stated anything. Why should this court, in exercise of 226, enter into this realm also? Because this is an administrative area. We don't find that government is being unreasonable, unfair. Government has 162, all right. Even if we don't go into all that, unnecessarily, we need not even go that way. That is always there. The Supreme Court decision is there. You have not challenged that clarification part. Now, how they want to do that, that is the government's prerogative. Other states may have devised some other mechanism. But just because state A has devised a particular mechanism, would it mean that state B will have to adopt the same mechanism? I understand it all comes from the same NC and whatever that is. See, I am only sharing this because you have to come prepared with these answers, because this is what is now in the mind of the court. You see, because otherwise the rest of the things, I don't think we need so much to go into all that, you see. Because I was with you to an extent that yes, suppose these are so onerous that you can't just give it. Of course, then, because then this would be unreasonable. Touchstone of Wednesbury principles.
The onerousness
Correct.
applies in terms of time.
No, you
Please-
see,
please
you see
appreciate
this.
the fact.
No, you see, the specific instances are not before this court. Because if you see, there are these acts also. Now, under these acts which have come in 2006, have you gone through this act?
I've gone through it.
So now there are a lot of provisions here. These schools have to provide. Now, if suppose these managing committees are not constituted, maybe these schools are not in existence, we don't know. Government wants to check. Why should this court says, okay, no, the government cannot do this check? Just because an experience certificate, because this court knows how these experience certificates are obtained. This court is aware of all that.
Very well.
These things are not unknown to the court.
Please see it from the other way.
You see, it has all this history, you
No,
see.
I understand, Balak,
So,
but
so
please-
just having an experience certificate given by some principal in 21 that oh, this person was working in 2017, was working till now. when submissions are also being made before this court, no, these schools have stopped working. COVID, post-COVID, they're not working. But then the certificate shows that no, some of the schools are still there. Some of the teachers are, the certificate says still then they are working. You see, lot of contrary things are coming. I am not saying that these are intentional, but it is appearing because of lack of clarity. Something is stated in general, submissions are being made in another way. You see, because of so many, there are 171 petitioners.
Indeed.
Could be their situation may be different. There could be one person who may not be able to give any of these documents. There could be one gentleman who can give that, and then you don't even give that list because it seems some of them has already been appearing in that provisional
None of the
list.
petitioners.
None of the petitioners.
None of the petitioners have given all these documents. The
No, but
petition-
you said the name appears in the
their name
provisional
appears
list.
because they went for the document verification. Whatever document they had, they gave it.
So their name appears.
Their name appears, and today the result says withheld. And my lord, with all due respect, my lord, I understand where it's coming from, state, etc., my lord, fairness. But for a moment, my lord, it is important to see from our side also, my lord. I understand whatever decision my lord will take will follow. Absolutely.
I am only you
My lord,
you reply.
Unfortunately, what has happened is, my lord, that at the end of the day, my expectation as a candidate, my lord, as I said, I'm not running away from anything. I'm not
All right,
running
Monday.
very well.
It was heard in part Monday, huh?
My lord, can I just pass over? That is.
Huh? Kundita Dinta case.
19, 20 to 25.
List like next week or any date to be fixed by the registration.
So till then, that interim protection.
Nothing.
My lord, at least, kindly hear me for a minute, my lord. Kindly hear me for a minute.
Mr. Chase, since this matter is fixed on Monday, I trust that nothing shall happen till then. Huh?
Let them give a statement to that effect then, because my writ petition cannot be rendered infructuous.
You don't declare the final results.
At least
Mr.
that
Chester?
statement may be recorded, my lord.
Ensure that. চিনি ভালকে একেলগে থব এইটো সেই আগৰ সেটটো নেকি এইটোতো অলৰেডি হৈ গৈছে মানে The eligible one has been returned back to you?
It is okay, my lord, we have an extra copy. Not to...
No, it will get only confused. I don't want to unnecessarily it will.
My lord may take it from me that every query I will